lahat. Thank you very much, Mr. Galanggam, for the introduction. Okay, Mr. Galanggam is one of my best students. Okay, you are doing well. Okay, being in this room at 8 o'clock in the morning. Okay, maski na bumabagyo. Okay. Umulan man, umaraw, okay, you should be preparing for the bar exam. During my time, we thought wala nang bar exam because months before, there were earthquakes and one of them seriously damaged Baguio, di ba? Nalala niyo yung time na yun. Akala namin wala na, pero wala, tuloy ang exam, okay? So it doesn't really matter kung may mga calamities, okay? Now, I was asked to discuss with you special contracts, okay? Today and I think Thursday and Friday, okay? And of course, the premise of these lectures is that the lectures on oblicon, tapos na, yeah? Yeah, because basically the general principles in oblicon as a rule are applicable to these contracts. Even if the problem, for example, pertains to a lease, the answer may actually be under the law in obligations and contracts. So do not consider for a moment that because a problem involves a contract of lease, the relevant principle will only be found under one of those provisions sa law on lease. Okay? For all you know, the problem may pertain to joint and solidary obligations or any other concept sa oblicon. Okay? So that's the premise. Now, before I proceed, I will just have a few minutes of your time to put this lecture really in its proper perspective, okay? I'm sure some lecturers have already done this somehow, but I want to emphasize a few points, okay? For example, this lecture should be considered in relation to the 2011-2012 exams, specifically in relation to the Supreme Court resolution. Okay, this resolution which dramatically changed the type of exam. Okay, because for a century it is said that the exam would always be essay type of exam. Okay, but with this resolution there were three major changes. Okay. And one of them pertains to the redefinition of the coverage. Okay? In other words, before the 2011 exam, the Supreme Court would just provide us, including during my time, with a list or enumeration of the laws that will be covered by the exam. Okay? So parang ganito lang, civil code, family code, etc. Probably with the exclusions. Okay? Kaya lang in 2011, the Supreme Court provided us with a 35-page outline in civil law. Okay? As far as civil law is concerned, 35 pages. Okay? The 2012 exam was practically with the same outline. Meron lang ilang modifications basically on typographical errors. Okay? But basically the same outline. The first here is just to show to you that just because torts and damages had so many pages allotted doesn't mean that most of the questions would fall under torts and damages. Okay? Still, 2011 persons until 2012 is the most favorite. Okay? Although 2011 ang sumunod ay succession, last year ang sumunod ay oblicon. Okay? Again, you should not consider the number of pages. Pero 2013, in a way, should I say, is worse. Okay? Because now the Supreme Court would only provide for an outline with 8 pages, basically. Okay? In other words, the details have already been removed from the outline, probably because they realized that their promise before that questions would only be based on the outline did not actually happen, okay? Especially last year, for example, 2012, if you examine the outline on contracts, there was nothing mentioned about the fundamental characteristics of contracts. But mind you, almost all fundamental characteristics appeared precisely because they are fundamental characteristics. Okay? So there were about, 8 questions on the fundamental characteristics. Kaya siguro, they already deleted the details. Pero you can just imagine succession, 1/8 page lang. In other words, nakalagay sa succession outline dito sa Supreme Court ay practically 4 lines? And therefore, nakalagay lang testamentary succession, interstate succession. In other words, study the entire law on succession. Ganun lang ang message na sinasabi ng Supreme Court. Mas malala dito sa special contracts, okay? Because in most special contracts, one-liner lang. Halimbawa, pledge. Anong nakalagay? Under pledge, wala pledge. Di ba? In other words, basahin nyo lahat about pledge. Di ba? Ganun lang. Okay? This outline to my mind is not really useful, but walang masama if you will read the outline. Di ba? Total 8 pages lang naman yan. You will have an idea more or less what civil law is all about. Okay? Now, but as to the second approved change for 2011, even until last year, yung MCQs 60%. Okay? Now, for MCQs, I have always maintained, okay, that because there would be like 100 questions. I'm not sure if this year 100 pa rin. Hopefully, baka 50 na lang daw, okay? 100 questions, then I predicted in a way that there would be questions which have never been asked before sa bar exam. In other words, kung ano ang favorite for the past century, I would still maintain that those favorites would still be the subject matter of the questions, but there will be more, okay? And true enough, 2011, 2012, there were questions on topics which have never been asked before sa bar exam, okay? Now, into this, take note that 2013 is 20%, unlike 2011 and 12 na 60%, but I don't want you to think or to have this idea that this is only 20%. The MCQs is 20%, not only 20%. In other words, take this part of the exam so seriously because you know the difference between 74 and 75. There had been many examinees, like during the time of Justice Sandoval, okay? Sandoval Gutierrez, that 33 examinees got a grade of 74.99999. Justice Sandoval, as the chairperson of the committee, requested the Supreme Court, the entire Supreme Court, to consider this as a passing grade. But most justices said no. So they did not become lawyers. That's 74.999. And this one is 20%. Kaya seryosohin nyo, okay? Kaya lang, do not take the instructions so literally, okay? Because last year, I've read in the instructions that the examinee should not proceed to the essay type of exam without first completing the MCQs. Parang at 8 o'clock in the morning or before 8, the questionnaires were already be with you. Ibibigay na lahat, okay? So actually, you can even start with the essay, okay? But nakalagay doon sa instructions sa MCQs, do not proceed to the essay type without completing your answers. Aba, kung napakahaba naman ng MCQ questions, and therefore you would take like 3.5 hours, 30 minutes na lang matitira sa essay, hindi naman tama yon. Especially now that the essay is already 80% of your grade. In other words, you should budget your time, okay? Kung ang MCQs sa tingin mo dapat maximum of 1 hour or even less kasi 20%, then so be it. Stick to that. Okay? Kung 100 ang questions, nasa 25 ka pa lang, 1 oras na, maybe the next best thing to do is sagutan mo lahat, puro letter C. Baka sakaling sumamba ang mga sagot. Diba? Kaysa naman ubusin mo ang time mo sa MCQs, natira 1 hour for essay, but essay is 80% now of your grade. Okay? So do not take those instructions so literally. In relation to the competencies, okay? Knowledge and recall, understanding, analysis, okay? Last year's exam was really an unusual exam, not only because so few passed, but because even in the exams itself, iba talaga. Sa civil law, most of the questions nasa knowledge and recall. I would say mga 80% knowledge and recall. In other words, basics lang. I would tell you therefore sa civil law, always start with the caudal, okay? Hindi kayo magkakamalian. Tingin ko nga, you should end with the caudal, okay? If you still have time, nasa venue na kayo, nasa UST na kayo alas 5 ng umaga, and you are waiting until 8, why not? Maliban sa magdasal o matulog, okay? Kaya lang dapat may alarm clock ka, okay? Baka mamaya alas 12 na tulog ka pa, okay? Ginigising ka na, ayaw mo magising. But maybe you should use your time reading the caudals lang, caudal professions lang, di ba? Now, but actually, I would want you to focus on the professions which are really the favorite sa bar exam, di ba? Focus on that, okay? Hindi lang arbitrary na hala, basa lang ng basa, wala lang, okay? Now, there were only a few questions last year sa understanding and analysis and solution. Kaya lang hindi ganyan palagi ang panahon, okay? Malay natin, ang chismis ngayon ay mukhang ang mga MCQs will be problem-based, okay? Hindi ito like yung civil law or yung political law questions na one-liner lang, options ka agad. So, may pagka-labor ang dating, okay, remedial last year, so problem-based, okay? In other words, always be prepared regardless of the type of exam, okay? A few days after the release of the bar results nung 2012 exam, so nung April ba yun or early May, okay? My former student who took that exam and passed the exam approached me, okay, here in San Sebastian, okay, to tell me na, Sir, when I was taking the exam, hindi ko alam kung magagalit ako sa iyo or matutuwa ako sa iyo, okay? Medyo alarmed na ako kung anong ibig sabihin nun. Apparently, while taking the exam, ako ang naaalala niya, ako si Uribe. But, ang explanation niya, because the exams daw, yung questions were so easy. Samantalang pag ako daw nagbigay ng questions, napakahirap. Even my quizzes daw were so difficult, more difficult than the bar exams. Hindi ako makapag-react, okay? Hindi ko alam kung should I say, you should be happy for that, okay? Inulit pa niya yun doon sa testimonial, okay? But that was good for her kasi alam na din niya ang fundamentals, di ba? Hindi rin dapat na nandun na kayo sa mga jurisprudence, wala pa kayong alam sa fundamentals, di ba? So focus first on the fundamentals and go into the cases, okay? Mind you, last year was also unique, not only because fundamentals, basic, knowledge and recall ang MCQs, pero pagdating naman sa essay, doon sa civil law lang, again, civil law lang ito, okay? Mind you, all the questions sa civil law were based on actual cases. Hindi guni-guni lang na examiner. And I fully agree with this examiner. Actually, ang explanation ko dyan kung bakit sa MCQs, number 1 ang oblicon, 40%. Sa essay, number 2 ang special contracts. A few percentage higher lang ang persons. Okay? Why? Kasi practitioner ang examiner, partner sa PECABAR. Kaya araw-araw yan, kontrata ang kaharap niya. Okay? Everyday yan. Kaya oblicon at saka special contracts ang tanong. Now, doon sa essay, based on actual cases, I fully agree to this. This is the most fair na exam. Kasi may tamang sagot na eh. May decision na ng Supreme Court kaysa naman yung examiner, guni-guni lang niya. So, we wouldn't know what is really the correct answer sometimes. Even the experts couldn't agree on the correct answer. Okay? Kaya, mabuti na itong based on cases. Yun nga lang, the other unusual thing, parang for the first time, at least in my knowledge, in 30 years, the examiner did not even bother to change the names of the parties in the case pagdating sa bar exam. In other words, kung sa kaso, ang party na isa ay si Roberto Reyes, in other words, si Amay Bisaya. Pagdating sa bar exam, ang pangalan niya ay Roberto. Okay? Kung ang party doon ay Manila Hotel, Manila Hotel din. Parang ganon. Okay? In other words, if the examinee read the case, he can easily answer that question. But I have only one, in a way, parang reminder lang sa mga examinees in relation to that type of questions. When the examiner would base his question sa isang case, he may actually have a twist, okay, in the case. Be careful because konting change lang, like yung date, baguhin niya, that may already result in another ruling, di ba? Another decision, okay? Hindi na yung decision ng Supreme Court. In fact, even in that case, yung Reyes case, the examiner did not mention what I think was one of the most important facts as proven in this case, as to whether or not he may hold the hotel liable, would go into whether he was embarrassed by the statement of the hotel wedding coordinator, hotel coordinator, because allegedly the coordinator shouted at him. Okay? So narinig daw ng ibang mga guests, so he was so embarrassed. But what was not mentioned in the bar exam question was the fact that when he was cross-examined, how close she was, the coordinator, to her, he testified that the coordinator was so close to her as if her lips were already touching his cheeks. Napaka-lapit na masyado. If that is the case, sabi nga ng Supreme Court, how could she have shouted when she was so close to the person? Diba, we don't shout pag nasa tabi na tayo ng tao. Sa Tagalog, bumubulong na lang tayo dahil malapit na tayo eh. Kaya ang Supreme Court, medyo knowing that, wala, dinismiss ang kaso. Di ba? But without that, baka tama siya. Yung answer, therefore, could have been, it depends. It depends on whether the allegation of Reyes can be proven. Okay? Otherwise, kung may proof, baka manalo siya, despite the ruling of the case in the actual case. Okay? So, always consider those matters. Okay? In the third approved change in 2011, ito yung trial memo, legal opinion, 40%. But last year, it's already essay type of exam. And lalo na this year, na 80% na ang essay type, I would only remind you of two things, really. One is your handwriting, okay? Even if you know all the laws in the world, if the examiner cannot read what you wrote, even if perfect pa ang sinulat nyo, sorry na lang kayo. Di ba? Whether sobrang pangit ng handwriting nyo katulad ko, okay? Or napakaliit ng letters mo, ang tingin ko isang major solution lang dyan. You write in big letters, okay? Pag purposive ang sulat mo, malalaki, mababasa yun. Maski pangit, basta mabasa, okay na yun. Di ba? You should ask someone to read yung handwriting nyo, yung mga works nyo. Okay? Kasi pag hindi mabasa ng mga kaibigan mo, may problema ka. Okay? But you have time to improve on your handwriting. Yung English, yung pangalawa, very important ang English. Dito, kasama dito yung communicating English, may weight noon, pero ngayon maski walang weight, still that is so important because your answers are only as good as how the examiner would understand your answers. Even if you thought your answer was this, but as written, it had another meaning, ay wala. Okay? We only read, ako as when I check papers, I only read what you wrote. Okay? Kung anong ibig sabihin mo. Although sometimes I would think, siguro ibig niyang sabihin ganyan. Okay? Siguro lang. Hindi tayo nakakasiguro din. Okay? So why should I give you full points? So again, parang write what you mean what you write. Parang ganon. Okay? Kung ano ang gusto niyong sabihin. At yung mga typographical errors should be avoided kasi irritant yun eh. May mga taong irritable na, lalo na pag medyo may edad na yung nagbabasa. And we all know as a matter of fact, most of the examiners would be much older than me. Kaya dapat consider nyo yun, okay? As clean as possible, without any typographical errors. Yung pagiging malinis, madali yun, basta you think first, okay? Pag-isipan nyo muna ang sagot before you write, okay? Somehow, dapat final na ang decision mo and then write your answer. And generally, kung ano ang una nyong naisip, yun ang tama, okay? Assuming may alam kayo on the topic, okay? Pero, do not change as a matter of rule. Do not change your answers. Instinct yan at tama yan normally. Unless 100% ka sure, mayroon palang kaso, ganyan, naalala mo na, binago na pala ng Supreme Court, pwede siguro yun. Otherwise, do not change your answers, okay? So, we will start with the law on sales, okay? So, special contracts, I have to tell you that of the special contracts, even including torts and damages, sales is a runaway favorite, okay? Napakalayo ng sales. And this had consistently every year, okay? And last year, lalo na, okay? Last year, out of the 23% sa special contracts, 15% nasa sales. So you can imagine, halos 0-0 ang iba, okay? Well, 5% ang partnership and 3% sa loan. In other words, walang tanong sa ibang field. So, if you have to focus on one special contract, that should be sales. And thus, I will also devote most of your time discussing the law on sales. Okay? I will devote around 9 hours for sales, and then 1 or 2 hours on lease, 3 to 4 hours, or about 3 hours for agency and partnership, 3 hours for credit transactions. Okay? I will not be discussing with you torts and damages. That's another topic, okay? So, medyo okay ang time. We have 16 hours, okay? And then, one last, okay? Sa MCQs, okay? San Sebastian, you are so fortunate that San Sebastian would have a very serious mock bar. May pagkaalatotohanang mock bar, okay? And last year, I was the one who prepared yung questions of more than 900 who took the mock bar exam, merong nilalabas na top 20, di ba? Top 20, kaya lang may mga tay-tay, so umabot sila na sa civil, okay? Umabot sila ng mga 34. Out of the 34, 33 pumasa, at least nasa list ng pumasa. I'm not sure if yung naisa ay baka hindi kumuha ng exam, baka nagkasakit or what. In other words, malay mo, nasa top 20 ka uli sa MACBAR ngayon, ay sigurado papasa ka. Okay? But more than that, yung top 20 doon sa civil law exam ko, 3 of them landed in the top 10 sa actual bar exam. Okay? Yung number 17 sa exam ko was number 3 in the bar exam. Yung number 2 sa aking exam, number 5 sa bar exam. Yung number 13 sa aking exam was number 6 in the bar exam. So malay mo, di ba? Seryosohin mo lang yung yung MACBAR. Pag nag-top ka dyan, there's a good probability that you will also top the bar exam. Although, last year, if you have noticed, medyo mabababa ang mga grades ng mga kumuha sa MACBAR. Mas mataas pang nakuha nila sa bar exam eh. And even my UP students would tell me, sir, ang hirap-hirap ng MACBAR mo okay? Mas madali pa ang bar exam nga kaysa sa MACBAR. Pero hindi ganun palagi ang buhay, okay? Kung tama ang chismis, ang civil law, ang exams ngayon for this year, even sa MCQs will be problem-based. Medyo hindi yan knowledge and recall. Basically, analysis yan, okay? So, I hope you will not also stop, but you should start with the fundamentals. But go as far as decisions of the Supreme Court and analysis of the principles, of course. Okay? Now, so into the law on sales. Okay? As far as the questions under this law is concerned, okay? If you would notice, almost 50% would fall under this. Obligation to transfer ownership, obligation to deliver, that definitely would be included. Okay, this is very much related to transfer of ownership. And risk of loss and double sales are concepts very much intertwined with transfer of ownership. Okay, so whether or not there was already transfer of ownership, or the transfer of ownership pertains to the first or the second buyer, would already be about 50% of the question. So I will also focus on this topics. But if there is one single topic na favorite sa bar exam, although last year medyo hindi. In 2011, there were about 6 questions on redemption. Okay? There are only a few provisions sa redemption and very concise, very short provisions. You should read all those provisions. Okay? Napaka-konti lang nun, napaka-brief, short, very easy to understand. Okay? So, that is already more than 20% of the questions. So, tuloy tayo. Okay? Every time I discuss, okay, a topic, I always start with the nature, okay? If you know the nature of the concept, you will know a lot about the concepts, or it will be easy for you to understand the rules, the principles in relation to the concept, di ba? Parang ano lang ito, if you know that this is a bird, then you know that it flies, di ba? That it has wings, okay? Kasi alam mo na bird, okay? So, ganun din sa batas. Know first the nature of the concept. Okay? Later on, you may know the characteristics, you may know the essential requisites to be able to fully grasp the nature of the concept. Okay? Saan ka magsisimula? Where do you start? In understanding a concept, by all means, start with the definition. Okay? I have not asked any of my students to memorize the Civil Code of the Philippines, nor the Family Code of the Philippines, but I demand that they memorize the definitions man lang. Okay? I think you can do that. Kayang-kaya nyo yun. Okay? Just the definitions. And from the definitions, you will know a lot about the concept, especially, generally, the definitions are good. Pinaghirapan ito ng mga members ng commission. Okay? Example, just to tell you about that claim. As defined by a contract of sale, alam niyo na kaagad, sale is a contract. Okay? And as a contract, it is one of the sources of obligations. Most of our time will be devoted to these obligations. Okay? Now, one of the contracting parties obligates himself to transfer. From that, it should be clear already that this is not a real contract. This is a consensual contract. By the mere meeting of the minds, by the mere fact that one promised to deliver and transfer ownership, there can already be a perfected sale. Okay? Unlike, for example, when a contract is a real contract, the law would say, would define like deposit is constituted when one delivers. Okay? It is only upon delivery that that contract is perfected. So again, from the definition, if there would be such contract if one of the parties obligates, mukhang consensual ito. Okay? Now, but ano ang obligation? Example, in a problem where one of the parties obliges himself to deliver a determinate thing to another, and the other party obliges himself to pay a sum of money upon the delivery of such thing, did they enter into a contract of sale? Not necessarily, okay? Because in order for the contract to be a sale, the purpose of the parties in the delivery must be transfer of ownership. In other words, if the purpose of the parties in the delivery of the thing is not for ownership to pass, maybe only for safekeeping, or maybe only as a security, then it is not a sale, di ba? So again, the law is very clear that one of the obligations here is to transfer ownership. Also, to deliver a determinate thing. What if the subject matter of the contract is not a thing? May it still be a valid contract of sale? We will discuss that as we discuss the subject matter of this contract. But also, if what was bought was a thing, but it is not a determinate thing, may it still be a valid sale? That the answer to that question nasa 1460. Okay? Kung 1458 ito, nasa 1460, we will go into that as we go into the object of the contract. Okay? And finally, if there is an agreement or one of the parties to a transaction bound himself to deliver and transfer ownership, but the other party was not obliged to pay a sum of money, is that a sale? Of course not. Okay? That could be a donation, because it is very clear from the definition that the other party would oblige himself to pay a price, certain money. Take note, the law says price is in money. Did the law say Philippine currency? Hindi rin. Okay? So as we discuss this topic, yung price, okay, we will go into that. Okay? Whether there can be a valid sale where the price, for example, is in Japanese yen or in Italian lira, may that be a valid sale. So, into the characteristics. Okay? I'm sure the lecturer sa Oblicon already discussed with you the characteristics of contracts. There are many kinds of contracts. Contracts are classified in so many ways, di ba? Kung mga 10 lang, we can discuss, okay, such classifications. But as far as a contract of sale is concerned, okay, a contract of sale is a principal contract, a bilateral contract, an onerous, in fact, essentially onerous contract, a commutative contract, a nominate contract, definitely, and what else? Consensual contract, of course. Okay, but okay, I will not be satisfied that you know that this is a principal contract, that this is a bilateral contract. Meaning, what does it mean when a contract is consensual? Okay, you should go into those, okay, deeper than just knowing it is consensual. In other words, it is consensual because it is perfected by mere consent. No other act is required for this contract to be perfected. In other words, mere meeting of the minds as to the thing and the price already results in a perfected sale. Why is it essentially onerous? Because the buyer, the other party to whom the thing is delivered and ownership is transferred, is required to pay a price, okay, in money or its equivalent. Okay, kaya hindi ito, this can never be a gratuitous contract. It is essentially onerous. Ganun din sa bilateral. Well, it is really wrong for an author to claim that a contract is bilateral because there are two parties. As if ang unilateral contract, there is only one party. Okay? But can there be a contract where there is only one party? Siyempre wala. Okay? Kasi walang nagpa-party na mag-isa siya. Okay? Kaya it can never happen. Thus, unilateral, bilateral does not go into the fact that there are two parties or two or more. Rather, it goes into the fact that both parties would be obliged. Okay? So, but this one is a classic bilateral contract. Okay? A contract of sale. The seller and the buyer would have an obligation or obligations under this contract, etc. But, okay, I would also not be satisfied that you stop at that. Okay? O sige, alam mo na bilateral, therefore, in this contract, reciprocal obligations would arise. I would want you to go further, okay? And apparently only one author would really do this, okay? What is the relevance of being essentially onerous? So what if this contract is bilateral? In other words, what are the principles which may or may not apply because this contract is a bilateral contract or this contract is an onerous contract? I will just have to remind you because this must have been discussed already in Oblicon. For example, if in the problem, the contract involved is a sale, okay? And there is a need to determine whether it should be the principle of the least transmission of rights which should be applied or should it be the greatest reciprocity of interest. Ano ang sagot? Ang dapat i-apply nyo ay the greatest reciprocity of interest if the problem pertains to a contract of sale because a sale is essentially onerous. Yung least transmission of rights principle will only be applicable in gratuitous contracts. Okay? Another one, okay? If you remember the rule in resistible contracts, okay, as to when a presumption may arise, okay? If a contract of sale, for example, was entered into by the debtor after a judgment was rendered against him, will there be a presumption that this sale is in fraud of a creditor? The answer is yes, because the law is very clear that if the debtor enters into an onerous contract after a judgment was rendered against him, the presumption that the sale or that contract, onerous in character, is in fraud of such creditor or creditors will arise. Kaya pag ganun ang problem, sale, pero naman onerous ang sale, mukhang that would be presumed to be in fraud of a creditor. Kaya lang nakalagay doon, alienation, onerous in character, and a sale would involve an alienation. I have to remind you of this because in one case, 2011 case, what the debtor did was to mortgage his property. Would that be covered by the presumption? Would there be a presumption arising? Wala. Because mortgage is not considered as an alienation in relation to resistible contracts as to when a presumption may arise. Okay? Pero naman, kung ang transaction entered into by the debtor ay donation, okay? Would there be a presumption na this was entered into in front of the creditor just because there was a donation after a judgment? Hindi, okay? Rather, there will only be such presumption if the debtor did not reserve sufficient properties, okay, to cover his debts. Okay? So magkaiba ang gratuitous at saka onerous, okay? Last, okay, in relation to bilateral, okay? What is the relevance of this characteristic of this contract of sale, being a bilateral contract? Naku, napakadami. Okay? For example, in 1191, if you remember, in reciprocal obligations, okay, uh, rescission is implied, okay? In other words, in contracts of sale, if one of the parties had already complied, but the other had not, okay? The other party, no. If one of the parties, for example, had not complied with obligation, the other party, more often than not, would rescind, okay? Thus, rescission is implied. Why would I perform my obligation? You did not perform your obligation. But in unilateral contracts, if the debtor did not perform, do you think the creditor would rescind? Of course not. Ang i-rescind kasi dito ay ang kanyang sariling obligasyon. Okay? He will not rescind because he doesn't have an obligation to the other party. What he will do, it would either be specific performance or he would demand for damages because the other party did not perform the obligation in a unilateral contract. Okay? But a sale is a bilateral contract. Another one, if you remember 1169, last paragraph, okay, in reciprocal obligations again, and the sale again would result in reciprocal obligations. The moment one of the parties had already complied and the other had not, the other party will already be considered in delay, even if there was no demand made. This is one of the exceptions to demand for delay to set in. It is because a sale would result in reciprocal obligations. Kaya, pag ang seller nag-deliver na, and the buyer had not yet delivered, okay, had not yet paid, from the moment there is delivery, even if there is no demand, the buyer would already be considered in delay under 1169. But I will have to warn you that the Supreme Court already ruled on this matter that despite the phraseology of the law, it is subject to the stipulations of the parties. Kung nga naman, hindi pa 1 month na from delivery, the buyer had not yet paid. Therefore, he's already in delay? Not necessarily. Maybe they agreed that the buyer will pay after 3 months from delivery. So subject yan to stipulation, and I will discuss a relevant provision on this under the law on sales. Okay? Now, siguro one last, okay, in relation to the fact that this contract is a bilateral contract, okay? If you remember in conditional obligations under 1187, the effect of the happening of the condition, which is suspensive in character, retroacts to the date of the constitution of the obligation, di ba? So if it retroacts and the thing to be delivered by the other party is fruit-bearing, may mga fruits, okay? Siguro kung house and lot, may nagre-rent, okay? Therefore, with the retroactive effect of the happening of such condition, who is entitled to the rentals? If this is a sale, mukhang buyer, kasi may retroactive effect eh. But if you will read further the provision, okay? Kaya I would always say, always read the provisions in their entirety. Hindi pwedeng tingi-tingi sa batas, okay? Dahil nabasa mo ng first 2 sentences, okay na yung iba, wala na yan, okay? Hanggang sa pinakakatapusan na period, basahin nyo, okay? One of the last sentences dito is, as to the fruits involving those 2 obligations, they are deemed mutually compensated, okay? In other words, if in relation to reciprocal obligations, in other words, kung sale ang pinasok nila, because again, this would result in reciprocal obligations, yung fruits as to the obligation of the seller to deliver the thing, ito yung rentals, kung nirerentahan. Yung to the buyer, ang fruits dyan ay interest on the price. These 2 fruits are deemed mutually compensated. Kaya sinong entitled sa rentals? The seller. But would the buyer be required to pay the interest? Hindi. Okay? Because they are deemed mutually compensated. A sale is a bilateral contract resulting in reciprocal obligations. Pero take note, just to complete the rule on the matter, had this transaction be a gratuitous contract, okay? Or at the least, okay? Kasi may implications yun. At the least, unilateral obligations is involved. Like in donation, okay? Pag donation, only one is obliged, the donor. Okay? If the condition happened, okay, and therefore the donor will now be obliged to deliver in my fruits, is he also required to give the fruits from the time of the constitution to the time of the happening of the condition to the donee? Or again, phrased differently, is the donee entitled to the fruits from the time of the constitution to the time of the happening of the condition? Kasi nga may retroactive effect. Sabi ng batas, the fruits shall pertain to the debtor, okay? Unless otherwise, the contrary intention is clear. In other words, ang debtor dito ay ang donor. Kaya the donor should be entitled to the fruits. Is this a good rule? This is really a good rule, okay? Kasi kung donation ito, the house and lot will already pertain to the creditor, to the donee. Kung pati ang mga rentals gusto pa niyang kunin, ang tawag ko sa kanya ay swapang, okay? Bigay niya nga sa kanyang house and lot, pati ba naman renta, kukunin pa niya. Unless it was so clear in the promise of the donor. Desperado siguro ang donor. Sabi niya sa kanyang apo, "Apo, pumasa ka lang sa bar exam na yan. Sa'yo na ang house and lot na ito. At lahat ng rentals mula sa araw na ito, sa'yo rin." That is so clear, okay? That the donee will be entitled to rentals from the time of the constitution of the obligation, okay? So again, okay, I hope you would be conscious of the fact that ito may characteristics, but what does it mean to be bilateral? What does it mean na onerous? But also be conscious of the principles, okay? Which may or may not apply because sale is bilateral, because sale is onerous, etc. Okay? For example, this one. Merly offered to sell her automobile to Violi for 60,000. After inspecting the automobile, Violi offered to buy it for 50,000. The offer was accepted by Merly. The next day, Merly offered to deliver the automobile. But Violi, being short of funds, secured postponement of the delivery, promising to pay the price upon arrival of the steamer, Helena. The steamer, however, never arrived because it was wrecked by a typhoon and sunk somewhere off the coast of Samar. Is there a perfected contract in this case? Why? In MCQs, actually, even in essay type of questions, okay? I would always encourage you to go directly to the questions, okay? Because kung alam mo ang tanong, you can focus on the relevant facts. You can disregard the irrelevant facts, etc. And ma-identify mo kaagad what is really the issue on the matter. Kasi malinaw sa iyo ang tanong. Okay? If you know the question, sabi nga, you have solved the problem already by 50%. Di ba? So focus on the question and then considering the facts this time. Correct answers in problems like this can only be based on two, facts and law. Magkamali ka sa isa, talo ka na. Okay? So do not only focus on the facts na walang law, or do not focus only on the law na mali ka sa facts. Tingin ko nga, mortal sin pag nagkamali ka sa facts. Kasi facts na yun, binigay na sa iyo yun, di ba? Ang law medyo understandable. Okay? But since ang tanong, is there a perfected contract? If there is such a question, perfection, ano dapat ang iniisip nyo? The first thing that should be in your mind, what contract was entered into? And reading the facts, malinaw. Even if the examiner did not say na sale ito or pledge ito, from the facts you can conclude, as here, that this is obviously a sale. And knowing what kind of contract was entered into, anong susunod? No, alalahanin mo what kind of contract as to perfection is a sale. Take note, as to perfection, even the Supreme Court outlined for 2 years, 11 and 12, isang classification lang ang nakalagay sa kanilang outline. as to perfection lang. There are no other classification of contracts. As to perfection, consensual, real, and formal. Okay? So, ang susunod na tanong, knowing na sale, what kind of contract is a contract of sale as to perfection? But I would tell you, as tinanong na ito sa bar exam, focus on the real contracts because there are only, nakalagay nga sa 1316, 3 lang ang real contracts eh. But there's a fourth, mutuum. Okay? So if you know that the contract is not one of these real contracts, you can really basically conclude na consensual because there are very few, 1 or 2 contracts which can really be claimed to be formal. And one of them is antichresis. Okay? Maybe a sale of a large cattle is a formal contract. Okay? Thus, dahil sale ito, and this is consensual, ano ang susunod? Ang susunod mong tingnan ay, had there been a meeting of the minds as to the thing and the price? Because that would result already in a perfected contract of sale. Thus, pupunta ka sa facts. Had there been a meeting of the minds? Definitely. The answer dito ay, yes, because the offer of Merle to sell her car for 60 was accepted. Mali. Okay? Because the offer of Merle was not accepted by Violi. In the problem, nag-counter offer si Violi. Okay? It was the counter offer which was accepted by Merle, di ba? After Violi offered to buy it for 50, so hindi niya tinanggap ang 60. In other words, this option is not a good answer because it is not consistent with the facts. Okay? Pangalawa, yes, because there was a meeting of the minds of thing, or no, because there was no delivery, or no, because there was no payment yet. Okay? No delivery, mali, because a sale is not a real contract, which requires delivery for its perfection. But no, because there was no payment is probably the worst. Okay? Because there is no contract in this country which is perfected by payment. Okay? Or by the performance. Kasi, ang performance presupposes that there had already been perfection. Okay? Can a party compel another to perform under a contract if there had been no perfected contract? Hindi. Okay? Kaya, this would be the worst option. The correct answer therefore is letter B, because there was a meeting of the minds as to the thing and the price. Okay? I drafted, just for your, para malinaw sa lahat, you will notice here the bar exam date, okay, kung kailan tinanong ito. Okay? Kaya if you would, if I would show to you an MCQ na walang date when the question was asked, guni-guni ko lang ito. Okay? Ako lang ang gumawa niyan, or I got it from another exam. Okay? Baka binase ko yan sa CPA board exam. Okay? Kung walang bar exam date. Okay? Now, I formulated another set of options. Okay? None, because the condition did not happen. Or yes, because the contract of sale is a consensual contract and there was already a meeting of the minds as to the thing. Or letter C, no, because the contract of sale is a real contract, there was no delivery. And letter D, none, because the contract of sale is a formal contract and the contract was not put into writing. Okay? This appears to be baka pwede. Okay? Because the condition did not happen. What condition is referred to? This is the arrival of the steamer, di ba? To pay upon the arrival of the steamer. That is a condition. Kaya lang, the error in this option is, it is not a condition for the perfection of the sale. It is a condition for the performance of the obligation. It has nothing to do with the perfection. The contract had already been perfected, pero ang performance is subject to a condition. Okay? Kaya dito, alam niyo na ang sagot. Ang sagot dito ay letter B, because ito ang pinakamahabang option. Okay? And I am not joking. Okay? If you don't know anything about the answer, wala kang ka-idea, okay? Clueless ka, okay? Ano kaya dito ang tamang sagot? Ang pinaka wise na sagot, yung pinakamahaba. More often than not, I would say it is correct. There is a scientific basis to that, because the examiner would always try to justify the correct option to the point na humahaba ang kanyang justification. Otherwise, it may not be an accurate option. Okay? Baka maguluhan ang mga examinees. Kaya in doing that, consciously or unconsciously, humahaba ang option. Kaya lang, pag si Uribe ang nag-draft, minsan sinasadya ko mas may mahaba na mali. Okay? Dahil alam ko naman yung ganito. Okay? So, do not all. Pero kung wala talaga kayong idea, that's it. Okay? Gamitin nyo na ang ganong style. Okay? Now, this is for real contracts again. Definitely sale under the civil code is not a real contract. Okay? Now, into the kinds of sale. Okay? There are many classifications again. Okay? There are many kinds of sale. Contracts are classified in so many ways, like into the subject matter. Okay? The sale may be a sale of a movable or a sale of an immovable. Why? They need to know. Ano ngayon kung movable? Ano ngayon kung immovable ang subject matter? Okay? Because there are certain principles, there are certain rules wherein you have to know, first and foremost, the object of the sale. Halimbawa, if you are confronted with a problem on statute of frauds, and this is a very much a favorite topic sa bar exam. At pag statute of frauds, 95% sale yan ang kontrata dyan. Rare ang tanong sa lease, okay? Or any other contract for that matter, okay? So, if the problem pertains to enforceability, pag ang tanong, is the contract enforceable? Aba, mag-isip ka na. More often than not, statute of frauds yan. Ito yung I would really advise you na focus on the question pero consider the facts. Okay? Pag ang tanong enforceability, okay? There are how many contracts na unenforceable? Ganun kaagad, diretso kaagad. So if the problem nakalagay oral contract ay statute of frauds more often than not. Okay? But it may also pertain to the parties. Kung nakalagay sa facts, both parties, yung isa baliw, yung isa minor, aba, unenforceable din yan. But not because of the statute of frauds, but because both parties are incapacitated. So read the facts, okay, to be able to answer really the question, okay? In a way, parang sabi ng mga examiners na nakakausap ko, ang pinaka-importante na marami talaga ang hindi nakukuha ay identification of the issues. You can only do that first if you read the question carefully. Is the contract enforceable? And then reading the facts, pag yung isang contract ay oral, aba, statute of frauds yan. Diba? Or ibang factual circumstances. So, ano pa? Statute of frauds, another principle or another rule which would require you to know the nature of the object of the contract of sale, whether movable or immovable, ay double sales, okay? Which we will discuss. Yung statute of frauds, I will discuss in mga 30 seconds, okay? Kasi dapat i-discuss na sa inyo yun, okay? Thus, parang papasadahan na lang natin ang statute of frauds under the law on sales, okay? Now, what else? Aba, direct to law, okay? Because that law can only be invoked if the object of the sale is a movable. Kaya pag ang tanong recto law ay unahin mong tingnan, movable ba or immovable? And sa bar exams, in relation to these topics, ang immovable lang na kanilang ilalagay sa problem, lupa. Okay? Walang kalapati na immovable na ilalagay nila. Okay? Hindi ka po problemahin masyado. Pag movable, ang ilalagay nila na object ay kotse, more often than not. Okay? Kaya ang kotse, movable talaga. Pag hindi na movable ang kotse, sindihan mo na. Di ba? Wala nang silbi masyado ang kotse. Okay? Now, lalo na pag ikaw pa ang pinapatulak para lang mukhang hindi na masyadong movable, ikaw na ang nag-move, okay, sa kotse. Now, but another one is the Maseda law, okay? Because this law can only be invoked if the object of the cell is an immovable but a very specific immovable. Hindi lahat ng immovables, okay, covered ng Maseda. Ang covered lang ay realty, okay? Kaya we will go into that, okay? Sa Maseda law. Thus, ano pa? A contract of sale may also be classified as to still the subject matter into whether the object of the sale is a thing or a right. Okay? Meaning whether the object is tangible or intangible, corporeal, incorporeal. This would be relevant, for example, when the question pertains to delivery, although this is not a favorite, but then again, I would always say there's always a first time, especially sa MCQs, okay? Kaya when I discuss delivery as one of the obligations, the obligation to deliver, it is very important to know because what is the object of the sale, kung thing or a right, because kung rights, okay, being incorporeal, walang actual delivery, walang physical delivery. And in other words, the law would provide for different modes of delivery in sale of rights. Okay? But also in things, it is important to know if the object of the sale is a thing because una nyo titingnan, is it determinate or generic? There have been questions like, what would be the effect of the loss of the thing? Okay? In a contract of sale, mamaya, titingnan natin, what if the thing was lost even before the perfection of the sale? Okay? What would be its effect? Okay? Nasa risk of loss basically ang tanong na yan. So we will go into that as we discuss the rule on risk of loss or the rules. Okay? But, by far, kaya ang pinaka-paborito sa bar exam, I would always maintain this, okay? Year in and year out. Ang classification of contracts of sale in relation to whether the parties agreed or the seller imposed a condition or conditions for ownership to pass. Okay? In other words, ang mga tanong sa bar exam would be like this. State the basic difference only in the legal effects between a contract to sell on the one hand and a contract of sale on the other hand. Okay? Sometimes I would ask my students, like sa finals or even sa midterms, questions taken from the bar exams. Okay? And I have asked this question a few times already. And a common error, pinaka-common, mga 90% ng mga estudyante would commit this error in their answer. Anong error? That they did not consider the fact that there are two kinds of contract of sale. In other words, you have to distinguish a contract to sell from the two kinds of contract of sale. Which kinds of sale are in the first article, nasa 1458, second paragraph, na ang isa ay absolute, ang isa ay conditional. In other words, you have to distinguish a contract to sell from an absolute sale, but you also have to distinguish a contract to sell from a conditional sale. And kung MCQ ito, this could be the possible options. In a contract to sell, ownership passes upon delivery. In MCQs, the examiner may not have to discuss yung buong buo. Like in a contract to sell, ownership passes upon delivery. Whereas in a contract of sale, ownership does not pass upon delivery. Obvious na yon, kasi nga distinction nga eh. Pag sinabing, because ang ganito ay pula, which means the other one is not pula. Di ba? So he doesn't have to repeat. And normally, he would only mention the first. Pag lalo na ang ginamit niyang word it, the it refers to the first, which is to be distinguished from the other. Okay? Dito nilagay ko mismo, contract to sell. Tama ba ito? That ownership passes upon delivery. Or, in a contract to sell, ownership passes upon the execution of deed of sale. Or, in a contract to sell, ownership passes upon the payment of the price. And finally, in a contract to sell, ownership passes upon the meeting of the minds, upon the thing and the price. The worst option here is letter D. Okay? That ownership passes upon the meeting of the minds, not in this country. Okay? Sabi nila sa France, ganun daw ang batas. That ownership would be transferred upon the mere meeting of the minds. Not in our country, because in our law, there has to be delivery. But the delivery need not be physical, need not be actual. It may be by constructive delivery, which we will discuss in a while. Okay? Now, kaya this is the worst. But ito ba or this one? Okay? This one is really wrong. Ownership passes upon delivery because that would mean the sale is an absolute sale. In an absolute sale, upon delivery, ownership passes because there is no condition imposed in relation to the transfer of ownership. Okay? Kaya upon delivery, ownership passes. Does it matter if the buyer not yet paid a single centavo? Hindi. It doesn't matter. In fact, in relation to this, magandang tanong palagi yan at madalas walang nakakasagot or konti lang. Ang installment sale, is it a conditional sale? Ang usual na sagot, it is. Okay? A conditional sale. Not true. Ang installment sale goes only into the manner of payment. That the payment will be by installment. Tingi-tingi. Pwedeng 10 monthly installments. But, okay? There may not be a condition as to when ownership would pass. And therefore, it would be an absolute sale. In other words, upon delivery, ownership would already pass, pero he still has to pay on a monthly basis. Installment ang payment plan. Okay? Now, but dito, ownership passes upon the payment of the price is also not correct. Okay? Because contract to sell ito, ownership would pass only upon the execution of the deed of sale. In other words, from its name, even in law, dapat ang pangalan would reflect the concept, di ba? Kung ang pangalan hindi nagre-reflect, parang pangit, hindi maganda. It will be hard for us to remember, okay? Minsan nga sa isang tao, pag ang pangalan niya ay sobrang ganda, hindi nagre-reflect sa tao, di ba? Parang ganda naman ang pangalan mo, parang hindi bagay, parang gano'n. Ganun din, when it is called contract to sell, because upon the fulfillment of the condition or the conditions agreed upon, there may not be only one condition, pwedeng dalawa, tatlo, ownership does not automatically pass in a contract to sell. Rather, the buyer would only have the right to compel the seller to sell now the thing to him. Kaya siya contract to sell. In other words, the seller now has the obligation to sell because the conditions had already been fulfilled. Okay? It is not true na ang condition in a conditional sale is always the full payment of the price. But that is the most common condition in a commercial sale. Kasi kung negosyo ito, ang seller normally would reserve ownership until full payment of the price. Yun lang naman ang kanyang interest, mabayaran siya. Pero among friends, it may not be the condition for ownership to pass. Baka ibang condition ang usapan nila. Kaya even this option, upon the payment of the price, not automatically correct, not necessarily correct, okay? Because it could be another condition. Rather, the Supreme Court would tell us that a contract to sell is a kind of conditional sale. It's a special kind, okay? Because ownership does not pass upon delivery. Pareho lang sila, okay? Yun lang, ang effect as to transfer of ownership is different. In a conditional sale, in an ordinary conditional sale, upon the fulfillment of the condition or conditions, ownership automatically passes to the buyer without the need of a new agreement. Hindi na kailangan mag-usap-usap ulit. Hindi na kailangan ng panibagong kontrata. Pero in a contract to sell, Just because the condition or conditions were fulfilled will not automatically result in transfer of ownership. There has to be the execution of the deed of sale. Ang tunay sa tunay na buhay, this is reflected sa sale ng mga condominium units. Okay? Pag may contract to sell na in-execute ang mga developers, okay? And the buyer had already, pag may contract to sell na yan, the buyer ordinarily would have the right to take possession of the condo, okay? Kasi normally bayaran na niya ang 1/3 of the price or what is known as the equity, which is normally 1/3. Pero pwede rin mas maliit, okay? Now, pag may contract to sell, dahil he's already in possession, does it mean that he already owns? Hindi. Okay? But upon fulfillment of the conditions, will he automatically own? Hindi. Okay? There has to be this final deed of sale for that buyer to acquire ownership over the unit. Okay? Now, ang next question dyan, in a sale agreement, nagkabintahan, how would you know if the contract entered into was an absolute sale, or a conditional sale, or a special kind of conditional sale na contract to sell? Ito magandang tanong, okay? Ito tinanong din, between a conditional sale and absolute sale. This is much easier to answer because, again, under the second paragraph ng 1458, there are two kinds of contract of sale, absolute and conditional, okay? Ang tamang option, conditional sale, ownership pass upon delivery, wrong. This pertains to an absolute sale. Conditional sale, ownership passes upon the execution, hindi. Para ito sa contract to sell. In a conditional sale, ownership passes upon the fulfillment of the condition or conditions is correct. Okay? Kung isa lang, this could be the full payment of the price. Again, this is the worst. But this one, again, how would you know if an absolute sale or a conditional sale or a contract to sell was entered into by the parties? Arthur gave Richard a receipt which states, receipt from Richard as down payment for my 1995 Toyota Corolla with plate number XYZ123, 50,000. Balance payable 12/30, 50,000. September dated, September 15, signed by the seller, okay? Does this receipt evidence a contract to sell? Okay? The answer is definitely no, okay? Dito, yes, because there was already a meeting of the minds. Again, just because there's a meeting of the minds. In all these three, may meeting of the minds naman talaga. Di ba? There was payment already. Just because there is payment already doesn't mean a contract to sell. Maski naman sa absolute sale, maski naman sa conditional sale, there could be payment already. Okay? But no, because there was no delivery yet, nothing to do with a contract to sell. In a contract to sell, the buyer may already be in possession, but he may not yet be the owner. Okay? But no, because there was no reservation of ownership. Basta sa isang sale agreement or receipt, which would be the basis of payment, does not show a reservation of ownership, absolute sale yan. Okay? Kaya, maski hindi pa nagbayad, not even a single centavo, as long as there was already delivery, there will be transfer of ownership upon delivery. Okay? Last year, ito ang tanong. Okay? This is 5%. A contract to sell is the same as a conditional contract of sale. Do you agree? Okay? Ang tanong, the same. Pag the same, pareho talaga. Kung ang buhok black din dapat sa kabila. The same eh. Iba ang the same sa similar. Okay? Are they the same? The answer definitely is no. They are not the same. Although, again, a contract to sell is a kind of conditional sale. Okay? Explain your answer, even if the examiner did not ask you to explain your answer, you have to explain the answer. Sabi nga, kailangan pa bang i-memorize yan? Di ba? Kailangan automatic, explain ka agad. Dahil so many questions na walang ganon. Okay? You will not get points pag walang mga explanation. Okay? Now, as discussed, it is not the same because it is a special kind. Okay? At ang distinction really, while since the same, ang similarity lang nila dito would go into the fact that there could be a condition or conditions imposed in relation to the transfer of ownership. However, the effect of the fulfillment of the condition or conditions would be different in a contract to sell kaysa sa ordinary conditional sale. Again, in a contract to sell, the fulfillment will not automatically result in transfer of ownership. There has to be the execution of the deed of sale. Pero pag conditional sale, upon the fulfillment of the conditional conditions, ownership automatically passes to the buyer, okay? Without the need of a new agreement between the parties, okay? Now, this one, okay? Distinguished from other transactions. Almost, I think I would say, all authors, okay, ng mga textbooks, would distinguish a concept from another, a transaction from another, okay? Like a sale from another contract or another transaction. But except for one author, okay, which si Villanueva, okay, in fairness to him, okay, all the other authors would have a portion of their book into this topic, distinctions, but they never bothered to tell us why they need to distinguish. Bakit kailangan mag-distinguish? Why they need to distinguish a sale from a dación in pago? Why they need to distinguish a contract of sale from a contract for a piece of work? Simple lang ang sagot dyan, okay? Because, for example, do you have a friend who asked you to distinguish this bottle of water from a Scotch tape? Pag mayroon kayong kaibigan na gano'n, medyo magduda na kayo, okay? Imagine mo, at the least, he's wasting your time, okay? But pangalawa, parang may nangyayari sa utak niya, okay? Wala namang silbi. In other words, there would be a need to distinguish one concept with another because there are similarities, okay? So that with the similarities, there can be a confusion as to what was entered into by the parties. Because if you failed to identify the nature of the transaction entered into, ay mali ang magiging principles na i-apply mo. Diba? In other words, you will not know the rights and obligations of the parties, of course, after considering the stipulations. Okay? Kasi ang akala mo, deposit yung pala pledge. Okay? Kaya mali na. Okay? But, in relation to dación in pago, why would the authors, lahat sila, would distinguish a contract of sale from dación in pago? One, because both transactions, I would not say contracts, okay? Isa lang ang kontrata doon. Both transactions would involve delivery, okay? Pero in sale, there is only an obligation to deliver. Whether or not the seller would be able to perform is another matter. In dación in pago, there has to be delivery. Can there be dación in pago without delivery? Wala. Okay? On the other hand, both also would involve transfer of ownership. Okay? But in sale, it is merely an obligation to transfer ownership. In dación in pago, there has to be transfer of ownership. This must have been discussed with you. Because in certain cases, pag walang transfer of ownership, ay walang dación in pago. Okay? But one last, probably one of the most important reasons is because if you remember 1245, under certain circumstances, dación in pago shall be governed by the law of sales. Kung pareho ang governing law nila, baka pareho lang sila, di ba? Thus, there is a need to distinguish one from the other. And sa bar exam, sa mga essay, this is a common type of question. Kanina, itong dito, phrased differently, parang ganyan lang yan. Distinguish a contract to sell from a conditional sale. Parang ganun lang yan, di ba? And there are many other bar exam questions. Ang tanong, distinguish this from that. Distinguish this from that. Especially in credit transactions. Because there are many transactions under credit transactions na maraming similarities. Okay? Kaya, going back to this, okay, sale, how do you distinguish? Distinguish a contract of sale from dasyon in pago. Pag ganyan ang tanong, again, always start with the nature of these concepts. Pag nasimulan mo na, ang maganda sa ganyang method of answering, meron ka ng template. Hindi ka na mag-iisip na ano bang approach ko dito, anong gagawin ko dito, di ba? Automatic, isipin mo nature of the transactions. Because if you know the nature, alam mo na ang susunod, more or less. Malalaman mo na kung bakit ganyan ang effects, bakit kailangan ng ganyan, because you know the nature concretely. Okay? Sale from dasyon in pago. A sale is a contract. Therefore, as a contract, it is a source of obligations. It is one of the sources of obligations enumerated in 1157. But dasyon in pago is a special form of payment. And therefore, this is a mode of extinguishment. In other words, alam mo na ang mga susunod. Like, sale being a contract, then obligations would arise from a valid sale. Whereas, if this is dasyon in pago, there was dasyon in pago, then an obligation would be extinguished. At alam nyo na dapat, dahil contract of sale ito, then there is no need for a pre-existing obligation for a contract of sale to be entered into. Pero can there be dasyon in pago without a pre-existing obligation between the parties? Wala. Okay? Kaya alam nyo na ang mga effects, ang mga consequences, minsan even the requisites, because you know the nature of the concepts. Okay? Yun nga lang, tingnan nyo naman ang points. Okay? Lalo na if the exam is a very long exam. Okay? Although I would say very long. Kasi ang long or short, very relative, di ba? To some examinees, the exam may be very long, but to some, it was a short exam. Why? Kanya-kanya tayo eh. Yung iba mabilis magbasa, yung iba hindi gaanong mabilis. Okay? Yung iba, at a glance, naintindihan na nila ang problem. Yung iba would take 5 minutes to understand the problem. So, relative talaga yan. At any rate, tingnan nyo ang points allotted to that question. Okay? Kasi naman kung 1 point lang naman ang naka-allot, maski alam mo lahat ng 10 distinctions, huwag mo namang ipaalam sa examiner, alam ko ang 10. In other words, inubos mo ang time mo. Diba? 1 point lang, pwede na yan. Isang distinction lang, at most 2. Diba? Huwag mo nang ipakita na alam ko lahat, sayang ang oras mo. Okay? Pero naman kung 5 points yan, katulad kanina dito, by all means, maybe 1/2 page ang sagot mo. Maybe 1 sentence may not suffice. 5 points eh, di ba? Kaya tingnan nyo lang, ito importante yan, yung points allotted. May mga questions na 1 point, mayroong 5 points, 3 points. More or less, alam nyo kung gaano katagal ka dapat per question. Divide mo lang ang points, okay? In a 5-point question, normally 10 minutes would be a good period. If you can answer less than that, that would really be good. Okay? Now, kaya lang tingnan nyo nga ang items. Okay? Ang promise daw yata ngayon, there will only be 10 questions sa essay. Pero pwedeng merong sub-questions like A and B. Hopefully, hindi A, B, C, D, and E. Diba? 10 nga lang, pero tigli-5 naman ang sub-questions, okay? At sometimes ang sub-questions, magkakaiba, iba-iba. Minodify niya ang mga facts every sub-question. Ganun din, okay? Sale from dasyon in pago, okay? But also, ang pinaka-common would pertain to this, okay? A placed an order with B for 100 pieces of t-shirts for 10,000. which were then not available but manufactured by B and consigned to its sales outlets regularly. The contract between A and B is a contract for a piece of work, contract of piece of service, contract of sale, and remuneratory contract. Ang pinaka-obvious na mali dito ay remuneratory contract because from the facts, there was nothing to be remunerated. Wala naman siyang ginawang serbisyo na kailangan ng remuneration. Okay? But alin dito? Take note, itong dalawang ito, if you know the nature of this, a contract for a piece of work is just a kind of a lease contract. Okay? It's just one of the kinds. Okay? Minsan, parang tama ang contract of lease, pero mas maganda if supported by the facts. Maybe contract for a piece of work ang mas accurate na sagot kung the facts would warrant. But in the problem, the answer is this is a sale. Okay? Why is this a sale? This is in 1467. Okay? The rule enshrined in that article is known as the Massachusetts rule. Okay? Ang sale at sa contract piece of work are similar in many ways. One, of course, parehong kontrata, but also both would involve, may involve a thing. Okay? Ang contract for a piece of work, a thing would have to be delivered also to the principal or the employer. Okay? Just like in a sale. But also, the employer, the principal, would also have to pay a price. Parang sale din. So may delivery din. Pero, how would one be distinguished from the other? Under the Massachusetts rule, okay? If the thing to be delivered by the obligor to the other party is being manufactured in the ordinary course of business, okay, of this obligor, and being offered to the general market, even if at the time the order was placed, it was not at hand. In other words, whether or not it was at hand, meaning may stock man o wala, that will have to be considered as a sale. Okay? In other words, from the facts again, going back to the facts, nag-order siya ng one piece, which were not then available, pero manufactured and consigned to its sales outlets regularly. Thus, it is being manufactured in the ordinary course of business and being offered to the general market. This is clearly a sale. But if the thing to be delivered will only be manufactured because of the order of the other party, obviously not being offered to the general market, that would be a contract for a piece of work. Example, okay? Kagabi I watched for a few minutes yung Celebrity Bluff, okay? Kung nanonood kayo, okay? You should watch every now and then, okay? Hindi naman as in every 15 minutes na basa ay isang oras ang TV. Parang mali yun, maling-mali yun. Dapat parang reward system ito. After 2 hours of intensive reading, nakafocus ka talaga, maybe you should reward yourself with a 15-minute break. Manood ka ng Bubble Gang o kaya kung ano pa mang Celebrity Bluff. Okay? Doon sa Celebrity Bluff, I think yung portion na panood ko goes into that. Yung 5 all-time best basketball players. Sino ang 4 na pinaka and si who is this basketball player is reputed to have Shaquille O'Neal. He is reputed to have this feet na pinakamalaki, 23 inches, okay, ang kanyang paa. Yung iba dyan, mga 6.5 lang siguro, okay? Siya, 23. And ito ang maling sagot ng out of 4 nakuha nila ang 3. Abdul Jabbar, mga ganon, is number 1 supposedly. Of course, si recent, sino ito? Pero ang dapat na pang-4 si Malone, okay? Ang sagot nila, Shaquille O'Neal. Shaquille O'Neal has yung ganon, 23 inches ang mga paa niya. And thus, if he would order a pair of shoes, more often than not, that would be a contract for a piece of work. Because in ordinary sales outlets, walang shoes na ganun kalaki. Okay? Normally, ang mga shoes, mga 12, baka 14, masyado malaki na yan. Therefore, it cannot be a sale, okay? Ordinarily, okay? Unless meron talaga mga tindahan na talagang para lang sa mga big ones, di ba? Parang gym. May isang gym sa US. Maraming gym na para lang sa mga medyo healthy, okay? Pareho sila, di ba? Pero tama din yun. Kasi mahirap pumunta sa isang gym na sila lahat, ang gaganda ng mga katawan, ikaw lulumba-lumba, parang gaganahan ka bang pumunta doon? Parang yung hiya mo pa lang, hindi na ako pumasok sa gym na yun. Thus, 1467, for the Massachusetts rule to distinguish a sale from a contract for a piece of work. But, anong relevance? Why do you need to know kung sale or contract? Anyway, magdi-deliver naman talaga ang isa. Magbabayad naman ang isa. But, there are many issues, okay, na principles which would require you to make this determination. Like, statute of frauds, okay? If this is a sale, this may be covered by the statute of frauds. If this is a contract for a piece of work, even if the price to be paid is 10,000 pesos, this may not be covered. I use the word may because hindi totoo, as claimed by some authors, that a contract for a piece of work will not be covered, is not covered by the statute of frauds. Meron kasing authors dyan, ang feeling nila, okay, tingin nila, that only contracts of sale and lease are covered by the statute of frauds or may be covered. Hindi totoo. Any agreement, any contract may be covered by the statute of frauds if under the terms of the agreement, it is not to be performed within 1 year. If it is not in writing, it will be unenforceable. Okay? But, aside from the statute of frauds, in actual cases, there would be such an issue. Ang naglalaban dito ay ang BIR at saka taxpayer. Because magkaiba ang tax rate pag sale at saka contract for a piece of work. Kaya ang BIR siyempre gusto mas mataas, yung taxpayer gusto mas mababa. So one would claim na sale, the other one would claim that this is a contract for a piece of work. Okay? Now, and then sa CPA board exam, okay, common itong tanong, but had not been asked yet sa bar exam. Pero, again, there's always a first time. Example, until nagkaroon ng MCQs, there had never been a question sa bar exam for the past 30 years on third-party payment. Okay? Pero nako, every year yan sa CPA board exam, may mga tanong palaging ganon. Pero mula 2011, may tanong na on third-party payment. Kaya, pwede rin ganyan, mangyari ito. Okay? In an agreement between A and B, okay, A obliges himself to give to B, to deliver and transfer ownership. To give to B his watch. Okay? Ang value ng watch could be 800,000. Okay? Parang ang ibinigay na watch ni Manny Pacquiao. Kanino kaya? Sa asawa niya. Okay? During her birthday. Now, si B on the other hand obliges himself to give to A his car, a specific car. Okay? This is a specific watch. Plus 350,000 pesos in cash. Okay? What contract was entered into? Okay? What law shall govern the transactions? Well, if you remember the rule, okay, you start with the intention of the parties. Okay? If they intended this to be what? Dalawa lang ang possibilities. Sale or barter. Kaya lang may issue dito kung sale or barter kasi may thing na may amount pa. Had this been car lang, an exchange of the watch and the car, that would have been barter. Without the car, cash lang at saka watch, this would have been a sale. Either is a combination, car and watch, car and amount. Okay? If the intention is not clear, ang susunod ay, how would you know? It depends on the value of the car in relation to the amount. The value of the watch is irrelevant. Ang gulo lang yan. Okay? You just have to consider the value of the car in relation to the watch, because if the value is higher than the amount, this is not the price, okay? The amount, okay? Then it would be barter. Pero kung ang cash is higher than the value of the car, then it would be sale. Pag equal, sale pa rin, okay? And then finally, this one. A granted B the exclusive right to sell his brand of maong pants, okay, in Isabela. The price for his merchandise payable 60 days from delivery, and promising B a commission of 20% on all sales. After the delivery of the merchandise to B, but before he could sell any of them, B's store in Isabela was completely burned without his fault, together with all A's funds. Must B pay A for his lost funds? Okay? Pag ganun ang tanong, what is really the issue here? Okay? Must B pay A for his lost funds? In a way, the issue here is who will bear the loss. Okay? Because if it will be A who will bear the loss, because the funds were lost, okay? Then he will have to pay the price. If not, then it would be A who would have to bear the loss, then B cannot be compelled to pay the price, okay? But how would you know kung sino as to who will bear the loss, okay? Well, una, you have to know the rules on risk of loss. But equally important, you have to know the nature of the transaction. Because if this is, in the problem, okay, there can only be two possible transactions here. This could be a sale or an agency to sell. Kasi may pagka-agency di ba? Meron nakalagay na commission, 20%. Meron nakalagay na exclusive right to sell. Pag ganyan, may pagka-agency ang dating. Okay? But apparently, this is a sale. Okay? May price, mayroong delivery, etc. Okay? Now, thus, how would we know kung sale ito or agency to sell? Okay? This bar exam question, I am 99.99% sure, is based on an actual case. Binago lang niya ang mga facts. Okay? This is based on Quiroga versus Parsons. Okay? Although in Quiroga, mga beds, hindi mga pants. Okay? But as to the other facts, medyo similar. Okay? Now, as discussed in that case, if a contract has characteristics, both of a contract of sale and agency to sell, ano ang gagawin? Express provision of the law, 1466, okay? Consider the essential clauses of this contract, okay? Ano ba ang pinaka-essential clauses? As discussed also in Quiroga versus Parsons, in this problem, ang essential clauses would go into the obligation to deliver, okay? But I would also say the most important clause in this problem is the clause wherein B is obliged to pay the price within 60 days from delivery. Okay? A granted B the exclusive right to sell the price for his merchandise payable 60 days from delivery. With that stipulation, would that be a contract of agency to sell? Definitely no. Because in agency, okay, the agent will never have an obligation to remit us any sum of money if he was not able to sell. Sine qua non ang pagbebenta bago magkaroon ng obligation to give a sum of money. But dito, payable 60 days from delivery, is there any condition na dapat maibenta niya? Wala. As long as umabot ang 60 days na yan, he has to pay. Kaya it cannot be an agency to sell. As the Supreme Court concluded, this is a sale. Now, knowing that this is a sale, just to complete yung discussion, para masagot ang tanong, ang susunod dyan ay, how would you know as to who will bear the loss? Aba, Philippine law follows as a rule, res perit domino rule. Whoever was the owner at the time of the loss, which is clearly fortuitous, okay, has to bear the loss. But, ang susunod mong tanong, in the problem, who was the owner at the time of the loss? Since this is a sale, ang susunod mong tingnan, what kind of sale? Is this an absolute sale or this is a conditional sale? Is this a sale on trial, etc.? In the problem, I will also tell you this is an absolute sale. In most bar examination questions, mga 95% absolute sale yan. As long as there is no reservation of ownership made by the seller, you can conclude na absolute sale. And therefore, ang susunod mong tingnan, dahil absolute sale ito, had there been delivery. Pag may delivery na, then the buyer already owns the thing. At the time of the loss, he was the owner, he will have to bear the loss. Therefore, he can be compelled to pay the price. Kaya dito sa options, must be paid A, yes, because they entered the contract of sale where the buyer bears the loss after its perfection. Wrong law, mali ang batas, okay? Our law does not say buyer bears the loss. It is owner bears the loss, okay? And the buyer need not be the owner at the time of the loss. In fact, there are exceptions to this rule, okay? Pangalawa, yes, because they entered the contract of sale where the owner bears the loss, okay? Or, no, because they entered into a contract of sale where the seller remains as owner until full payment, okay? Which is not necessarily correct. Contract of sale can be an absolute or conditional sale. But in the problem, walang condition, okay? Kaya it's not true that the seller remains owner. Letter D, no, because they entered into a contract of agency. Ito, problem niya, nasa determination ng contract, what contract was entered into. But they entered into a contract of sale. Ang tamang sagot ay letter B. They entered a contract of sale where the owner bears the loss. Okay? Now, thus we can go into this topic, okay? Elements of a contract of sale, okay? In contracts, we know that there are three elements of contracts, okay? May essential elements, may accidental elements, may natural elements, okay? And these elements really can be seen sa sale, okay? Unlike in other contracts, because there are natural elements in a contract of sale. Natural elements like implied warranties. In other words, they are deemed part of the contract even if not stipulated by the parties. In fact, even if not known to the parties. Deemed part of the contract. Whereas ang mga natural elements in a contract of sale would only be present in the contract because the parties so agreed upon. Okay? Because it was so stipulated. For example, in a contract of sale involving a parcel of land, as to whether the seller would have the obligation to have the land registered in the name of the buyer, that is an accidental element, okay? Because there is no law requiring the seller to perform such an obligation. It has to be stipulated by the parties, okay? Of course, ang pinaka-importante ay ang essential elements, okay? Now, essential elements again, because without one of these elements, there can be no valid contract. Each element is necessary for the contract to be valid. Okay? Lacking one, wala. Void ang kontrata or inexistent. Okay? So, I'll go into the essential elements. I'll start with I would normally ask my students, what are the essential elements of a contract of sale? Ang common na sagot dyan ay consent, object, cause, o diba? May pagka-judgment ang sagot, okay? by all means, pag sinabi ng batas, consent of the contracting parties, kumpletohin nyo ang batas. Consent. Consent of whom? Consent of one would suffice? Hindi Consent of the contracting parties. 3 man sila, 5, basta consent nilang lahat. Di ba? Kung ang 3, kung 5 sila, 3 did not give their consent, baka yung 2. Okay? There could be a contract as to the 2. Okay? Now, pangalawa, object at saka cause, yung sagot na yan may have been a bit accurate. Kung ang tanong, what are the essential elements of a contract? Kaya lang ang tanong, essential elements of a contract of sale. And the contract of sale has its own object, has its own cause. Okay? Otherwise, tinanong ko about agency, ganun din ang sagot mo. Consent, object, cause. Partnership ang tanong, consent, object, cause. Parang walang pagkakaiba. Di ba? So we have to know the subject matter of its contract, of its nominate contract, and the cause in its nominate contract like a sale. Okay? Of course, consent, kasama dyan, who are prohibited from entering into this contract. There are certain people who are so prohibited. Okay? But just to tell you, for example, if I would ask, what is the cause in a contract of sale? Aba, ang sagot dyan ay the price, okay? Which is really wrong, okay? Because if you know what is a cause is the essential reason which impels one of the parties, okay, to enter into the contract. And the cause will depend on what kind of contract is involved, whether it is an onerous contract, a gratuitous contract, or a remuneratory contract. Pero dahil alam mo na ang sale ay onerous contract, in fact, essentially onerous, therefore, what is the cause in an onerous contract? Sabi ng batas, in an onerous contract, the cause as to each contracting party is the promise or prestation to be performed by the other party. In other words, as applied to a contract of sale, ang cause ng seller is the promise of the buyer to pay the price, among other promises. But as to the buyer, ang kanyang cause is the promise of the seller to deliver and transfer ownership over the thing. Magkaiba ang kanilang cause. Okay? Now, thus, into these 3 essential elements in relation to a contract of sale, I would start with this. Okay? Now, I will not deal on the specifics. Okay? Not relevant to a contract of sale. But we all know na ang pinaka-common na fictitious contract is a contract of sale. Okay? Kung mayroong 100 na kontrata na fictitious, I'm sure 99 dyan ay sale. Okay? I've read only one case na fictitious ang lease. Okay? But sale would be common. If no consent was given, no consent by whom? Even only by one of the contracting parties, the contract would be void. Okay? And in sale, take note under 1409, fictitious contracts are void contracts. Okay? Simulated contracts are also void contracts. Okay? Now, but fictitious, normally ang walang consent dyan ay ang seller. Okay? Because in a deed of sale, ang manifestation ng consent ay signature. At ang signature ng seller would normally be forged. Okay? Kaya walang consent ng seller, kaya the contract is void. I still have to read a case na ang signature ng buyer ang finorge. Okay? Mukhang wala. Kasi kung buyer, pera yan eh. Okay? Kung pera yan, maraming paraan sa pera. Pwede mag-hold up, although hindi ko sinasabing mag-hold up kayo kung kailangan ng pera. Manghiram, o di ba? Instead na mag-forge ng signature. Pero pag seller, because this person wants the property of the seller, okay? Gusto niya ang lupang yon, hindi pwedeng ibang tao, etc., ibang transaction. So, fictitious. But simulated, the law would tell us the 2 kinds of simulated contracts. Ang absolutely simulated and relatively simulated. And I would have to tell you yung nangyari sa impeachment proceeding. Okay? If you follow this proceeding, okay, mula simula hanggang dulo, I dare to say, okay, most of the issues halos nasa contracts. Okay? Araw-araw kontrata ang pinag-uusapan. Okay? Mga kontrata. Kaya understandable, pagdating sa bar exam, kontrata ang pinakamarami. Sa Oblicon, out of 40 items, 28 nasa contracts. Ganun kadami ang tanong. Okay? Anyway, doon sa impeachment proceeding, just to show to you yung relevance ng mga kontrata na ito. The prosecution had these theories. Okay? Kasi ang pinaka, I would also agree, the most serious of the charges pertains to the charge that the Chief Justice, there was a culpable violation of the Constitution. And basically, ano ang violation na ito? That he did not include in his SALN certain properties. Okay? Pagdating sa absolutely simulated sale, ilang kontrata ang involved dito. And one of them, if you remember, pertains to a sale of a parcel of land somewhere in Marikina. Di ba? Now, ang theory ng prosecution, absolutely simulated sale ito. Okay? Because una, ang buyer is a relative. Okay? Parang pinsan. Okay? Although per se, I will not accept that as a good basis to conclude na simulated. Dahil pinsan, simulated na. Pangalawa, ang reason ng prosecution was because the sale purportedly was executed in more than 10 years earlier before the proceeding, pero the buyer never bothered to have that land registered in his name. Do I also consider that as a serious basis? Hindi rin. Kasi ang mga Pinoy, basta hawak-hawak lang nila ang deed of sale, lalo na hawak nila ang original owner's copy, ay okay na sa kanila. Wala nang register. Yung iba nga hindi alam yung registration di ba? So why register? But one of the most serious, if I would personally consider this serious, pertains to the credibility of this document, deed of sale. Credible lang yan, una, kung notarized. Kasi kung private instrument yan, ay easily it can be antedated, di ba? Kunyari, 2001 ang date ng sale, pero sa totoo lang, kahapon lang yan, di ba? Nilagay lang 2001 ang date ng execution. Pero, pag notarized ang document, nako, with the presumption of the regularity of the performance of the functions of notary public, baka totoo nga. Ang date ng notarization ay 2001, baka totoo may presumption of regularity, kaya baka totoong may bentahan as early as 2001. Therefore, wala talagang, the property is not his property, therefore he doesn't have the obligation to include the land in his SALN. Di ba? Ang problem lang in relation to that, okay, na naging issue uli ay the fact na ang notarized nga. Pero naman, ang notaryo publiko who allegedly notarized doesn't exist. Okay? Because it was supposedly, the notary public was supposedly commissioned sa city of Makati, but the clerk of court of Makati issued the certification to the effect that there is no such person, there had never been such person authorized or lawyer authorized to as a notary public in the city of Makati. Kaya mukhang guni-guni lang ang notarization na ito. Okay? Although, one of my students after the conviction na in another law school told me that this person daw is totoo daw talaga, but the person is already in the States. Ako, I told the class, that person who notarized should have testified in court. In fairness to the Chief Justice, di ba? For truth to come out, for justice to be administered, hindi. Baka naman talagang gawa-gawa lang nila yon, di ba? Ganun palagi ang presumption. But, in relation to yung absolutely simulated, because the contract, like the sale, will be simulated because ang effect nun, No, ang purpose is just to deceive somebody else that there was such a sale. Ang usual na sinasabi ko ay to deceive creditors, to make it appear that the debtor doesn't have properties which may be reached by the creditors. Pero in the impeachment proceeding, it was meant to defraud clearly the government, okay? To make it appear that the person doesn't own the property anymore, okay? Yun ang theory ng prosecution. But sa relatively simulated contract, and again, this would normally be a sale, the parties really intended another transaction, but they would simulate a sale. For what reason? Ang pinaka-common ay tax evasion, hindi nga tax avoidance. Kasi pagdating sa ang tunay na transaction ay donation, ang isi-simulate nila ay sale. Kasi ang tax liability sa sale ay di hamak na mababa. Okay? Like 5% capital gains plus documentary mga 7%. Pag donation, lalo na kung malaki ang value ng property, magkano na ang tax percentage? 32 ba? I'm not so sure. Hindi ko masyado ang percentage sa tax. Okay? Kaya, many Filipinos would simulate a sale even if the real transaction was a donation. Sa impeachment proceeding, that was exactly the theory of the prosecution. In relation to the sale of a condominium unit, okay, na ang spouses were the sellers, ang buyer was one of the children. If I remember correctly, si Carla. Ang price in the deed of sale was 14 million pesos. Dalawang theories. Sa civil law, pwede ka magkaroon ng 10 theories. Okay? At kung yung isa lang ang natsambahan mong tama, panalo ka ng kaso. Diba? Ang theory ng prosecution, pwede itong absolute sale, pwede rin itong simulated sale. Absolute in the sense, well, they never intended to be bound. Kunya-kunyari lang ito, okay? Nabentahan sa anak. Diba? But ang relative simulated, ang theory ng prosecution was, ang tunay nilang transaction ay donation. Okay? But they made it appear na sale. Again, for tax liability. Kaya, what happened? Sino ang witness ng prosecution in relation to this? No less than Kim Chu. Ay, hindi pala si Kim Chu. Namatayan ng nanay si Kim Chu. Okay? Si Kim Hinares. The commissioner herself of BIR was the witness. And she testified in court. Pag simulated ang kontrata, okay, they never intended to be bound. Do you think the buyer would have to pay? Wala. Kasi wala namang tunay na intention na magbayad. Okay? But, kung relatively simulated, donation ito, okay? Pero sale ang sinimulate, ang tunay na kaso, mga kaso sa Supreme Court, how to prove na simulated lang ito? Ang buyer walang capacity to pay. Tambay lang siya, di ba? So kung tambay ka lang, ang price ay 14 million, paano naman naging sale yan? Mukhang hindi sale. Mukhang donation lang ito sa anak, especially to children, okay? Kaya si Commissioner Hinares ang nag-testify as to the income of this buyer for the preceding year bago ang sale. Aba, kung napanood niyo yon, kung magkano ang income ng anak in the year preceding the sale, a staggering amount of 9,000 pesos. Okay? And she bought a condo for 14 million pesos. O diba? In a way, parang ang balahibo ko tumataas. Okay? Kasi, una, 9,000 pesos lang kita niya, nakabili siya ng 14 million. Ako nga, ang kita ko buwan-buwan ay baka Kim Hinares din ako. Hindi ako nakakabili ng condo worth 10 million pesos. Di ba? Kaya mukhang hindi totoong sale ito. Anong nangyari? Ngayon, may kaso sila. Di ba? Kinasuhan sila ng BIR for tax evasion. Okay? Now, thus, ganun ka-importante ang mga principles na ito. Okay? On the other hand, if consent was given, okay, by both parties, even by both parties, it will not guarantee na valid ang kontrata. Normally, when I say valid, it is really valid and binding in a way. It is enforceable. Otherwise, I will say unenforceable. Otherwise, I will say voidable, etc. Okay? Now, pero sa bar exam, madalas yan, valid and binding. Okay na rin yun. Okay? Buti pang sobra kaysa kulang. Di ba? Now, but even if consent was given by both, the contract may not be a valid contract or not be a binding contract because consent may have been given by a party who is incapacitated. Okay? So if given by an incapacitated person, what will be the status of the contract? Una, it depends on what kind of incapacity is involved. Okay? In sale, nako, talagang totoo ito. Merong absolute incapacity, merong relative incapacity. Okay? Absolute incapacity, by its name again, the person cannot validly give consent in any contract with anyone involving anything in whatever capacity. Absolute. Cannot validly give consent, it doesn't mean that he will not give consent, but it was not a valid consent. Okay? Like, but in absolute incapacity, there are two kinds of capacity under the Civil Code. May juridical capacity, may capacity to act. Okay? Again, juridical capacity is the fitness to be the subject of legal relation. Who is this party to a contract without juridical capacity, which is synonymous to juridical personality? Well, it could be in a deed of sale, one of the parties was already dead at the time the contract was entered into. Kaya lang, more often than not, the signature will be forged. Patay na nga, paano makakapirma? But there is a good possibility, ang isa ay, his thumb mark was affixed on the document when he was already dead. Pero mainit-init pa, okay? Medyo napo-fold-fold pa kasi after so many hours, matigas na, di ba? Mahirap na. But that is possible. In real life, in an actual case, De La Cruz case, okay? These persons who were interested in the parcels of land of the deceased, okay, affixed his thumb mark when he was already dying, okay, unconscious in his deathbed. He was almost 100 years old na. In fact, after the alleged execution of the sale, he died, okay, days after, okay. Now, status of the sale, was it merely voidable because there was fraud? The Supreme Court said, hindi lang ito voidable. This is really void. There was really lack of consent. Hindi lang ito vitiation of consent. Wala na siyang ulirat unconscious na. What consent ang binigay? Wala. Okay? Kaya the contract was not merely voidable. Kasi issue dyan kung voidable lang or void. Dahil may fraud voidable, not necessarily. Baka because of the fraud, he really actually did not give consent. Kaya void. Why is there a relevance here? One, prescription. Di ba? Because pag void, imprescriptable ang action. Dito, within 4 years in general. Okay? Now, also ratification. But, in relation to other cases, okay, in most cases, the contract would be void because one of the parties has no capacity to act, because one of the parties is a corporation which is not registered with the SEC. Therefore, it did not acquire juridical personality. Therefore, the sale would be void. Practically, isa lang ang party doon sa contract. Okay? Pero, dito, ang pinakamaraming tanong dyan sa absolute incapacity pertains to the fact that there is or there are restrictions in one's capacity to act. Okay? I prefer the use of restriction because in a few provisions nakalagay lack of capacity to act. It's not strictly lack of na wala, okay? Kundi meron lang restriction sa kanyang capacity to act. And we are all too familiar with these restrictions, okay? Ang pinaka-common na lahat tayo ay dumaan ay minority, of course, okay? I'm sure wala na sa inyo ay minor under the present law, okay? But there is another common factor which would incapacitate, although mukhang hindi lahat tayo dumaan. Kaya ilan lang dito ang dumaan, which is insanity. Okay? Although minsan may mga moments of insanity talaga tayo, di ba? Lalo na kung bastos yung driver sa harap mo, maraming meron talagang as drivers, sino man ang drivers dyan, always bear in mind that you are not the only person in the world, okay? Hindi lang ikaw mag-isa sa daan, okay? Kaya lalo na kung ang daan, isa lang for one person, huwag kang mag-drive at 10 kilometers per hour, di ba? Busy yung ibang tao. Maano ba naman ang 50 kilometers per hour or even 80 kilometers, lalo na kung medyo highway yan, okay? Kaya nga sa mga expressway, may minimum di ba? Kaya isipin nyo lang palagi yung ganon. Lalo na yung ibang drivers, 2 lanes yan, pero nasa gitna talaga sila, di ba? Pwede naman sa kanan, pwede sa kaliwa, pero wala talagang pag inanuhan mo, paggalit pa, sila pa ang galit, di ba? I hope you would always consider that, okay? So, insanity, marami pang mga ibang restrictions, okay? Like civil interdiction is a restriction because the person cannot freely dispose of his properties by acts inter vivos, okay? Kung gusto mo, mortis causa, di ba? In a will, pwede, okay? Now, but if only one of the parties is incapacitated kasi minor siya, voidable, okay? Voidable, but, okay? Is it possible that if this party, who was then a minor at the time when he entered into the contract, the action may not prosper? Yes, there are many reasons, okay? But I have to emphasize to you in relation to a sale, una, the principle of stopel, okay? Because the seller, who was then a minor, may have misrepresented actively as to his age, okay? He made the other party believe na of age na siya when in fact he was not yet of age, okay? Pwedeng sabihin niya, 18 na ako o 19 na ako when in fact he was only 16 years old, okay? Although minsan, yung ibang tao, siguro, medyo confident siya na mukhang 19 na ito kasi balbasarado, di ba? Mukhang 19 years old. Pero talaga may mga tao na 16 pa lang, pero pag magsalita, o yung mukhang 25, mukhang 35, di ba? Pero meron din mga 45 pag mag-isip 15, okay? So, kanya-kanyang trip lang ito sa buhay, okay? Kaya pag ikaw ang party ng kabila, ay manghingi ka ng ID, di ba? Na may date of birth, para may diligence ka na ginawa, okay? But, the other one under the law on sales is, if the buyer is a minor, he may be bound to the contract. Ordinarily, he may have the contract annulled kasi nga, minor siya. But he may not be able to do that. He will be bound if the object of the sale is one of those considered as necessaries. Okay? Mga indispensable for sustenance. Pagkain, baka medisina, baka clothing, etc. Okay? Kaya lang, De Leon would say, this contract is valid. I will not go as far as that. Pag sinabi mong valid, completely valid, then the parties, both parties, would be bound to their obligations, okay, in that contract. Hindi naman absolute yan. Because if you read the provision, kung ang price na nakalagay, 10,000, do you think the buyer is required to pay 10,000? Not necessarily. Because he will only be bound to pay the reasonable price for the thing, not the price agreed upon or stipulated in the contract. Okay? Now, but both parties parehong baliw when they entered into the contract is unenforceable. Last year, nandito ang mga tanong, okay, sa status ng contracts. Okay? Unenforceable, but pag niratify ng isa, magiging voidable na lang. Isa na lang ang incapacitated. Okay? Now, relative incapacity, I'll just have a few minutes dito, okay? break na muna tayo. Baka ginugutom na rin kayo, okay? So I'll continue with this incapacity, relative incapacity. Mahaba-haba pa lang usapan dyan, okay? Relative incapacity. There are certain persons who are prohibited, okay, from entering into this contract. But this is called relative because, una, only in relation to a sale. Second, because he may be prohibited only as a buyer. Third, because he may be prohibited only as to certain properties. And fourth, he may be prohibited only as to certain persons. Okay? Kaya relative incapacity. The provisions here under the Civil Code are 1490 and 1491. Okay? The spouses are prohibited from selling to each other. Okay? But then again, always be conscious of the possible exceptions. Okay? In 1490, the sale between spouses may be valid first if they executed a marriage settlement, and in that marriage settlement, they agreed on a regime of complete separation of property. Okay? Take note, do not stop because the spouses executed a marriage settlement. Again, hindi pwede ang tingi-tingi. Okay? Because they may have executed a marriage settlement, but if they agreed on a conjugal partnership of gains, the prohibition would still apply. Okay? It should have been a regime of complete separation of property for them to be able to sell to each other validly. Okay? Second, even without such marriage settlement, if during the marriage they were able to obtain a decree of separation of property. Take note, the law does not require a decree of legal separation, which is a common misconception. Because can there be a decree of separation of property without legal separation? Yes. Although if there is legal separation, necessarily there will be separation of property. Okay? But what is only required is separation of property, decree of separation of property. What is controversial is 1491. Okay? Although this had not been asked for the past 30 years, but again, it may be the first. Today, this year may be the first. Okay? First, for example, okay, ang controversy dito would go into the status of these contracts under 1491. Yung first paragraph pertains to a contract of sale entered into a guardian involving a property of his ward, where he was the buyer. Okay? Take note, under 1491, the following persons cannot acquire by purchase. Diba? 1, guardians in relation to the property of his ward. 2, agents in relation to properties which they were supposed to sell or supposed to administer. Yung third, executors and administrators. Okay? The fourth, the fifth, the sixth pertains to the judges, staff ng korte, where the thing is the subject of pending litigation, lawyers, etc. Okay? There are three groups of authors here in relation to the status. Some would say all these contracts are void, and believably that this would include Tolentino, kasama niya sina Professor Paras, etc. But on the other side, opposite, voidable lang sila. On the other side, sina Justice Vitug, sina Professor Baviera, Villanueva, all these contracts are void. In the middle, sina De Leon, Pineda, the first three daw are voidable, the last three are void. Okay? With all due respect to these authors, okay, ang sina Pineda, De Leon, may pagka-compromise ang kanilang position, di ba? Hati-hati. Okay? But the correct, if not just the better position, is all these contracts are void. Okay? But I will discuss at least the arguments raised by Professor De Leon. Siya lamang talaga ang may arguments dito. Why the first three should be treated merely as voidable and not void. First argument, that in these contracts, only private interests are affected. Pag private interest lang daw, hindi void, only voidable. There is no basis to this claim, okay? Private interest meaning interest lang ng ward, interest lang ng heirs, interest lang ng principal. But even in his book on sales, okay, he discussed the rationale of this prohibition. Sabi niya, because it is contrary to public policy. And he discussed the public policy involved here, okay? Thus, if a contract or an act is contrary to public policy, do you think it will merely be voidable? Okay, I don't think so, okay? It would be considered as void, okay? Second, I will discuss the last, yung isa. Ang basis daw is the decision of the Supreme Court in the case of Wolfson versus Martinez, where the court ruled that these contracts are merely voidable, okay? But if they read Rubias versus Batiller, the Supreme Court in that case ruled that ruling in Wolfson versus Martinez had long been abandoned by the Supreme Court even before the effectivity of the Civil Code of the Philippines. In other words, panahon pa ng mga Amerikano ang ruling na yan, okay? Kaya, even before the effectivity of the Civil Code of the Philippines, such ruling had already been abandoned. But what is really, in a way, magandang deep argument, okay? Maganda in the sense na there is parang konting basis, is that these contracts daw can be ratified, okay? Thus, they are merely voidable because void contracts cannot be ratified, okay? How are these contracts ratified, okay? As discussed by the Supreme Court in Rubias, concrete example, if the guardian bought the property of his ward when his ward was only 16 years old, mukhang this is prohibited under 1491. But what if, in that sale, who is the seller? Is the guardian representing the ward. But the buyer is the guardian also, okay? Ang tawag na dito ay auto contract, di ba? But what if the ward attained the age of majority, naging 18 na o 19 na kaya, and this time he sold the same property to the guardian again? May that sale now be a valid sale? Of course, it may already be a valid sale because there's no more prohibition. 18 na siya or 19 na siya. Therefore, this contract ratified the first. The Supreme Court said in that case, there are those who would claim that this contract can be ratified. The Supreme Court did not say that this contract can be ratified. Iba ang sinabi that there are those who would claim that this contract can be ratified. How? In that manner. But really, with the execution of the second contract, is there really a ratification? Sabi ng Supreme Court, ang tanong, when would the effect of the second contract start? Would the effect of the second contract retroact to the date of the first contract? The Supreme Court said no. Kaya sabi ng Supreme Court, there is ratification, but quote-unquote. This is not the real ratification, as ratification is discussed in the Civil Code. Okay? Because if there is really ratification, the effect of the second contract retroacts to the first contract, it would cleanse all the defects of the first contract as if there was no defect when it was entered into. Kaya kung mag-start lang siya dun sa date ng second contract, walang tunay na ratification. It would appear that the first contract is void because there can be no retroactive effect of the second contract. Now, but really, what is the basis why these contracts are void? Because of 1409. Malinaw ang 1409 that 1491 muna. 1491 says, the following cannot acquire. When the law says cannot, then the person is prohibited. And under 1409, prohibited contracts are void contracts. Okay? And take note, this prohibition is because of a public policy. Okay? This goes into the fact that there could be abuse of the power of the guardian, of the power of the agent, etc. Power of the judge. Kaya they are prohibited. Okay? Therefore, these contracts are void. But finally, the most favorite sa lahat ng prohibition dito in relation to relative incapacity pertains to aliens. Okay? If one of the contracting parties is an alien, and I would ask my students, In a contract of sale, if one of the parties is an alien, what is the status of the sale? More often than not, ang sagot, the sale is void. At ang sasabihin ko ay, if that is the law in this country, aliens will die, okay? Because they cannot buy anything in this world, okay? Hindi naman, okay? They are not prohibited from buying pandesal, okay? They can always buy mga deodorant o kaya mga underwear. But the Constitution prohibits them only from acquiring. And acquiring, it could be by purchase. In other words, from that prohibition sa Constitution, they are prohibited only as buyers. In other words, in a contract of sale where the seller is the alien, there appears to be no prohibition in the Constitution. Okay? Although ang tanong, how can he sell if he cannot buy, if he cannot acquire in general? Maraming rason. Una, the Constitution also would provide for an exception to the rule. In other words, aliens may inherit private lands, okay? Which I think that provision has wisdom, okay? This Constitution was drafted in 1986, pero at that time, wala pa masyadong OFWs, di ba? But now, there are millions of Filipinos by blood, but already citizens of other countries. I have cousins who are citizens of Britain, Canada, US, basically, okay? But when their parents died, did they inherit parcels of land? Yes. They are, in a way, this is an exception to the general rule that aliens cannot acquire, okay, private lands, okay? But also even that may exception, okay? Even if the buyer, okay, is, so hindi to succession, sale, okay, where the buyer is an alien, may the sale nonetheless be valid? The answer is yes. There is also a prohibition here, an exception to, in relation to a sale. If the buyer is a former natural-born Filipino citizen, okay, and the purpose of the purchase is for residential purposes, then it may be a valid sale. Take note, the buyer must not only be a former Filipino, but a former natural-born Filipino, okay, for the sale to be valid. Ang apparent intention here ng framers is to encourage our mga kababayan who are already citizens abroad to spend their retirement days in the Philippines. And by that time, milyonaryo na sila, okay? So the country will benefit from such, which I think has a basis. Because if you will survey yung mga Filipinos who are citizens already in other countries, tanungin nyo saan sila mag-spend ng retirement days? Sa Pilipinas pa rin, di ba? Iba pa rin ang Pilipinas, lalo na pag may pera ka, okay? Now, the Constitution, but take note, ang prohibited lang sila to purchase private lands, hindi naman sa lahat, okay, ng ibang properties. Before I proceed to that, I'll just complete yung discussion dito. Even if the parties who gave consent have the capacity to give consent, okay, that will not still guarantee a valid contract or a binding contract because there may have been vitiation of consent. Take note, ang vitiation is always confused with lack-of, mali, okay? Lack-of, wala. Vitiation, mayroon. May consent, pero napilitan lang, okay? Or there was, kaya nga, vitiation of consent, okay? Or nagkamali lang siya sa pagbibigay, pero nagbigay siya, okay? And in oblicol, this should have been already been discussed. Yung factors which would vitiate consent, like violence, intimidation, fraud, mistake, and undue influence, which would make the contract voidable, okay? Now, the last scenario is, consent was given by a person having the capacity to give consent, but it was given in the name of another person without the authority of that person. As a rule, unenforceable, okay? Unenforceable unless he has the authority of the law, okay? Because for example, yung guardian, does he have the consent of the ward? Wala naman. But he has the authority of the law, therefore contracts entered into by the guardian may bind the ward, okay? In this scenario. Otherwise, unenforceable. Example, okay? A husband and his wife were living together, the conjugal partnership gains. Later, because of a quarrel, the wife left the husband without judicial approval. They have thus been living apart for more than 10 years. The wife later sold her land to the said husband. Is the sale valid? Okay? The sale is valid because the fact of being separated for more than 10 years. It's not a matter of physical separation. Okay? It's not a separation in fact. The sale is valid because after the separation, there's already separate properties. Not necessarily, okay? The sale is void because of the absence of a regime. That is really correct, okay? Because the spouses are living apart, well, it's not about, again, separation in fact, okay? But this is the more common type of question, which appeared even last year, okay? Here in 2009, Luciano, in 1972, Luciano de la Cruz sold to Chua Chung Chun, a Chinese citizen, a parcel of land in Binondo. Chua died in 1990, take note 72 to 90, leaving behind his wife and 3 children, one of whom, Julian, is a naturalized Filipino citizen. 6 years after Chua's death, so that would be 96, the heirs executed an extrajudicial settlement of estate and the parcel of land was allocated to Julian. In 2007, Luciano filed suit to recover the land he sold to Chua, alleging that the sale was void because it contravened the Constitution, which prohibits the sale of private lands to aliens. Julian moved to dismiss the suit. On grounds of pari delicto, laches, and acquisitive prescription, decide the case with reasons. Okay? Ordinarily, if you are asked to decide the case, sa tunay na mga kaso, you have to address the arguments of the parties. Okay? If you decide for one of the parties, yung arguments ng kabila, i-address mo lahat. Okay? Because isa lang na argument niya ang tama at hindi yun ang na-address mo, mali na ang sagot mo. Diba? Now, but even in this alone, yung pari delicto, is this applicable here? No. Okay? Basta prohibition sa Constitution, yung pari delicto rule does not apply. Okay? Pangalawa, prescription, obviously no. Does not apply. Okay? Actions for the declaration of nullity of contracts are imprescriptible. Okay? Ang medyo pwede ditong i-argue ay laches. Pwede sana. But not under the facts, okay? Laches, unbelievably, sa Supreme Court, okay? In a recent case, the court already cited laches as a ground even only after 5 years. I really cannot accept really the decision, okay? Kasi nga, ang prescription nga, pwede nga 10 years eh. Laches pa 5 years, parang you slept on your rights 5 years pa lang. And when you have supposedly 10 years within which to file the action, parang hindi maganda. In so many cases, ang laches, pag mga 25 years, even if the contract is void, you may not be able to get back the property because of laches. Okay? Pero dapat matagal-tagal naman. Hindi naman 5 years, di ba? But nonetheless, that can happen. But here, I made these options. Okay? I will decide in favor of plaintiff because the sale is void as it is prohibited under the Constitution. Mukhang tama ang option, di ba? But I will decide in favor of plaintiff because the sale is void, thus the action does not prescribe. Parang tama din. Okay? Even if 2007 na ang action, 1972 ang sale, the action does not prescribe. Letter C, I will decide against the plaintiff because of prescription. Opposite lang. This is really wrong. Because an action nga, to declare a contract void does not prescribe. But letter D is the correct answer, okay? I will decide against the plaintiff because when the action was filed, the land was already owned by a Filipino. In other words, do not just know the law. Know the facts, okay? From the facts, okay? It was already acquired by one of the sons of the buyer, who is a Filipino, si Julian. And in the decisions of the Supreme Court, consistently, the court would tell us, hanggang 2012 na kaso, okay, that even if the contract of sale was void because the buyer was an alien involving a private land, the defect of such sale is cured if the land thereafter will be acquired by a Filipino. Kasi anyway, ang gusto lang naman ng Constitution, all the parcels of land would be owned by Filipinos. So if at that time the action to recover was filed or to declare the contract void, the land was already acquired by a Filipino, wala na. Okay? There's no more reason for the action to prosper. Okay? Kaya letter D. Last year, ito ulit. Okay? Which the same principle should be applied. Okay? If at the time the action was filed, Filipino na siya, okay? Yung owner ng lupa, then that land may no longer be recovered under the prohibition or because of the prohibition sa Constitution. Okay? Now, so into the subject matter. Okay? Some contracts may have the three as a subject matter. Pwedeng things, pwedeng rights, pwedeng services. But a contract of sale may also have these three. Yung lease, di ba? May lease of things, may lease of service, may lease of rights. But sale, hindi pwede ang service. Only things and rights may be the subject matter of a valid sale because we cannot buy service. Okay? Yung masahista, binibili ba natin ang serbisyo niya? Okay? Wala. Okay? We rent. Okay? We lease. Okay? Yung lawyers, we retain the services. Okay? We don't buy the services of lawyers. Okay? One basic reason for this is because we cannot own rights. Okay? Or we cannot own services. In sale, there has to be transfer of ownership, or at least an obligation to transfer ownership. Okay? Now, thus, as mentioned earlier, in the definition, only things. Okay? But if you will read the other provisions under this topic, under this chapter, even rights may be the subject matter of a valid sale. Yun lang, these contracts would normally be denominated or called as assignment instead of a sale. Pero, sabi nga ni Senator, pero Senator-elect din, okay? Alan Peter Cayetano, during the impeachment proceeding, sabi niya, if I remember correctly, if there is an assignment of a right, that is a sale. They entered into a contract of sale. Totoo ba? Accurate ba ang kanyang claim? Hindi. Okay? While a sale of a right is an assignment of a right, an assignment of a right need not be a sale. In other words, if there's an assignment of a right, it could be a donation. Kung wala namang valuable consideration, walang babayarang price, donation yan, bigay lang sa right, assignment of a right yan. But also, the Supreme Court had consistently considered an assignment of a right as dasyon in pago. Okay? Dasyon in pago may involve a right. Ang ipinambayad ng debtor sa creditor niya, rights niya. Like in one case, yung debtor, instead of paying in cash, ang ipinambayad niya, hereditary rights. So even before the partition of the estate of the deceased, kung saan siya heir, ipinambayad niya ang rights niya. Okay? In another case, ang pinambayad ng debtor by way of dasyon in pago ay ang kanyang credit as against third person. So ang third person, may utang sa kanya, siya may utang sa creditor niya, pinambayad niya ang credit niya to his creditor. Okay? Now, so again, rights may be the subject matter. As to rights, madali lang. Okay? The only in contracts, this should have been discussed, is the same rule in sales. Okay? As long as the right is not intransmissible, in other words, transmissible. Okay? It may be the subject matter of a valid sale. Okay? Like yun nga, credit, like the right to repurchase, like shares of stocks. Okay? Basta transmissible siya, then it can be the subject matter of valid sale. Pero sa things, okay, marami-raming requirements, okay? But I will start with, as promised, doon sa definition. The law says, determinate, okay? What if the object of the sale is generic, okay? Halimbawa, the object of the sale in a contract between A and B is a dog, okay? The features of the dog were not agreed upon by the parties, okay? Kaya walang nakasulat doon sa deed of sale except dog, okay? And the price could have been 120,000 pesos, okay? On the other hand, between X and Y, ang object of the sale nila ay 2013, okay? Maybe brand new Toyota Altis, okay? I think wala namang manual transmission na Altis, okay? So, automatic na ang kulay ay metallic brown, mga ganyan, okay? Status of these contracts. If you notice, both contracts of sale involve, each one would involve a generic thing. Kung dog, generic. Kung 2012, 2013 Toyota Altis, it's still generic, okay? This time, the law already would tell us when a thing would be considered determinate. Unbelievably, the law on obligations and contracts did not mention, did not tell us, di ba? Kung kailan ang bagay determinate or generic. Although there are so many provisions in oblicon which would require us to know kung determinate or generic. Pero nasa 1460 lang under the law on sales when a thing would be considered determinate because it is either particularly designated or physically segregated from all others of the same class. Okay? In other words, kung kotse ito, it would be particularly designated pag may plate number. Pinaka-common yan. Pero pwede maski walang plate number, kung may chassis number, that would be a determinate thing because it would then be particularly designated. Pero para sigurado sa mga deed of sale, nakalagay lahat. May plate number na, may chassis number, may unit number, lahat ng number nandun, di ba? But also, even if the features of the car were not mentioned, hindi nga nakalagay kung Toyota or Mitsubishi, but the parties agreed that this car is the car located in this garage at this address. And assuming lalo na, if there's only one car in that garage, that is a determinate thing because it is physically segregated from all others of the same class. Okay? Now, ang question thus is, in the definition, determinate ang nakalagay, may a sale involving a generic thing be a valid sale? The answer is yes. It may be. Again, pag may ang tanong, at maraming mga tanong dyan, as I will show you, okay? Ang sabi sa Tagalog niyan, ang tanong niya ay pwede ba? Okay? Kung pwede, by all means, yes. Kung hindi pwede, by all means, no. Walang sagot na it depends pagdating sa tanong na may. Okay? Last Thursday, I think, I was in another law school where the faculty members met and the administrators met the fourth-year law students, okay, in preparation for the bar exam. Medyo systematic sila ng konti, okay? And one of the professors, actually, he was my professor, okay? And he is also a professor in that law school. Told everyone, kasama ang mga faculty members, that in the bar exams, there should be no answer na it depends, okay? React agad yung isang professor who was also holding a microphone, dalawang microphones. Okay? Sabi ng isa, hindi naman. Hindi naman, pwede naman. If there is a need to qualify. In other words, if the facts in the problem are not sufficient for you to give a categorical answer, by all means, your answer should be, it depends. But ang question normally should be, will the action prosper? The answer is, it depends. Kung meron kang It depends kung ang kulay ay puti, it will prosper. Pag pula, it will not prosper. Diba? Because there's a need to qualify. Hindi na ilagay doon ang kulay. Okay? Pero ang categorical ay hindi pwede. A few days ago, ang estudyante ko ang sagot, Sir, it depends. Sabi ko, siguro may narinig ka na pag si Uribe ang nagtanong, ang sagot dapat ay it depends. Hindi totoo yan. Okay? Hindi sa lahat ng panahon ay it depends ang sagot. Okay? If the facts would warrant a categorical answer, hindi pwede ang it depends. Itong nag-react na faculty member who is, in a way, should I say, respected kasi nominated siya as Chief Justice ng Supreme Court. Kaya siguro siya nag-react ng napakabilis sa pag-react because I've heard her in one of our gatherings, faculty meetings, tell everyone that pumasa siya sa bar exam dahil ang lahat ng sagot niya ay it depends. Okay? Pumasa daw siya. Well, nagkataon siguro na ang mga sagot, ang mga tanong, warrant an answer na it depends. Okay? Kaya tingnan mo ang tanong. Okay? Importante ang tanong. Okay? So may the sale be a valid sale? Even if the object of the contract is a generic thing, the answer is yes. Okay? Under 1460, the requirement of the law that the thing be determinate, okay, is sufficiently complied with if the thing, which is obviously generic, is capable of being made determinate at the time the contract was entered into without the need of a new or further agreement. In a way, tatlo ang requirement dyan. Capable of being made, pag sinabi ng batas capable of being made determinate, hindi pa siya determinate. Capable pa lang. In other words, generic siya. But, hindi lang siya capable, but capable of being made determinate at the time the contract was entered into, not at any other point in time. But also, there is no need for a new or further agreement. Concretely, if you buy a bottle of water from a certain restaurant, there is a good possibility that there is no bottle of water in front, diba? So they may have the owner, if he is the owner, may have to go to his warehouse, okay, to get one of these bottles of water. And in that warehouse, what kind of thing is this thing? This is a generic thing. To be more precise, this is a limited generic thing. Pero, once he got this and delivered this to the buyer, that is already determinate. Because now, it is physically segregated from all others of the same class. Thus, is this capable of being made determinate? Yes. Every generic thing is capable of being made determinate. Okay? Kaya lang, it is not at any point in time, not at the time of delivery. It should be at the time when the contract was entered into. Okay? But pangalawa, without the need of a new or further agreement. Doon sa example ko kanina, sale of a dog. Okay? If the seller delivered a dog, lalo na kung askal ang dineliver, okay? Ang askal, sabi ng iba, pang asusena, okay? Ang presyo niya, mga 300, 400. Do you think the buyer will accept the dog na ang babayaran niya 120,000? Baka ang ibig niyang sabihin, dapat i-deliver siya sa kanya ay Rottweiler, di ba? Dalmatian, mga ganyan. Okay? Kaya nung dineliver niya ang askal, mukhang hindi pwede. But, he may accept. But the acceptance requires, in a way, a new agreement. Na okay na ito, na itong askal na ito ay okay. Otherwise, if they cannot agree, walang valid sale. Because they were not able to agree on the object of the contract. Okay? Thus, in that scenario, the sale would be void. But, doon sa altis, what would be the status of that sale? That can be a valid sale. I would normally say it may be a valid sale. Yung iba, it is a valid sale. Not necessarily. Malay mo, nagbintahan mag-asawa. Diba? Unless you know all the facts. pag sinabi ng examiner, may it be a valid sale, do not say it will be a valid sale. Follow the lead of the examiner. Kung may lang ang ginamit niya, by all means, may din ang sagot mo. It may. Okay? Maski ang tanong niya, will it prosper? Pwede ang sagot mo, it may prosper. Kasi hindi sa lahat ng panahon, it would prosper. Okay? So, ganun din dito. Okay? Doon sa Altis, it may be a valid sale because although the thing is generic, it is capable of being made determinate at the time the contract was entered into without the need of a new or further agreement. In other words, pag bumili ka ng brand new na Toyota Altis, hindi ka bumibili ng determinate thing. Okay? It will only be determinate una pag pinirmahan mo ng kontrata. Kasi iba yung reservation eh. By that time, may kontrata na kayo. Okay? Meron ng contract of sale pero wala pang permahan ng deed of sale. But in the deed of sale, kasama na yung chassis number, etc. Wala pang plate number. Kasi mga 3 taon pa bago mo makuha ang plate number. Joke lang. Sabi nila, it took me more than 2-3 months, okay, before the plate number was released. Pero ngayon, mas matagal daw. 6 months, wala pa rin, okay? Now, thus, into that requirement determinate, okay na tayo. But, this contracts of sale, okay? M. Ray Esperati at saka M. Spain. Okay? Minsan, magaling ka dapat pati sa mga Latin. Malay mo, magtatap ka dahil doon, di ba? At minsan, yung top notchers, maliliit lang yung 0.01 lang ang difference. Number 1 ka na sana. Okay? Kaya lang, medyo 0.03 ang difference, number 2 ka na lang. Okay? So, paminsan-minsan may mga Latin words, okay, or phrases. I will admit to you, in 2011, there was a question, MCQ sa property, okay? English ang tanong, ang STEM, pero ang options, puro Latin, okay? I honestly don't know the Latin of yung STEM na yun, yung problem. Pero when I read the options, alam ko yung 3 options, kung anong ibig sabihin. And I'm sure they do not pertain to the problem. So alam ko na, yung hindi yun ang tamang sagot, di ba? That's the beauty of MCQs where there are only 4 options. Pag na-eliminate mo ang 3, edi tama ka, di ba? Tsamba-tsamba lang ito, okay? But in a way, intelligent elimination, okay? Now, MCQs pay sale of hope, okay? And sabi ko kanina, sale is commutative, di ba? But actually, there can be a valid aleatory contract of sale. I would say, as a classic na commutative contract ang sale, because ordinarily, there would be equivalence in the value of the prestations to be performed by the 2 parties, di ba? Yung value ng property would normally be equivalent to the price. Because ordinarily, no person would sell his property at a price lower than its value. But ordinarily, again, a buyer will not buy a thing at a price higher than its value. Lalo na ang mga Pinoy, di ba? Mahilig tumawad, okay? Kaya pag halimbawa Green Hills ka o Divisoria, ang nakalagay 500 pesos. Pag sinabi mo 250, biglang sinabi, okay, talo ka, okay? Kasi pa sa kabilang tindahan, 150 lang yon, okay? Kaya minsan medyo dapat nga mag-ikot-ikot muna bago talaga bumili, okay? Thus, the value would be reflected sa price. But, of course, you can sell your property at a much lower price. As a rule, as will be discussed, that will not affect the validity, okay? Now, but aleatory, because in some contracts of sale, the value of the thing, okay, may not be reflected sa price. At ang pinaka-common dito ay yung sale ng mga lotto tickets, for example, okay, where the buyer may actually be entitled to 500 million pesos but he only has to pay 20 pesos, di ba? Kaya lang sabi ko, may lang, pwede lang. More often than not, hindi. Okay? Hindi siya mananalo, di ba? Out of so many numbers, kailangan mong 7, 6 ang makuha mong numbers. I tried this only twice in my life. Okay? Yung una, because of sa office. Okay? Yung mga officers sa office, in a way, agreed, mag-ano tayo? System betting. Okay? We choose only like 9 numbers, pero yung permutation sa 9 na numbers, covered lahat. Mahal ang babayaran nun kasi maraming combinations yun eh. Anyway, we have to pay each one of us 300 pesos. Okay? At marami kami. Pero nung lumabas ang draw, 0. Walang lumabas. Okay? Sa aming number. Maski siyam na number, 0. The next time around, kaibigan ko, one of my good friends. Okay? Ang usapan namin, paglampasan ng 50 million, naku, tataya na tayo kasi 50 million na. So, one morning, dahil alam namin mahigit 50 million, nag-jogging kami. Okay? At bumili kami ng ticket. Sa awa ng Diyos, wala ding lumabas. Okay? Kaya mula noon, hindi na ako bumibili. Anyway, nonetheless, this is an aleatory contract of sale. This is a sale of hope. Ang binibili mo lang ay pag-asa. Okay? Na importante sa Pilipinas kasi maraming mga tao nabubuhay sa pag-asa. Okay? Dumidilat sila kinabukasan dahil kailangan nilang tingnan kung lumabas ang number na kanilang tinayaan. Otherwise, there's no reason to be alive. Parang ganun. Now, that's sale of hope. Yun lang, it should be clear that sale of vain hope is void. Hindi lahat ng sale ng hope ay void. Okay? It's only the sale of vain hope. For example, sale of a lotto ticket, which ticket had been the subject of a draw a month ago. Void ba yun? Not necessarily. Baka naman winning ticket ito na binibenta, di ba? Actually, this is a sale of a right. Yung karapatan mo na i-encash yun, na kunin ang price mo, yun ang binibili mo, okay? As a buyer, you're buying the right, okay? Although ang tanong, why would anyone sell a ticket which is a winning ticket? Di ba? Aba, maraming rason, okay? Yung isa, security, for security purposes. Ang alam ko, 1 million or more, hindi mo yan may encash doon sa sari-sari store where you bought the ticket, di ba? You have to go to the main office. Kung taga Sambuanga ka, ako pupunta ka pa sa head office sa Manila. By the time na umabot ka, hold up na, di ba? Kaysa naman may hold up, ibenta mo na lang sa Sambuanga, di ba? On cash basis. Pero normally at a lower price, okay? And so many other reasons, okay? Pero kung losing ticket yun, ibibenta, that is a sale of a vain hope and the sale will be void, okay? Empture esperati pertains to the sale of future things, okay? Future goods, future things. In other words, even if the thing is not yet in existence at the time of the perfection of the sale, as long as it has a potentiality of existence, the sale may be a valid sale. At ang common in the rural areas na binibenta na hindi pa man din tinatanim ay ang palay, di ba? It is sad that our farmers would actually be selling yung produce ng lupa nila after 1 year pa, hindi nga yung susunod na harvest. Yung 1 year after pa na produce, yun ang ibibenta nila. Pag ganyan, parang wala ka nang gana magtanim, ano? Dahil nagastos mo na, but nonetheless, that can be a valid sale because that is a sale of a future thing and which thing has the potential of existence. Kaya kung may tanong, what if ang promise niya is yung to sell, this is a sale of palay that will be harvested from a specific rice field. On that harvest season, walang na-harvest ang seller. Does that mean that the sale is void? The answer is no. The fact that there was nothing harvested goes only into the performance of the obligation. So he would not be able to deliver. Okay? But automatically liable siya for damages? Hindi rin, okay? Not necessarily, because the reason why he was not able to harvest, maybe due to a fortuitous event. Imalay natin ang baha ala Peping hanggang rooftop ng SM Rosales. Siyempre, mamamatay naman ang mga palay na yan. O kaya pestilence. There are instances na even in the Pampanga area, di ba, may yung iba, rats, na malalaking rats, kinakain talaga. Okay? Kaya ang mga taga-Pampanga, minsan kumakain na rin ng mga rats. Okay? Have you seen this feature? Kinakain nila rats. Okay? Pero may mga rats pala na agricultural. Yun daw parang pwedeng kainin. I-try nyo lang. Okay? Ako hindi na. Kasi maski palaka, hindi kaya ng sikmura ko eh. I once went to Clark. Okay? May restaurant doon nagsiserve ng palaka. Magandang pagkakaluto ha. Pero sabi ko mukhang okay ito, mukhang masarap. Mukhang masarap. After mga 30 minutes, naku, lumalabas na sila ng kusa. Okay? Mula sa bibig ko. Okay? Ayaw talaga, maski ako gusto. Now, thus, M-Sure is therapy. Okay? Now, in relation to this sale, who may fix the price? If the parties agreed that a third person would be the one to fix the price, may the sale be a void sale? The answer is yes. But ang isang common na sagot dyan, the sale would be void if the third person acted in bad faith, which is wrong. Okay? Because if the third person acted in bad faith, he either pegged the price at a very high price or a very low price. Okay? The court would have the power to fix such price. Kaya hindi void ang sale. Okay? However, yes, the sale may be void if the third person refuses or is unable to fix the price. Because there will be no price. Di ba? Siguro sabi ng third person, why would I be the one to fix the price? Okay? Pakialam ko sa inyo. Okay? Kaya walang price. O kaya, ang third person nasa Makati Medical Center pala, comatose. Kaya hindi talaga ma-fix ang price. Okay? Maghintay ka ng 25 years. Okay? Diba? Meron minsan ganun katagal. After more than 25 years, biglang nagising. Okay? Ang comatose. Kaya in a way, parang tama din yun na minsan mahirap mag-decide. Okay? Pag comatose ba, ay wala. Tanggalan na natin ng mga nagsusupport, life support systems. Okay? Now, a very difficult decision at least. Okay? Now, but if the parties agreed that one of them will be the one to fix the price, may the sale be perfected? Yes. If that party did fix the price and the other party agreed to the price fixed, it's not that he fixed the price. Kailangan pa rin ng agreement ng kabila. Okay? And it is only at that time that the contract will be perfected. Okay? Now, into last two topics in relation to this, into the price. Okay? Listen, the rule in contracts as far as listen is the same as sale. The rule is gross inadequacy of the price does not affect the validity of this contract. Okay? Kaya lang in a way, mas detailed ang provision on sales because the law provides that however, the fact that the price is grossly inadequate may actually reflect vitiation of consent or that the parties intended another contract. Di ba? Take note, if the price is grossly inadequate, it doesn't mean that there is vitiation of consent. It doesn't even result in a presumption. In other words, whoever would claim na may vitiation of consent, he has the burden of proving that there was such vitiation of consent. Kasi naman, kung 100,000 ang value, binenta mo lang at 5,000, baka naman talagang girlfriend mo o boyfriend mo ang binentahan mo. Di ba? Kaya pwedeng ganun ka mura. Okay? Now, but, of course, there are instances when listen or gross inadequacy may actually affect the validity of the sale. Okay? And ang sagot dyan, nasa rescissible contracts, if you still remember. Okay? Like if the guardian enters into a contract of sale under 1381, hindi to 1491. Under 1381, in a contract of sale entered into by a guardian involving a property of the ward, where the ward suffers lesion of more than 1/4 of the value of the property, that would result in a defective contract. The contract is rescissible. Okay? So, consider those exceptions to the rule that gross inadequacy of the price does not affect the validity of this contract. I would tell this story every time because totoo naman talaga ito, okay? I once bought a car, okay? In the deed of sale, ang nakalagay doon sa, ang value ng kotse at the time of the sale was about 350,000 pesos, okay? Brand new pa ito kasi ang mileage wala pang mga 10,000 kilometers pa lang, okay? But it was sold to me, ang price 1 peso. And I used the car for about 9 years pa, 8 years at least, okay? Sana maulit muli, diba? Hindi ganun, hindi palagi nangyayari yan eh. Pero I hope it will happen again. But I will tell you, if the price is grossly inadequate, okay? Ordinarily, there would be another cost in relation to that contract, okay? Dito, ang cost allegedly dito parang remuneratory. Having served the company for a certain period and apparently they were satisfied with the service that I rendered, they sold to me the car for 1 peso. Okay? In a contract of lease, maya-maya or bukas next meeting, okay? I will tell you, ang Trinoma, the consortium of 7 corporations would lease the hectares of land only for 1 peso annually. And I will tell you the reason pagdating sa lease. Bakit piso lang ang rental? But no one would dare question the validity of this lease. Okay? That is consistent with the general rule that lesion or gross inadequacy of the price as a rule does not affect the validity of the contract. Finally, if the motive in entering into this contract, which is common again, is illegal, would that affect the validity of the sale? In one exam sa CPA board exam, this person bought a gun. Ang purpose niya is to use the gun to kill another person. And he did kill the person. Anong status ng sale? The answer is, it will not affect the validity of the sale. As a rule, the illegality of the motive does not affect the validity of the contract, and that is true in sales. Okay? The reason why, as a rule, it does not affect, because the law provides motive is different from the cause. Pero pag ang cause ang illegal, ay void. Pero ang motive, it's not the same as the cause. Ang motive is the personal reason. Okay? Kung bakit ako bumili ng kotse kasi i-convert ko into a taxi cab, di ba? Yun ang motive. But in sale, ang cost ng seller is ng buyer is the promise of the seller to deliver and transfer ownership. That's the cost. Okay? Now, but by way of exception, the court would tell us if the motive, which is illegal, predominates the purpose of the contract, that would affect the validity of the contract. I would say a classic example here is in a rescissible contract where the seller sold his property to defraud his creditor. Okay? So if all the requirements of the law as far as rescissible contracts are concerned in relation to contracts in front of creditors are present, then the contract would be a defective contract. Again, this is a rescissible contract, okay? Because the illegal motive predominates the purpose of the contract, okay? Now, thus, we can proceed to this one, ang tanong, okay? Can future inheritance be the subject of a contract of sale, okay? With this question, sabi nga nila ng mga so-called experts in 8 mga questions, okay? A good MCQ, with a good MCQ, you should already know the answer even before you check on the options. In other words, pagtingin mo sa options, dahil hahanapin mo na lang which is the correct answer. Okay? So reading this question, can future inherit be the subject of a contract of sale? The answer readily is no. Because the law expressly so provides for that. Okay? This is, I believe, 1347, if I'm not mistaken. Ang problema mo lang dito ay dadalawang no. Di ba? May no sa letter A, may no sa letter C. In other words, para hindi sayang ang oras nyo, huwag nyo nang basahin ang mga yes. Dahil mali na yon, di ba? Sayang ang oras nyo. Although itong yes, since the death of the decedent is certain to occur, ano ngayon, di ba? What has that got to do with whether future inheritance can be the subject? Or, yes, but the condition that the amount can only be ascertained after the obligations have been paid, which is the law on the matter, okay? Yung heirs can only sell or assign what they inherited, okay? But ito future inheritance, meaning the person whose succession is to be considered is still alive, buhay na buhay pa, okay? Letter A, no, since it will put the predecessor at the risk of harm from attempted buyer contrary to public policy. In other words, because you sold the object of the future inheritance, it may tempt one of the parties to kill, okay? Parang yung buyer, para naman makuha ko na yung binenta sa akin, okay? Hindi naman siguro, okay? But I would agree with Dean Pineda that the better answer is no, since the seller owns no inheritance while his predecessor lives. This is consistent with 777, okay? Successional rights will be transmitted only upon death. Kaya before that, wala kang karapatang magbenta. You have only an inchoate right, which may not even arise at all. Okay? Kaya common ito, even kanina ba, I was listening to a program, okay? Ang common na tinatanong ay, Sir, can I stop my parents from selling their properties because that would affect my legitimes? Maling-mali ka, bata ka. Kaya yung legitime mo to be computed only upon death. Eh kung during their lifetime, pinagbibenta nila, ay wala ka nang mamanahin. In other words, during their lifetime, they have the right to dispose of their properties by onerous title. Okay? Pero kung donation, pwede ang collation dyan. You may still inherit. Okay? Baka ang donation ay in officious, okay? Nag-impair ng legitime mo. Pero kung benta, ibig lang nilang sabihin, ayaw kanilang pamanahin, okay? At gusto nila magliwaliw sa Europe, okay? At ang kanilang naibenta, gagastusin nila. That they can do, okay? Kaya, this would appear to be the best. I would say this is the best. Ang isang lesson sa nitong MCQ, you may be able to answer the question correctly only if you know the reason for the law. Okay? Minsan alam mo ang batas pero hindi mo alam ang rason, nandun ang distinction sa MCQs. Kaya parang pare-pareho pero ang reason, ito talaga ang tama. Ang aking reservations lang dito, because of the possible interpretation na owns no inheritance while his parents are alive, there may be just a misconception that if the seller doesn't own the thing, the sale would be void. Which is wrong, okay? As we will discuss in a while, pagdating sa rights and obligations of the parties, okay? Now, last year, which phrase most accurately completes the statement? If at the time the contract of sale is perfected, the thing which is the object of the contract has been entirely lost, okay? It is at the time or before, okay? Has been entirely lost, the buyer bears the risk of loss, or the contract shall be without any effect, or the seller bears the risk of loss, or the buyer may withdraw from the contract. Una, because the object of the has been entirely lost, before the perfection or the time perfection, anong status ng contract? It is void. It is inexistent because one of the requisites is lacking. Okay? Because the contract is void, who will bear the loss? Tama ba ito that the buyer bears the loss? Definitely no. There can only be a transfer of ownership as a consequence of a sale if the sale is valid. How can there be a transfer of ownership if the sale is void? Di ba? There would be no basis for the transfer of ownership. Thus, letter A is really wrong. Okay? That the buyer bears the risk of loss. Pangalawa, letter D, the buyer may withdraw. There is nothing to be withdrawn because the contract is void. Kaya mali din ang letter D. Kaya, alin na lang natitira? B and C. Letter C appears to be the correct answer, but that is not really the correct answer. Okay? The seller bears the risk of loss is not really accurate, okay? Because the seller may not be the owner of the thing, okay? Pag sinabi mong seller bears the loss, mali. Ang ating batas, owner bears the loss, hindi seller bears the loss, okay? Kaya, ang tamang sagot, the contract shall be without any effect kasi nga void. One of the requisites is lacking, di ba? Maganda ang MCQ na ito, okay? Now, we go into, tapos na tayo sa essential elements, okay? In a contract, not necessarily a sale, if all the essential elements are present, necessarily the contract is already perfected? The answer is no, okay? Baka ang contract ay real contract. So it would require the delivery for the contract to be perfected. But, sale, knowing that it is a consensual contract, as long as the three essential requisites are present, then the sale may be a valid sale. Di ba? Kaya, ang question lang dito, as to when the sale is perfected upon the mere meeting of the minds, but is this applicable in a sale of right? The answer is yes. Under a certain specific provision, in a sale of right, the law provides that Article 1475 shall apply. In Article 1475, involving a sale of a thing, it is perfected upon the mere meeting of the minds as to the thing and the price. I would always insist, kumpletohin nyo ang sagot. Hindi lang ito mere meeting of the minds. Mere meeting of the minds na manunod kayo ng sine, di ba? It's a meeting of the minds as to the thing and the price for a sale to be perfected. Okay? Now, pero, if there would be problems in relation to perfection, okay, or related to perfection, especially involving a sale, this may pertain to a stage before perfection, okay? Almost all, if not all authors would consider three stages, di ba? The negotiation, perfection, and consummation stage. In the negotiation stage, may there be a perfected contract? The answer is yes. Okay? Ang tawag sa kontrata nito ay option contract. In other words, if there is an offer to sell or offer to buy, but the offeree is not yet in a position to decide, okay, whether to buy or to sell for whatever reason. Maraming rason, di ba? Wala pa siyang pera, hindi pa siya sigurado kung ito o ito ang kanyang bibilhin, okay? One of them, either the offeree or the offerer, okay? Hindi offeror, okay? Ang offeror sa simbahan, maya-maya lang, okay? Pumunta tayo sa simbahan, mag-offer kayo, offeror ang tawag sa inyo, okay? Sa mga ganitong agreement dito sa offer to sell, offerer, okay? So if one of the parties may, either the offerer may tell the offeree, I will give you 2 years within which to decide, o di ba? Or the offeree may tell the offerer, can you at least give me 30 days within which to decide? And the other party said yes. Anong tawag doon sa agreement nila? At this point, you should call that merely as an option agreement. Do not call that an option contract because there appears to be no consideration, which is something paid or promised, separate and distinct from the price. Okay? So kung ang price usapan nila doon sa lupa ay 1 million, ang consideration na ito should be separate and distinct. Okay? Pero as the Supreme Court would tell us, okay, ang misconception sa consideration ay pera. Like ang tawag natin option money, not necessarily. The consideration may be any prestation which is something paid or promised. Kung sinabi ng offeree, give me 30 days, and within that period of 30 days, I will clean your car every day. That can be a sufficient consideration, separate and distinct from the price. Okay? Pag mayroong ganung consideration, then you can call their agreement as a contract. So, contract of option. Why make this distinction is because under the law, if there is no such consideration, meaning option agreement lang, okay, the offerer can withdraw the offer at any time before acceptance is conveyed to him. Conveyed, hindi sent, okay? Because Philippine law, the Civil Code of the Philippines follows the cognition theory now. Hindi na ito manifestation theory. In other words, pwedeng lalo na before hindi pa uso ang mga email o mga text, okay? Ang acceptance, the offer may have been sent through a letter. At ang letter dati, mga 3 buwan bago dumating, di ba? So, ang acceptance may have been made immediately after receipt. Pero, it was received 3 months after, okay? Kailan ang perfection? Upon sending o upon receipt of the acceptance? Upon notice of the acceptance, okay? Kaya in the meantime, withdraw na niya, bago niya na-receive, wala na. There's no more contract which can be perfected. Or, namatay ang offerer before na-receive ng kanyang asawa siguro. Had there been a perfected contract, wala na. Under the cognition theory as distinguished from the manifestation theory. Okay? Kaya, as long as the offerer had not yet received the acceptance or he had no knowledge of the acceptance yet, he can withdraw the offer at any time and he cannot be held liable for damages because he is not bound to this contract. Okay? Wala namang consideration. Pero pag kontrata ito and he would withdraw, he can be held liable for breach of contract because this is an option contract. Okay? Not because of the sale, there is no perfected sale yet, but because of the perfected option contract or contract of option. Okay? Now, in relation to a sale, okay, una, what if during the period agreed upon, the contract was perfected, natuloy ang kontrata, binili ng buyer, okay? And as consideration, doon sa option agreement or option contract, he gave 50,000, okay? Would the 50,000 now be considered as part of the price? Can the buyer buy? You can call them buyer-seller already kasi perfected na ang sale, okay? Can the buyer now claim that the 50,000 should be deducted from the price? Ordinarily, the answer is no. Kasi nga, separate and distinct ito from the price, but there is an exception to this. If it was so clear in their agreement that if the sale thereafter is perfected, this amount will be treated as part of the price, then so be it. Without such stipulation, it cannot be considered as part of the price. Okay? Now, one last point is, what if there was earnest money given? Okay? Ang earnest money by definition is part of the price. When there is an earnest money given, does that mean that there is already a perfected sale always? The answer is definitely no. Okay? Although ordinarily, parang mayroon na. Okay? Kasi why would anyone part a sum of money na wala pang perfected? Yung iba nga perfected na, ayaw pa magbayad eh. Di ba? But, I said not necessarily because, okay? The law provides that earnest money is just a proof of the perfection of the sale. And just because there is a proof doesn't mean that there is a perfected sale. As I would say, just because there is a proof of murder in a murder case, like the thumb marks ng accused were found in the glasses, found in the scene of the crime. Does that mean that he committed the crime? Not necessarily. May proof nga, but it may not be sufficient to conclude that in fact the fact that he killed happened. Okay? Now, ganun din sa sale. But ang tanong therefore is, how could there be no perfected sale? May earnest money na. Well, sa bar exam last year, the 2011, okay? Kaya walang perfected sale, even if there was earnest money, is because they were not able to agree on the object of the sale. Take note, ang option money pertains only to the price. Wala pa pala sila agreement in the par exam question. Itong seller, the parties entered into contract of sale involving a parcel of land. But it turned out that the seller has 5 parcels of land, and they could not agree as to which parcel of land was the object of the sale. Maski may earnest money pa na 1 million dyan, if there was no agreement as to the object, the sale would be void. Okay? Baka akala ng buyer ang binili niya na lupa doon sa loob ng Ayala Alabang, di ba? Yung pala nasa tabi lang ng Ayala Alabang, doon sa likod ng bakod. Okay? Kaya there was no meeting of the minds as to the object. But even if there was a meeting of the minds as to the object and there was earnest money, baka wala naman silang meeting of the minds as to the total contract price. Yung earnest money is just part of the price. Okay? Kaya kung hindi sila nagkasundo sa total contract price kasi gusto ng seller 1 million, gusto ng buyer 650,000, and wala na, hindi na nagkasundo. Although such money, 50,000, was given and understood by the parties to be considered as part of the price, walang perfected sale. Okay? Now, then, into this. Okay? This is a classic question, okay, sa bar exam na sa hinapahaba ng facts, ang tanong, explain the nature of an option contract. In other words, walang saysay ang facts. Okay? You can answer the question by just without reading the facts. Kaya nga I am very serious about my recommendation sa inyo na lalo na kung mahaba ang facts, basahin niyo muna ang tanong. Okay? Ano ba ang gustong tanong? Anong isasagot? Because only then would you know which facts are relevant, which are not relevant. Di ba? As in this case, yung pala, explain the nature lang pala. Okay? So, ito yun. What is the effect of an option contract? Okay? Both the offerer and the offeree are bound to enter into a contract kasi may option contract. Or, the offerer is bound to enter into a contract with the offeree whether or not the offeree gave a consideration separate and distinct from the price. Or the offerer is not bound to enter into a contract even if he gave a consideration separate and distinct from the price. And finally, neither the offerer nor the offerer is bound to enter the contract, which is really wrong. Bakit pa nagkaroon ng kontrata, option contract, if no one would be bound? Bound sila sa option contract, but as to whether, for example, bound to enter into another contract, that's another matter. Because in an option contract, ang bound lang dyan is the offerer. Okay? Yung offeree, even if he gave a consideration separate and distinct from the price, he is not bound to enter into the contract of sale. He may not enter into that contract. Karapatan niya yon kung itutuloy niya or hindi. Yun lang ang common consequence if he will not proceed with the purchase, forfeit ang kanyang option money. Okay? Kung nagbigay siya ng option money. Okay? Rare yan na isosoli nung offerer ang kanyang option money. Okay? Now, thus, into the form of this contract, briefly, ito na lang ang last topic. Is there a law requiring a particular form for this contract, for the validity of the contract under the civil code? Wala. Okay? But in a special law, there is. Okay? In a sale of large cattle, under the cattle registration decree, the sale has to be in a public instrument. Not only that, it has to be registered. Moreover, the buyer has to obtain a certificate of title in order for the sale to be valid. So I would say that sale is a formal contract. But under the civil code, walang formal contract na sale. Okay? Now, but is there a law requiring a particular form for this contract for its enforceability? Okay? The answer is very much yes. Okay? And this time, that is the statute of frauds. Okay? In 3 scenarios. the sale must be in writing, otherwise it will be unenforceable under the statute of frauds. Okay? But also, the law may require a particular form for the greater efficacy of this contract. If you remember 1358, the law provides the following acts and contracts must be in a public instrument. A sale would involve conveyance of an immovable property, for example, like a parcel of land. It has to be in a public instrument, but under 1358, that requirement is only for the greater efficacy of the contract. Because if it is not in a public instrument, do you think you can have the contract registered? Hindi. Sabi nga ng Supreme Court, the Register of Deeds doesn't have any business accepting a private instrument for registration. Okay? Kaya, a particular form is required para mo marehistro. Pag narehistro mo na, yun nga lang ang misconception. Pag public instrument na, it will always bind third persons. Hindi totoo yan. Okay? It is the registration which binds third person. That is constructive notice to everyone. Okay? Ninotaryo mo nga, tinago mo lang naman sa baul. Okay? So who will be bound? Kayo lang ng parties. Okay? Generally. And those who have actual knowledge of such contract. So, sa sale, kailan magiging unenforceable? Tatlong scenarios I said. One, sale of an immovable. As I said, lupa yan. Okay? Sa bar exams. Pero ang argument nyo, hindi dapat. It is unenforceable because the statute of frauds provide that a sale of land must be in writing. Walang ganung nakalagay sa statute of frauds. It's not a sale of land. It's a sale of an immovable. And however, land is immovable. Therefore, the contract, if not in writing, would be unenforceable. Huwag mong i-attribute sa batas yung hindi sinasabi ng batas. Okay? Pag sinabi mong expressly provided, hindi naman. Okay? Jurisprudence lang naman. Mali ka na. The examiner would know na nambobola lang ito. Okay? Sinabi mo, under the civil code, wala naman sa civil code. Di ba? Kung hindi ka sigurado, sabihin mo na lang, the law provides. Okay? Kasi pati ang decision ng Supreme Court would form part of the law of the land. Okay? So medyo safe ka doon. Okay? Now, immovables. The price of in that sale, is it relevant? Irrelevant. Maski 350 pesos lang ang price, if it involves an immovable property and not in writing, unenforceable. Pangalawa, sale of movables. This time, sa movables like cars or dogs or bags, okay? Ang relevant ay price, hindi ang value of the thing. Remember, you can sell a thing at a price much lower than its value. Kaya ang value niya, 3,000, pwedeng 3 million nga eh. Di ba? May bag na Herpes. Hindi pala, Hermes. Dati kasi, before nagkauso-uso itong bag na ito na Hermes, ang alam ko lang Herpes. Okay? Yung pala may Hermes. Okay? Na 3 million, 4 million, isang bag. Okay? Ewan ko bakit nagkakaroon ng mga ganon. Kailangan ng bag na million-million ang presyo. Ano? Samantalang million-million ang walang makain sa mundong ito. Joke lang, okay? Because baka meron kayo nun. Some people deserve that. Pinaghirapan nila yon, di ba? Pag nakakita sila ng Hermes nila, may nawawala ang kanilang mga problema sa buhay. Kaya okay na rin sa akin yan. Sige, mag-Hermes ka, okay? 3 million. But it's not the value which is relevant under the statute of frauds. It is the price. Ang value man 3 million, binenta lang 300, it will not be covered by the statute of frauds because it involves a movable and the price is not at least 500. Okay? Dapat 500 or more to be covered by the statute of frauds. But finally, sale of a bag, ang price 350. May that be covered still sa statute of frauds? The answer is yes. If under the terms of the agreement, it is not to be performed within 1 year. Kasi nga, kung ang usapan nila, the bag will be delivered 2 years from the signing of the contract, from the agreement, verbal agreement of the parties, and the payment will be made upon the delivery. That requires the agreement to be in writing. Okay? ang reason dito nasa first paragraph. Kasi the reason behind is pag more than 1 year na, even honest men would commit mistake. Nagkakalimutan, di ba? Kaya it has to be in writing, okay? Now, I think just examples. Ito lang ay the payment delivered to be made 2 years. Kaya unenforceable it being oral contract because under the terms of the agreement, it is not to be performed within 1 year. Pero sa bar exam, ito yon, okay? X came across advertisement in the Manila Daily Bulletin about the rush sale of 3 is likely used Toyota cars, okay? Thus, alam mo movable, okay? Model 1989, only 200,000. Above, this is more than 500. Finding the price to be very cheap, and in order to be sure that it gets 1 unit ahead, X immediately phoned. Pag phoned, syempre oral, okay? Now, Y placed an order for one, Y accepted the order and promised to deliver the ordered unit July 15. On the said date, however, Y did not deliver the unit. X brings an action to compel. Y, will such action prosper? Okay? The answer, yes, because there was a perfected sale already. Just because a contract is already perfected doesn't mean that an action for specific performance will prosper, because perfection is subject to the formalities. Okay? If you will read 1475, ang perfection ng contract of sale is subject to the statute of frauds and other laws, okay, which would require a particular form. Okay? Thus, mere perfection will not necessarily make a contract enforceable. Letter B, yes, because the object of the sale is only for, thus no particular form is required. Hindi naman totoo ito. Okay? Because if the price is 500 or more, it has to be in writing. Letter C, no, if there is a proper objection because the sale is not in a public instrument, is a common misconception. The statute of frauds does not require a contract to be in a public instrument. The statute of frauds merely requires that the contract be in writing. Pero, kung public instrument yan, syempre in writing yan. Pero even if not in a public instrument, if it is already in a private instrument, pwede na yan. That would comply with the requirement ng statute of frauds. Therefore, the answer is no if there's a proper objection because the sale is not in writing. Take note, ang tanong ay an action to compel performance. Okay? If the contract is unenforceable, it is valid but it cannot be enforced if there is a proper objection. In other words, proper objection, dapat mag-object ka bago pa mag-present ng evidence. Okay? Kasi kung mag-object ka at the end of the testimony, wala na. Nandun na sa record ang testimony which may have proven the existence of the contract. Pag immovable property, parang last na ito, hopefully, one other siguro. Verbal contract to sell his only parcel of land this time, lupa, okay? 20,000. B agreed to buy. B went to the bank, withdrew the necessary amount, returned to A for the consummation. A, however, had changed his mind, refused to go through with the sale. Is the agreement valid? Will an action by B against A for specific performance prosper? Sa essay type ng mga questions, okay? It is common, just like this, that there would not only be one question, but 2 or more questions, okay? At ang common defect ng mga sagot ay isa lang na tanong ang nasasagot. At ang premise ko, kung ako ang examiner, ay hindi mo alam ang sagot sa iba pang mga tanong. Kaya wala kang sagot. Pero pwedeng nakalimutan mo lang. In other words, every time you answer a question, go back to the problem. Baka may 2-3 tanong. Malay mo, alam mo din ang sagot. In other words, dito sa problem na ito, these 2 questions are totally different questions. Okay? Is the agreement valid? Is different from whether an action for specific performance will prosper, because an unenforceable contract is also a valid contract. Di ba? So is the agreement valid? This is a sale. As long as the 3 essential requisites are present and no one is prohibited from entering into this contract, then it can be a valid sale. Di ba? But will an action by the agreement prosper? The answer is it will not if it is valid, but the action will not prosper if there's a proper objection because the agreement is not in writing. Kung essay ito, do not stop at that, okay? Dapat you should further explain because the sale involves an immovable property, which is a parcel of land, okay? A parcel of land which is an immovable property. And under the statute of frauds, a sale of an immovable property has to be in writing. Since it is not in writing because it was merely by verbal agreement, then it is unenforceable. Di ba? Kumpletuhin nyo ang arguments. Okay? This one, ito yung doctrine of part performance. If there's already performance of the obligations arising from the contract, that will take the contract out of the operation of the statute of frauds. Okay? Ang sagot, because the contract was taken out of the operation of the statute of frauds. May mga bayad na, may delivery na, but ang misconception lang sa sale, sabi ng Supreme Court, that for the doctrine of part performance to apply, there should be either partial payment or partial delivery. Hindi totoo yan. Okay? As long as there is performance of obligations arising from this contract, which was orally entered into, then the contract would be taken out of the operation of the statute of frauds. Example, tunay na kaso, sale of a parcel of land. There was an agreement that the buyer will be the one to cost the survey of the land. Okay? Tapos, she would also have to pay the real property tax among others. At ginawa niya ito. Pinasurvey niya ang lupa, binayaran niya realty tax, etc. But, was there partial payment? None. Was there partial delivery? Wala din. But was the contract taken out of the operation of the statute of frauds? Yes. Under the doctrine of part performance, as long as there is performance of obligations arising from a verbal contract, that would take the contract out of the operation of the statute of frauds. Kaya, break na muna tayo. Kain muna tayo. Magandang hapon sa inyong lahat. We are now into the rights and obligations of the vendor, okay? Of course, I will be discussing only the rights and obligations imposed by law, okay? The parties may stipulate as to other obligations of the vendor. Now, of these obligations imposed by law, I would focus on these three obligations as the questions would really be under these obligations. The obligation to transfer ownership, the obligation to deliver, and the obligation to warrant the thing. Okay? Now, just 1 or 2 minutes as to the other obligations. Example, does the seller have an obligation to take care of the thing which is the object of the sale? The answer will depend first on whether the thing again is determinate or generic, okay? Because there will never be such an obligation if the thing is a generic thing, okay? But even if the thing is a determinate thing, there may not be an obligation to take care of such thing. For example, if the scenario is the thing was already in the possession of the vendee at the time of the perfection of the sale. If you remember, there will be a kind of delivery constructed in character known as judicio brevi mano. Okay? Of course, in a specific transaction known as a COD, cash on delivery, of course, there is no obligation also to take care of such thing. Okay? Now, so into the three, okay? As to the obligation to transfer ownership, if, for example, the snatcher, okay, who forcibly took necklace of a passenger of a jeep, sold the necklace to somebody, okay, will that be a valid sale? Second question, will the buyer acquire ownership over that necklace? Thus, this is a good question as far as I'm concerned. Okay, one of the good questions, if not one of the best. A very simple question: may a person sell something that does not belong to him? Now, again, the question is may. Pwede ba? May a person sell In a way, there are two aspects to this question, okay? The first aspect here goes into the validity of the sale. In other words, if the seller is not the owner of the thing sold, will the sale be valid? May it be a valid sale? The answer is yes, okay? Because the law does not require the seller to be the absolute owner. Unlike in mortgage and in pledge, okay, where the law expressly requires the mortgagor to be the absolute owner. In fact, there are many contracts of sale where the sellers are the owner, like sale by a sheriff, sale by an agent, sale by executors, administrators, receivers. In all these contracts, the sellers are not the owner, but nonetheless, that will not affect the validity of the contract, okay? But the second aspect to this question, probably the more important aspect, is if the seller is not the owner of the thing sold, may the buyer acquire ownership? Because the question is only may, the answer is again yes, okay? When would the buyer acquire ownership even if the seller is not the owner? The first answer should be if the seller has the right to sell. The seller may not be the owner, but he may have the right to sell. Therefore, he can cause the transfer of ownership to the buyer. Okay? But when would a person have the right to sell if he is not the owner? The reason basically is because he has the authority to sell. Who may have given him such authority? If he is the agent, it is the owner who gave him such authority. If he is the guardian or the executor, it is the law which gave him such authority. If he is the sheriff, it is the court which gave him such authority to sell the properties of the judgment debtor. Kaya, in these contracts, even if the seller is not the owner, the buyer may acquire ownership over the thing. Okay? Now, thus, into this question, yes, because the buyer will acquire ownership even if the seller is not the owner, or yes, because the buyer may acquire ownership even if the seller is not the owner, or no, because the seller must be the owner of the sale for the sale to be valid. Definitely not true. And letter D, no, because the buyer will not acquire ownership if the seller is not the owner. Also not true. Okay? Ang difference lang between A and B is the word will and the word may. Okay? As I told you, pag ang examiner ang tanong may lang, just follow the lead. Okay? Kung pwede naman, then your answer should be may. It will not necessarily be valid, but it may be valid. Okay? The answer is B. Now, but, sa par exams, the questions would not really pertain to a scenario where the seller has the authority to sell. Okay? In the bar exams, the question would pertain to a sale where the seller doesn't have the right to sell. So he is neither the owner nor does he have the authority. So, ang tanong pa rin, may the buyer acquire ownership? Okay? Or may the buyer acquire any right over the thing sold? So, ang general rule, okay, if the seller doesn't have the right to sell, seller has no right to sell, the rule is the buyer acquires no better title than what the seller had. Okay? The law did not say that the buyer will not acquire any right over the thing sold. The law provides that the buyer acquires no better title. In other words, whatever the seller had, whatever rights the seller had, those rights may be transferred to his buyer nung binenta niya yung bagay. Okay? Of course, if the seller is a thief, okay, anong rights over the thing may be acquired by the buyer? Pag dineliver niya sa buyer ang bagay, some would actually give us an answer, possession. Maybe this is the reason why parang there's something wrong. Yung mga magnanakaw, baka akala nila ay pwede na nilang ma-acquire ang possession, the right. Possession, as a matter of fact, is different from the right to possess. Okay? A person may be in possession, but he doesn't have the right to possess. Di ba? But if the seller is a thief, he doesn't have the right to possess, therefore he cannot transfer such right to the buyer. In other words, in that scenario, what will be transferred to the buyer? Wala. Okay? As I would say, kung meron mang matatransfer doon sa buyer na ninakaw ang binenta ay karma lang. Okay? Yan lang ang pwedeng mai-transfer. Okay? But, that is a general rule at wala dito din ang bar exam questions. The bar exam questions would fall under the exceptions. Okay? In other words, even if the seller doesn't have the right to sell, the buyer may acquire ownership under any of the exceptions. One of the first, and this is in 1205, in 1505, sorry. Under Article 1505, and this is in relation to 559, okay? Now, under 1505, Stoppel, okay? Maybe the reason why the buyer may acquire ownership even if the seller had no right to sell. Second, maybe this is a sale by an apparent owner to a buyer in good faith and for value. But there is a third requisite here, okay? In order for the buyer to acquire ownership. The last one is, this buyer purchased the thing at a merchant store or market or fair in good faith and for value, okay? Let's start with Stoppel, okay? Who would be stopped in order for the buyer to acquire ownership even if the seller doesn't have the right to sell? Ang pinakamadali ay the seller, okay? Sorry, the owner, okay? Under 1431, by his conduct or by his representation, he led the buyer to believe that the seller had the authority to sell. Even if he actually did not give authority to such seller, he will not later on be allowed to deny such authority of the seller to the prejudice of the buyer who relied on his conduct or representation. This is under 1431, which pertains to a Stoppel in pais, which is an equitable Stoppel. Okay? Hindi pa tinanong yan sa bar exam. But ang tinanong na related somehow is the other kind of Stoppel, which relevant dito. Okay? One half of a parcel of land belonging to A and B was sold by X to Y for the amount of 1,500. The sale was executed verbally. 1 year later, A and B sold the entire land to X. Is the sale executed verbally between X and Y valid and binding? Okay? Take note that this pertains to a parcel of land. This is a verbal sale. But it appears that at the time of the sale, between X and Y, X doesn't have the right to sell. He was not the owner, nor does he appear to have the authority to sell. Okay? But a year after, he acquired ownership over the land because A and B sold the entire land to X. But the question does not pertain to the second sale. The question pertains to the first sale between X and Y. So, is the sale executed verbally by X to Y valid and binding? Ito ang possible options. Yes, because it is a perfected contract of sale. Again, a very important defect in this option is ang question executed verbally, valid and binding. Okay? Perfection of a sale does not necessarily make the sale enforceable because of the possibility that it is covered by the statute of frauds. Okay? Pangalawa, because there was payment already. This actually is one of the suggested alternative answers in the UP Law Center suggested answers. Okay? that yes, it is a binding contract because there was payment. But read the facts. Was there payment? Mukhang wala. Okay, so if only for that, I cannot agree to that answer. Okay. The third one, no, because it is void, as it is not in a public instrument, again, is one of the most common misconception that if the sale, if the contract of sale involving a parcel of land is not in a public instrument, void daw, maling-mali. Okay? In fact, even if it is only in a private instrument, it is already binding between the parties. It will only be unenforceable, not void, if it is not in writing, pag verbal lang. Okay? Thus, I would consider the answer to be letter D, no, because it is unenforceable under the statute of frauds, this being a sale of an immovable property and the sale is not in writing. There is this alternative answer related to the topic that the seller here will be stopped, okay, from claiming that the contract is unenforceable. Under Article 1434, this is a stoppel by deed, which is a technical stoppel, because in this article, if the seller at the time of the sale has no right to sell, he is neither the owner nor does he have the authority to sell. Now, but nonetheless, after the sale, he acquired ownership by whatever title, just like in the problem, binili niya. Or pwede rin dinonate sa kanya, pwedeng dinasyon sa kanya, binarter sa kanya, but yun nga, the buyer thereafter, after the sale, acquired ownership by whatever title. By law, ownership is deemed to automatically pass to his buyer. In other words, the seller will not be allowed to claim that when I sold it to you, I don't have the right to sell, and therefore you will not acquire ownership over this land under the principle of stoppel. But is Article 1434 applicable to this scenario? I dare to say hindi. Because one very important requirement for 1434 to apply, in other words, for the buyer to acquire ownership because of the principle of stoppel, is that the thing must have been delivered already to the buyer. And under the facts, had there been delivery, wala akong makita. Until then, the statute of frauds would apply, okay? That this contract would be unenforceable, okay? Now, but the most favorite of all these exceptions sa bar exam is number 2, the second exception. Sale by an apparent owner to a buyer in good faith and for value. In fairness to the examiners, okay? The bar exam questions would only involve a parcel of land. Wala nang iba. Okay? Because tama naman yun, in real life, wala namang ganitong problema kung mangga lang ang binenta. Okay? Or bag lang ang binenta. Di ba? Thus, this would involve a parcel of land. We should have no problem with a buyer in good faith and for value. In other words, this buyer had no knowledge of the defect of the title of the seller, that the seller pala doesn't have the right to sell. Okay? Nonetheless, the seller is an apparent owner. Okay? So this is a sale by an apparent owner. Ang tanong ay, when would the seller in a sale involving a parcel of land be an apparent owner? If he is in possession of the land, does it make him an apparent owner? I would not also think so. Kasi ang mga squatter, or should I call them informal settlers, okay, are also in possession but they are not apparent owners. In bar exam, sa mga bar exam questions, they would be apparent owners because the land is registered in their name. Okay? Yun nga lang, paano naging narehistro sa kanila if they don't have any right over the thing? Maraming paraan. Okay? Maraming paraan, pero ordinarily, this would involve forgeries. Okay? Pwede may breach of trust, most common may breach of trust, pero pwede rin wala. I'll show you yung two scenarios. Yung isa walang breach of trust, yung isa mayroon. In fact, I do not intend to discuss with you the law on trust. Kasi wala naman sa outline eh. Okay? Di naman kasama. And for the past 2 years, wala talagang tanong. 2011 and 2012. Okay? Now, ito na muna. Rod, the owner of an FX taxi, found in his vehicle an envelope containing PCT number, okay, over a lot, meaning yung certificate of title ang nakita niya, okay, registered in Cesar's name. Posing as Cesar, Rod forged Cesar's signature a deed of sale in Rod's favor. Rod registered the said document with the Register of Deeds and obtained a new title in his name. After a year, he sold the lot to Don, a buyer in good faith and for value, who also registered the lot in his name. A. Did Rod acquire the title to the land? B. Discuss the rights of Don, if any, over the property. In this scenario, there is no breach of trust. Okay? Hindi naman pinagkatiwalaan ni Cesar si Rod. Naiwanan lang niya. Di ba? Nonetheless, there's a forgery. Okay? But did Rod acquire title to the land? And thereafter, what are the rights of Don, if any, over the property? Having registered the land in his name, binenta niya kay Don. Okay? Letter A, yes. Rod acquired title to the land because he was able to register the land in his name. Okay? Don acquired whatever title Rod had over the land. The first one, the first sentence is really wrong. Okay? Just because a person was able to register the property in his name doesn't mean that he acquired title. Okay? Na-register lang niya. Pero, he may not have acquired any title at all. Okay? Kasi nagawa niya through fraud. Okay? Now, but pangalawa, yes, Rod acquired title to the land because he sold the land to a buyer in good faith and for value. Ang tawag dito sa in philosophy, this is really in logic to be more specific. Ito yung non sequitur at the least. Okay? Just because he sold the land to a buyer in good faith doesn't mean that he acquired title, di ba? Nagkataon lang na naibenta niya to a buyer in good faith, but it doesn't mean that he acquired title. Hindi naging effect ng sale ang acquisition ng title. In the first place, did he acquire title even before the sale? Okay? Kaya this is really wrong. Letter C, no, Rod did not acquire title because he did not pay Cesar. Thus, Don also did not acquire any title to the land. Both sentences really are not accurate. Okay? Statements of the law. Okay? Did not acquire title because he did not pay. A person may acquire title over a land without paying. Dami-daming paraan. Pwede kang magmana. Pwede kang dahil sa dason in pago, etc. So, also in a sale, pag absolute sale, even without payment, the buyer would acquire title. Yun lang, may utang siya. Di ba? But ang second, also did not acquire title to the land. Well, there are exceptions to the rule. Even if the seller doesn't have the right to sell, the buyer may acquire title better than what the seller had. Translated, the buyer may acquire ownership even if the seller doesn't have the right to sell. Okay? But the correct answer is letter D. Rod did not acquire title because a forged deed cannot convey a valid title. Di ba? But can be the root of a valid title. Thus, Don acquired title as a buyer in good faith and for value from the apparent owner. Okay? Take note under the fact, she sold the Don to a buyer in good faith and for value. Malinaw na kaagad. Okay? Therefore, Don acquired title because he bought it from an apparent owner, nakarehistro kasi kay Rod, and he bought it in good faith and for value. I told you there is a third requirement for the buyer to acquire ownership. That is, there has to be a law which enables the seller to dispose the thing as if he is the true owner. And in this scenario, in relation to a parcel of land registered under the torrent system, is there such a law? The answer is yes. Now it is PD 1529, or the Property Registration Act. If you remember this doctrine, this is the doctrine, the mirror doctrine, that those dealing with a registered land only has to rely on the certificate of title. He doesn't have to go beyond the certificate, okay? But I have to warn you, this doctrine, the mirror doctrine, cannot be invoked by those who are required to exercise the highest degree of diligence, okay? Like yung mga lately, yung mga realty firms, they are already required by Supreme Court decision to exercise the highest degree of diligence. Just like banks, they cannot just rely on the certificate of title. They have to investigate. Like, they have to check if the one in possession is really the owner. Walang kamalay-malay ang may-ari, binibenta na ang lupa nila to a buyer who may be a buyer in good faith and for value. And the land may have been registered in their name. Okay? But hindi na pwede. But in this case, that is so applicable. Okay? Don't acquire the title as a buyer in good faith and for value from an apparent owner. Ang isang scenario where there is really a breach of trust, at most of the problems may breach of trust. Okay? Ito lang, as simple as this. A is the owner of a registered land. The torrent's title is entrusted to B. What is meant by the examiner that the torrent's title, it is the certificate of title. Okay? Again, may pagkasino-shortcut nila. Okay? Is entrusted to B, his clerk secretary, who forged a signature on a deed of sale of said land in B's favor. A new title is issued in the name of B upon registration. Does B have a valid title over the land? If B sells the property to C, does the latter acquire a valid title over it? I have to emphasize that the land will not be registered in the name of the forger by virtue of the fact solely that there is a deed of sale which is a forgery. But there is one other requirement, okay? That the owner's copy of the certificate of title is surrendered to the Register of Deeds. Pag hindi yun isinurrender, ay the Register of Deeds will not cancel the owner's certificate of title and it will not issue a new one, okay? Eh baka nandun lang umiikot ang owner's copy, okay? Baka nga naman forgery. In a way, dalawa ang protection dito. Una, kung sale ito to be registered, it has to be in a public instrument. It has to be notarized. Kung forgery lang ito, paano na notaryo? Okay? Ibig sabihin, may nagpabaya. And that would be the notary public. Okay? Kasi the person is supposed to appear before him, pero wala. Maraming mga notaryo publiko, hala, basta may 150 na pambayad, notaryo lang ng notaryo. Okay? They couldn't care less if the parties themselves would appear before them. Pero yun ang basis ng Register of Deeds, okay? That there is regularity in the performance of the functions. Kaya ang seller, apparently talagang pumirma. Forgery lang. But pangalawa, yung owner's copy, it had to be surrendered. Paano napunta sa forger kung wala siyang karapatan? Kaya alam, may mga ganitong scenario. It was delivered to him only for safekeeping. Okay? And so when he forged the signature and had the land registered in his name, clearly there was a breach of trust, okay, in that scenario. Thus, to answer these questions, does B have a valid title? As a forger, he will not acquire at all a valid title. But if B sells the property to C, does the latter acquire a valid title? He may acquire a valid title if he is a buyer in good faith and for value because he bought the land from an apparent owner, and there is a law which enables the seller to dispose the thing as if he is the true owner. Okay? Again, the answer here is no, because the forger acquires no title, but his buyer may acquire owner title if he is a buyer in good faith and for value. Okay? Now, but the last one, exception. If number 2 exception is the most favorite, susunod ito. The last one, third ito, Stoppel. Purchase at a merchant store. Okay? If a thing was sold in a merchant store, ang premise ng exception na ito is the owner of the merchant store doesn't have the right to sell. Di ba? Kaya lang, paano na ibenta sa tindahan? Walang karapatan ang tindahan na magbenta. Maraming rason. Okay? Maybe the owner of the store bought it from a thief sa isang magnanakaw, o baka ang may-ari ng tindahan siya mismo ang magnanakaw. Okay? Pero parang ibang negosyo na yon, di ba? Sa kanila na yon, hindi na niya negosyo yon. Ang negosyo lang niya ay magbenta ng mga ninakaw. Okay? Which can happen every now and then. Okay? I would remember when I had this car, a white car. Okay? Kaya siguro hindi na ako bumibili ng kotse na puti. Okay? Because with that car, I think 3 times ako ninakawan ng mga side mirrors, ng mga fenders. Ninanakaw talaga. And because wala ka ng side mirrors, you have to go to usually sa Banawe, di ba? To buy yung mga side mirrors. Okay? Now, in Banawe, maraming mag-o-offer sa'yo. Okay? But I would not normally buy yung brand new kasi ang kotse ko, ito yung binili ko for 1 peso. Okay? Mga 8 years old na, 6 years old, 7. Why would I buy a brand new? Di ma-obvious na aking kotse, luma. Okay? Kasi ang side mirrors, bagong-bago. So, ang binibili ko, yung mga second-hand din. Okay? But if somebody would offer to me a second-hand side mirror, parang ang feeling ko, ito ang ninakaw sa akin. O, di ba? Parang ganun ang feeling ko palagi. Kaya yung ibang mga may-ari, ay dinidikitan nila, nilalagyan nila ng epoxy. Kaya pag tinanggal ng mga magnanakaw, wala, hindi matatanggal. Sira, buo. Kaya lang mahal yun. Pag nasira, yung magnanakaw hindi magbe-benefit, pero ikaw, malaki din ang damage. Pero at least, hindi siya nag-benefit. Yun ang isip-isip siguro ng may-ari. At any rate, so, what if such thing was sold in a store? Okay? First question, will the owner have the right to recover the thing from the buyer in that store? Binili sa tindahan eh. Second question is, if the owner has the right to recover, is the buyer entitled to reimbursement? Kasi binili niya. Okay? Kung marirecover man na may-ari, at least ma-reimbursement lang siya. Okay? A good question. I'll start with the much easier to answer. Okay? Mahinhin lost her diamond ring when the bus she was riding on was held up by a band of brigands who divested the passengers of all their money and valuables. This is 1986. But if you remember a few months ago, a bus was held up dyan along EDSA, okay, sa katanghalian at noon, talagang tanghaling tapat. Okay? Bus, yung mga passengers, lahat talagang nilut. Ang funny thing dito ay, itong ABS-CBN, kung napanood nyo ang news na ito, parang they were into these investigations at nasundan nila ang bus. Okay? It turned out na parang may police na nakasunod doon sa bus. Okay? Naka-motorcycle yata. When the hold-uppers went down, okay? Nakuha nila ang gusto nila. It would appear na itong mga police, kakutsaba pa ng mga nang-hold up, di ba? It's so sad. The people are supposed to protect us, sila pa ang kasama doon sa pandarambong, okay? At any rate, this really is a real scenario, could be a very real scenario. The ring found its way to the Pasanglaan pawn shop, where one of the robbers had pawned it. The pawn shop in due time foreclosed the pledge and sold the ring at a public auction to Mayaman, the highest bidder. Okay? 3 years after the loss, Mahinhin, the owner, was able to trace the ring to Mayaman and demanded that the latter give the ring back to her. Mayaman refused, saying that he had acquired the ring in good faith. Who has a better right to the ring? Mahinhin, the owner, because she was unlawfully deprived the ring, but she must reimburse mayaman who bought it in a public sale in good faith. Or mahinhin, because the ring was lost, but as the owner, she is not required to reimburse mayaman. Or letter C, mayaman, because he is a purchaser in good faith, and D, mayaman, because he bought it in a public sale. The worst option is letter B. Una, as a matter of fact, it was not lost. It was stolen, hindi lang stolen. It was forcibly taken from her. Okay? Iba rin ang stolen, ninakaw lang. Di ba? Walang stress. Okay? Masyadong stress sa mga ninakawan. Pero pag hold up ito, nako, baka yung stress mo hanggang langit. Okay? Now, but as the owner, she is not required to reimburse. Also wrong. Okay? In this scenario, okay, ang applicable dito is Article 559 because the owner was unlawfully deprived of this movable. Okay? And when the dalawa ang scenario sa 559, either the owner was unlawfully deprived or the thing was lost. Okay? So even if such thing is sold in a store, katulad dito, in a public sale, okay, the owner has the right to recover. May karapatan siya. Yun lang, is he required to reimburse the buyer. The law further would tell us the buyer will only be entitled to reimbursement if the two conditions are met. Dalawa. Dapat mag-concur. One, he bought it in good faith, and second, he bought it in a public sale. One without the other, he is not entitled to reimbursement. The owner would have the right to recover the thing from him. Kaya clearly, the answer here is letter A. Mahinhin has the right to recover, but because she was unlawfully deprived, but she must reimburse mayaman who bought it in a public sale and in good faith. Always bear in mind that good faith is presumed. Okay? So unless the facts would give you a basis to conclude na bad faith, you should always presume good faith. Okay? Now, but ito medyo mahirap-hirap ng konti. Okay? Rita owned a valuable painting which was stolen from her house. The theft was duly reported to the authorities a year after Rita saw the painting hanging in the office of Mario. When queried, Mario said that he bought the painting in a gallery auction. Okay? The painting was positively identified as the one stolen from the house of Rita. Letter A, could Rita recover the painting? If so, would Mario be entitled to reimbursement of the amount he paid for the painting? Letter B, supposing Mario bought the painting from a friend instead of a gallery auction, would your answer be the same? To the first question, could Rita recover the painting? The answer is yes, because clearly from the facts, she was unlawfully deprived of such thing. Okay? Now, but would Mario be entitled to reimbursement of the amount he paid? Even if we consider him to be a buyer in good faith and for value as the law presumes him to be a buyer in good faith, a gallery auction, I would readily agree, is not a public sale. Ang mga gallery auctions are by invitation. Okay? Kayo ba ay naimbitahan na sa mga gallery auctions? Diba? Ako hindi pa. Okay? Kaya pag pumunta ang Christie's of New York sa Pilipinas para i-auction ang mga diamonds nila, by invitation yan. Wala akong ganong invitation na re-receive. Okay? Yung mga tawag sa kanilang iniimbitahan yung mga hoi polloi, yung nasa Tattlers, okay? Tama ba? Yung may magazine na Tattlers, okay? Sila lang iniimbitahan, okay? Thus, the answer is yes, because Rita was unlawfully deprived, but without the obligation to reimburse because he did not buy the thing in a public sale. Okay? Paminsan-minsan, there will be questions requiring common knowledge. Okay? Parang in-expect na ng batas na alam mo na dapat yan. Pero minsan hindi gaano ka-common. Okay? Pero ang tawag doon ay common knowledge. Okay? Now, pero lalo na kung ang tanong ay, supposing Mario bought the painting from a friend, obviously it cannot be a public sale, okay? And therefore, Mario will not be entitled to reimbursement. What had not been asked sa bar exam ay, what if the owner was not unlawfully deprived, nor was the thing lost, but the thing thereafter was sold in a store, in a merchant store, and the merchant store doesn't have the right to sell? What would be the effects as far as the buyer's rights are concerned? In other words, again, would the owner have the right to recover? Okay? And if he has the right, would the buyer be entitled to reimbursement? Okay? Ang tanong dito first is, how could the merchant store owner sell a thing which he doesn't have the right to sell, but the owner was neither unlawfully deprived nor was the thing lost? Diba? Madaling isipin, kaya naibenta sa tindahan kasi ninakaw, di ba? Ninakaw, ibinenta sa may-ari ng tindahan, binenta ng may-ari tindahan sa tindahan niya. Kaya how could it be sold if the owner was not unlawfully deprived? A good case here is the case of Sun Brothers versus Velasco. Okay? This is a very good case, a classic case in relation to these principles. Okay? Velasco here is in the business of selling brand new appliances. Okay? No, Sun Brothers. Okay? Now, Sun Brothers sold a refrigerator. So, napaka-importante ng pinag-aawayan nila dito. Refrigerator. Okay? Pero mind you, noong mga 1950s, ang refrigerator was a prized possession. Di ba? Parang sa buong town, ikaw lang may-ari ng refrigerator. Okay? Thus, it was sold to a certain Lopez, okay, in a conditional sale. So Lopez only paid a small amount, down payment, the balance payable in installment, okay? And the seller reserved ownership kasi nga conditional sale. Now, but and the refrigerator was delivered to Lopez. But the very next day, Lopez sold the same refrigerator to Velasco, okay? Clearly, did Lopez acquire ownership upon delivery? Siyempre wala, okay? Kasi nga, the seller retained ownership. And the condition for ownership to pass had not yet happened, was not yet fulfilled. Kinabukasan nga eh. So, nung binenta ito ni Lopez kay Velasco, do you think Velasco also acquired ownership or acquired ownership? Hindi rin. Because the general rule is applicable here. The buyer acquires no better title than what the seller had. None of the three exceptions is applicable, okay? But last na scenario is, si Velasco may tindahan. So, binenta niya. The next day ulit, mabilisan ang transaction dito, okay? Binenta ni Velasco, ang kita nila dito, mga 300 a day, di ba? Isang araw lang, kita ng 300. The next day, 300 ulit. Matagal na ito, okay? Malaki ang 300 at that time. Ang sweldo ng teachers ng baka 25 pesos a month, di ba? Velasco this time, the owner of the store, sold it to Kokang Chu, okay? And it was only after the delivery of the refrigerator to Kokang Chu that Sun Brothers became aware of these transactions. So, Sun Brothers filed an action against Kokang Chu for the recovery of the refrigerator. Okay? Did the action prosper? Hindi. Okay? Because first, 559 is not applicable. The owner was not unlawfully deprived. Dineliver niya ito as a consequence of a conditional sale. But neither was the thing lost. Hindi naman nawala ito eh. Therefore, 559 not being applicable, the Supreme Court, the Court applied 1505. And under 1505, the Court said, as long as the buyer bought it in good faith, as he bought it in a in a merchant store, the buyer acquired absolute ownership over the thing. Such that even if the owner is willing to reimburse the buyer cannot be compelled to return the thing to the owner. Okay? Again, under 1505. Okay? Now, thus, we would go into this, how transfer of ownership is effected. I already mentioned that it is by delivery, but if there was delivery, physical delivery of the thing to the buyer, does that mean that ownership already passed to the buyer? The answer is not necessarily. We have discussed already conditional sales and the special kind of conditional sale, which is a contract to sell. Okay? But this one, yung sale or return. In a sale or return, does ownership pass to the buyer? The answer is yes. Kaya hindi ito kapareho ng conditional sale. Ownership passes, but the buyer has the right to revest the title back to the seller. Ordinarily within a period agreed upon. Kung walang period, within a reasonable time. But another kind of sale wherein despite delivery, physical delivery, there is no transfer of ownership, is what is known as a sale on trial, also known under the law as sale on approval, or also called sale on satisfaction, or any name. Basta ganun ang implication. It has to be tried, it has to be tested, it has to be accepted before ownership may pass. Okay? So in this kind of sale, when would ownership pass? Okay? First, it would pass when the buyer signified his approval or acceptance to the seller. Take note, it's not a matter of the buyer deciding that he is accepting the thing. He must communicate his acceptance to the seller in order for ownership to pass. Okay? But also, even if he did not signify his approval to the seller, ownership may be deemed to have passed to him if there was a period agreed upon within which the buyer would have to decide whether he would accept or reject, and that period had already elapsed without the buyer manifesting his rejection nor his acceptance, and he continued to retain the goods. Okay? By law, he is deemed to have accepted the goods, and therefore ownership will be deemed to have passed to him by the mere lapse of such period. But, for example, 10 days ang usapan nila that the buyer would have for him to decide whether he would accept or reject. Before the lapse of the 10-year period, without the buyer manifesting to the seller his intent, his acceptance, may he be deemed to have accepted already? The answer is yes. If he did an act which is inconsistent with the ownership of the seller, ang sabi ng batas, by such act, he will be deemed to have adopted the transaction. Okay? Ano kayang ginawa ng buyer? Well, he may have sold the thing to another buyer. Okay? Or he may have altered the thing. Alteration is an act of ownership. Okay? Or he may have mortgaged the thing, or he may have donated the thing. Basta, he did an act inconsistent with the ownership of the seller. Although, ang isang maling sagot dito palagi ay when the buyer used the thing, which is really wrong. Okay? Because using a thing is not inconsistent with the ownership of the seller. In fact, because of the nature of that sale, which is a sale on approval, the buyer has to use the thing. If this is a car which has to be tested, alangan namang titigan lang niya ang kotse. Okay na ba ito? Medyo okay ba ang itsura? Naku, yung mga magagaling tumingin sa kotse, nalalaman nila yung defect by just listening to the engine habang tumatakbo. Pag medyo iba ang dating ng engine, naku, they will not recommend that you buy, di ba? So, again, the mere use is not inconsistent with the ownership. Ang lessee, gumagamit din. Pero is not claiming ownership. Okay? Now, that's why I will discuss this, because we will now go into topics where ownership as to who is the owner is very important. Okay? And these are yung risk of loss and double sale. Okay? So, let's start with risk of loss. In a way, doon sa subject matter kanina, I already presented to you yung effect if at the time of perfection or before that, the object of the sale had already been destroyed. Wala na. Okay? What would be the status? Would the sale still be perfected? It can never be perfected. And if it is never perfected, it will be the seller, if he is the owner, who will have to bear the loss, because ownership will not pass if the sale is a void sale. Okay? But ang scenario sa bar exam would normally deal with a situation where the sale had already been perfected. If the thing was lost after the perfection, who bears the loss? Okay? Example, D sold a second-hand car to E for 150,000. The agreement between D and E was that half of the purchase price, or 75,000, shall be paid upon delivery of the car to E, and the balance of 75,000 shall be paid in 5 equal monthly installments of 15,000 each. The car was delivered to E, and E paid the amount of 75,000 to D. Less than 1 month thereafter, the car was stolen from E's garage with no fault on E's part and was never recovered. Is E legally bound to pay the said unpaid balance of 75,000? Kanina, in another bar exam question, I already told you that if the object of the sale is lost or destroyed, lalo na pag fortuitous event apparently like this, and the question asked would be like this, whether the buyer is still bound or legally bound to pay the balance, effectively the question there is who bears the loss. Because if the buyer will have to bear the loss, he can be compelled to pay the balance. But if the seller will be the one to bear the loss, sorry na lang siya. He cannot compel the payment of the balance. Okay? Thus, since the question is who bears the loss, malino na sale naman ito. But the next step here is to determine what kind of sale is involved. And so far sa bar exams, in a way, I can tell you that in problems like this, absolute sale lahat ang mga tanong. Wala namang tanong na sale on approval or conditional sale in relation to risk of loss. Okay? So far, may nakita ka ba na reservation of ownership? Wala. And therefore, the sale appears to be an absolute sale. And since it pertains to an absolute sale, ano ang susunod niyong gagawin? Determine under the facts if there had been delivery already. Because with delivery, then ownership already passed to the buyer. Under the facts, there was already delivery. And therefore, at the time of the loss, due to a fortuitous event, ownership was already with the buyer. Therefore, under the res perit domino rule, the buyer bears the loss. Okay? In English, whoever was the owner at the time of the loss will be the one to bear the loss. Okay? Kaya, the buyer here is bound to pay the balance because he will be the one to bear the loss. Ang sagot dito is yes, because upon delivery in an absolute sale, ownership passes to the buyer, thus, he bears the loss. Okay? Yung isa, yes, because in a contract of sale, after delivery, the buyer bears the loss. Hindi totoo yan. Okay? Because kung sale on approval ito, ordinarily, the seller will be the one to bear the loss. If the buyer, for example, had not yet accepted the goods. Okay? Let it be known because the loss was without his fault. Even if it was without his fault, due to a fortuitous event nga, ang question lang naman dyan, who bears the loss? Okay? Wala naman may kasalanan. Di naman kasalanan ng seller, di naman kasalanan ng buyer. But between the two of them, who bears the loss? Okay? That's the question. And let it be known because he was not yet the owner as he has not yet paid the price in full, which is wrong because this is a conditional sale. Okay? This is an absolute sale. And therefore, upon delivery, even if there had no payment yet, the buyer already acquired ownership. Okay? Yung isa, pareho lang yan. Basically, it's the same principle involved. Okay? So, punta na lang tayo sa next. Okay? Before I proceed sa double sales, I will just have to tell you that there are exceptions to the res perit domino rule na hindi pa tinatanong sa bar exam. But I think it should be asked. Okay? Kasi may mga kaso naman di ba? Totoo naman nangyayari ito. So, when would the owner not bear the loss? If the thing was lost, ang premise palagi ng risk of loss is fortuitous event. The loss was due. Because if the loss was due to the fault of one of them, whoever was at fault will have to bear the loss or may be liable for the loss. Di ba? But, ano itong mga exceptions? A good case relevant to these exceptions is the case of Lawyers Co-op versus Tabora. This is a classic case, okay? In relation to risk of loss, okay? Attorney Tabora, obviously a lawyer, okay, is from Naga City, okay, and about 4 or 5 years ago, he was still alive. I hope he's still healthy today, okay? I asked the reviewees in Naga kung kilala nila si Attorney Tabora, kilala daw nila, okay? Anyway, Attorney Tabora bought a complete set of American jurisprudence, okay, from Lawyers Co-op, okay? Imagine mo, AMJUR ang binili niya, hindi lang Philippine Reports o kaya hindi lang SCRA, AMJUR talaga, di ba? Before this internet, before yung mga ano na lang, you can subscribe na di ba? Wala nang hard copy, okay? Dati hard copy yan, talagang you would notice, pero tingnan niyo ito palagi, maging conscious kayo, maging observant. Pag ang lawyer nagpapakuha ng picture, ang background niya palagi mga libro, o diba? Mga SCRA, mga Philippine Reports, parang office niya, basta puro yan libro sa likod niya. Okay? Pag nagpapa-interview sa TV, o kaya picture yan. Siyempre, ang dating niyan, pag ang background mo, kumpleto ka ng SCRA, parang abogado di Campanilla talaga ang dating, di ba? Pero itong si Attorney Tabora, AMJUR ang binili. Hindi lang SCRA, American Jurisprudence. Naku, pag may ganyan ka sa opisina mo, naku, mahal ang bayad. Okay? Talagang ang dating sa'yo, abogado di Batingaw. Talagang umaalingaw-ngaw ang ganda ng kaya lang mahal din ang bayad sa abogado. Anyway, but this is a sale this is a conditional sale also. Attorney Tabora only paid a small amount, the balance payable in installment, and however, on the very night these books were delivered to Attorney Tabora, all the books were destroyed due to a fire, okay? Which destroyed not just his library or his building, but the entire block sa Naga City, okay? Now, siyempre, wala na ang libro, hindi na nagbayad si Attorney Tabora sa balance. Mahirap magbayad pag hindi mo na nakikita ang binili mo, di ba? You should try yung ganung scenario. I already experienced that, okay? Ninakaw ang aking bagong-bagong laptop, parang one of those early laptops na mahal, like 65,000, 75,000 yata ang laptop. And ano yun? Payable in installment. Okay? Hindi naman conditional sale. Okay? Do not have this notion na pag installment payment again ay conditional sale. Ang pinag-utangan ko yung isang law school. Okay? Payable salary deduction. Pero wala pang 3 buwan, ninakaw na sa akin. Para mas masamang loob ko dun, mas bago ang kotse ko. Okay? And my car was also destroyed. Sinira yung left mirror, left glass, yung driver's side to be able to get the laptop. Ang sabi ko nga, sana yung kotse na lang ang ninakaw, iniwanan ang laptop. Di ba? Why? Kasi ang kotse insured, ang laptop hindi. Okay? So, pero actually, mas mahirap kasi ang laptop na yun because rare time yun na I brought the laptop outside of my home, okay? Because I wanted to update my notes. Specifically, mga oblikon, ganyan, magpa 5 years na kasi yung notes ko, so I wanted to update. So, i-encode ko na naman. Ninakaw. Kaya ang sabi ng iba, ang suspect dito, estudyante mo. O, di ba? One of your students must be the culprit, okay? At any rate, mahirap magbayad ng isang bagay na wala na sa'yo. Okay? So, Attorney Tabora did not pay, and therefore lawyers co-op filed this action to recover a sum of money plus damages. Okay? One of the defenses raised by Attorney Tabora was res perit domino rule. This being a conditional sale, lawyers co-op retained ownership until full payment of the price. Okay? Yun lang ang condition. Okay? Now, but a valid defense, a tenable defense, the Supreme Court said, hindi. Okay? Because in the contract, it was stipulated, napakalinaw, that, okay, upon the delivery of the books to the buyer will be the one to bear the loss, whatever may be the cost of the loss. In other words, by stipulation, it may not be the owner who will bear the loss. Okay? Magaling ang mga abogado ng lawyers co-op. Okay? Siyempre, pangalan pa lang, lawyers na lawyers co-op. But, assuming lang for the sake of argument that there was no such stipulation in the contract between lawyers co-op and Dr. Tabora, would the defense now be tenable? I would still say hindi pa rin. Because there's a second exception, this is under 1504, okay? Where it will not be the owner who will bear the loss, again, as an exception to the res perit domino rule, if the seller retained ownership only to secure the fulfillment of the buyer's obligation. Okay? Ang tawag sa title ng seller dito ay security title, pang-secure lang. And in that case, I don't think there is any other reason why lawyers co-op retain the ownership over the books. That is only to secure the fulfillment of the buyer's obligation. So the second exception is also applicable. Ang third exception to the res perit domino rule is not applicable dito sa case na ito. Okay? The third exception provides, still in 1504, that if there is delay in the delivery of the goods, and thereafter the goods were destroyed due to a fortuitous event, whoever was at fault resulting in the delay of the delivery will be the one to bear the loss. Siya may kasalanan, kaya na-delay ang delivery, kaya he will be the one to bear the loss. In a way, this is consistent with 1165. In an obligation to deliver a determinate thing, even if such thing is lost due to a fortuitous event, if at the time of the loss he was already in delay, he will still be liable for the loss of that thing, di ba? But concretely, in a contract of sale, when would this happen? Ang mas madaling scenario is the ownership is still with the seller. But because ordinarily, like if you bought furnitures from SM, okay, would SM deliver to you, or you should get the furnitures from SM? Ordinarily, we would get the goods from SM. But if you want SM to deliver the goods to you, you will have to have an agreement with SM, and you will have to pay additional amount for delivery fee, di ba? So ordinarily tayo ang pupunta, doon tayo ang kukuha. So in this scenario, before delivery, is there transfer of ownership already? Mukhang wala pa. The goods are still with the seller, and the buyer was supposed to obtain the goods from the seller's place, but due to the fault of the buyer, he was not able to obtain the goods from the seller's place. And thereafter, the goods were all destroyed, probably dahil sa undoy na baha. Okay? Who will bear the loss? If you apply res perit domino rule, wala pang transfer of ownership, it will be the seller. But in this scenario, because it was the buyer's fault, resulting in the delay of the delivery, it will be the buyer who will bear the loss, even if he was not the owner at the time of the loss. Again, by way of exception to the res perit domino rule. Pero, balik rin natin ngayon, if it was at the time of the loss, if the buyer was already the owner, but the goods were still with the seller. But this time, due to the fault of the seller, there was delay in the delivery. Again, this time, the seller will be the one to bear the loss, even if he was no longer the owner at the time of the loss. Okay? ang medyo mahirap-hirap na tanong dito ay, how could the buyer be the owner already if the goods are still with the seller? Ang sagot, by constructive delivery. Because Philippine law would allow transfer of ownership by constructive delivery. But ang tunay na mahirap na sagot, tanong ay, what mode of delivery, constructive in character? Ang mga maling sagot would include breve mano. Breve mano cannot be a good answer because ang premise ng scenario, the seller still has possession at the time of the loss. But in breve mano, at the time of perfection of the sale, the buyer is already in possession. Lawful possession, but not yet in the concept of owner. In breve mano, baka ang buyer was the lessee, kaya in possession na siya. O baka ang buyer was the borrower, okay? Kaya lang palagi niyang hinihiram ang bagay na inis ang seller. Sabi ng seller, total palagi naman nasa iyo yan, palagi mong hinihiram, bilhin mo na lang kaya, di ba? Kaya binili ng buyer ay breve mano ang mode of delivery. But it's not applicable kasi ang goods in our problem, in our scenario, nasa seller. But another wrong answer ay constitutum possessorium. That's not a good answer because in constitutum possessorium, the seller will not be in delay. Because the seller will still have the right to the possession but no longer in the concept of an owner. Kung dati siya ang may-ari, binenta niya, later on, he may still have the right to possess. No longer in the concept of an owner because probably after the sale, they entered into another contract. Like a lease. Nilease ng buyer sa seller. So it cannot be in delay. Diba? Ang premise natin, there was delay in the delivery. Okay? A good example ay, a good mode of delivery is by the execution of a public instrument. So when ownership passed, okay, the possession was still with the seller, but if the seller was at fault resulting in the delay, okay, he will be the one to bear the loss by way of the exception to the res perit domino rule. Okay? Again, under 1504. So, into double sales. Okay? It is, in this country, there are many such scenarios where a parcel of land would be sold by the owner not only to one buyer but to 2 to 3 buyers. Diba? Although, buti na lang ang mga bar examiners, wala namang problem on double sales na ang 2 beses binenta ay mansanas. Okay? Parang masyado namang may pagkaano ang buyers. Hindi niya wala siyang nahahawakan, bumibili siya. Okay? So, lupa, normally ang object ng sale in problems involving double sales. So, ito magandang tanong, okay? Especially if it was really intended by the examiner. If the same thing should have been sold to different vendees, to whom shall the ownership be transferred? If not intended by the examiner, unless, in a way, magaling ang examiner, okay? Something is wrong with the question, okay? To whom shall the ownership be transferred? Because in double sales, ang tanong talaga dyan, who has a better right? Kasi binenta sa isang buyer, may karapatan na rin siya. Pero binenta pa sa isang pang buyer, maybe the second buyer would have a better right, okay? In other words, is it not possible that the first buyer acquired ownership, but since the second buyer has a better right, the ownership of the first buyer will be terminated, it will be transferred to the second buyer. That question, that scenario is very much possible. Ang scenario, for example, involving a sale of a parcel of land would be this. The seller delivered sold the land to buyer A, and it was delivered to him. So A took possession of the land. But thereafter, the seller sold again the land to a second buyer. And this second buyer registered the sale without knowledge of the prior sale. Yung first buyer, did he acquire ownership? Of course he did. Because he took possession and there was delivery. Kaya lang, in the problem, under 1544, the second buyer has a better right. Okay? As this is a sale of an immovable and he was the first to register it in good faith. Okay? In other words, the ownership of the first buyer will be terminated, it will be transferred to the second buyer. Kaya, I formulated options na ang premise ko lang ay sale of an immovable. Okay? In relation to this question, to whom shall the ownership be transferred? If the question was really who has a better right. If the thing is an immovable, the buyer was the first to register the title in good faith. Or, if the thing is an immovable, the buyer was the first to register the thing in good faith. That received the thing is an immovable, the second buyer who bought the thing in good faith and was the first to register the sale. And letter D, if the thing is an immovable, the buyer was the first to register the sale in good faith. If you notice, letter A, letter B, letter D, halos pare-pareho lang. Isang word lang ang pinagkakaiba. This one registered the title. This one registered the thing. This one registered the sale. Yung confusion dito ng marami is because the law says register it in good faith. Kaya ang karamihan, marami at least, hindi alam what it pertains to. In my classes, when a student says it, and I would ask, what are you referring to? More often than not, hindi niya alam ano ang ini-it niya. Di ba? Kaya, avoid the it. Okay? If you are referring to the sale, just say sale instead of it. Okay? In this law, 1544, what is meant by the law na it is the sale. It's not the title, it's not the thing, it's not the certificate, it is the sale. Register the sale in good faith. Literally, ang nare-rehistro mo ay ang papel, the deed of sale. But when you register the deed of sale, nare-rehistro mo na rin ang kontrata. Di ba? Kaya, ang tamang sagot dito is letter D. The buyer was the first to register the sale kasi immovable ito. What's wrong with letter C? Okay? The second buyer who bought the thing in good faith and the first to register. Ang mali dito, the law says the first to register the sale, not the first to buy and then register. Okay? Buying in good faith is not the same as registration in good faith. Kasi pwede, nung binili ng buyer, at the time he purchased, he had no knowledge. Therefore, he is a buyer in good faith. Pero nung nirehistro niya, after so many months, he already had knowledge of the prior sale. Kaya, the registration was not done in good faith. And what is required is registration in good faith, not merely buying in good faith. I would have to tell you, some of you would probably be the legal counsel, if not the chief legal counsel, ng mga realty firms. Malay mo, maging Mega World chief legal ka, o kaya Phil Estate. Although maraming problema yata yun, okay? Pag nandun ka, okay? You will have these situations where a parcel of land may be sold by your client, by your boss, okay, by the company, okay, and but kung ikaw ang abogado, ipaparehistro mo kaagad ang sale. Aba, magtanong ka sa mga boss mo because they may not want that sale to be registered immediately. Maraming rason, okay, and one of them pera, okay, because the moment you have that sale notarized, preliminary to registration, tatakbo na ang prescriptive period for the payment of the capital gains tax at saka documentary. Kung in the billion ang transaction, aba, million ang babayaran. Okay? My boss in a realty firm once bought a 20,000 square meter lot from Ayala, okay? Sa Makati Avenue, going to Mandaluyong, okay? Imagine mo, 20,000 square meters. At that time, nung binili nila, it was 400,000 per square meter. O diba? Tapos 20,000, ilang bilyon yon? Ako nga, isang square meter, hindi ko kaya, diba? Pero kung meron kang isang square meter, pwede ka na magpatayo ng bahay, pataas, okay? Building. Kaya lang pag matulog ka, patayo, diba? Ganun din ang, have you seen structures na gano'n? Parang liliit talaga. Talagang parang patulog, nakatayo. Okay? At any rate, they may not want to pay. But there is one other reason. Mga negosyante ito, sometimes they will change their minds. They may not want the land anymore, yung buyer. Kaya ang gagawin ng buyer, ibibenta sa another buyer. Pag pinarehistro mo na yan, kailangan mo naman magbayad ng tax. Pero pag wala pang notarization, private instrument lang ito, binenta ulit sa second buyer, it will be treated, they will just agree among themselves na isang transaction lang ito. From the first seller to the second buyer. So, walang double taxation, di ba? Tipid sila ng milyon-milyon na salapi. Okay? So, huwag masyadong atat na atat. Rehistro ka agad kasi may sale. Okay? But at the time of purchase, pwedeng walang alam ang second buyer sa prior sale, but at the time of registration, he may already be aware of the prior sale. Therefore, alam na niya na may defect ang title niya. Okay? But this one is a good question. Madali lang ito. Gawa-gawa ko lang ito. Okay? This one. Just to emphasize to you the requisites in order for to answer correctly the question who has a better right. Okay? This was asked in 2004. At that time, 2004, ang exam, September. Okay? And I would have a class every Sunday na Civil Law Review 2. By September, we would be discussing the law on sales already. Okay? So that at that time, September, para alas 8 ng umaga, we would already have a copy of the questionnaire. Di ba? I don't know how these people from Taft Avenue nakakakuha na sila kung kani-kanino. Okay? But alas 8 ng umaga, my class would be 1 o'clock. So 1 o'clock, I read this problem sa kanila. Okay? JV owner of a parcel of land sold it to PP, but the deed of sale was not registered. Okay? 1 year later, JV sold a parcel of land to RR, who succeeded to register the deed and to obtain a transfer certificate of title over the property in his name. Okay? Who has a better right over the parcel of land, RR or PP? Why? Explain the legal basis. Take note, yung examiner very much conscious. Register the deed. Okay? Yun ang nare-rehistro. Plus, certificate of title. Okay? Mamaya, may relevance yan. Okay? Who has a better right? When I ask this question to my students, ang sagot, parang choir ang dating. Parang isang boses lang sila, isang sagot. Na si RR. Because RR succeeded to register the deed and to obtain a TCT in his own name. Pero, even if you read the suggested answer of the UP Law Center, ang kanyang suggested answer ay, it depends. It depends on whether RR registered the sale in good faith. So, ganun ka-importante ang good faith in order for the buyer to have a better right. Okay? Even if he is the second buyer, as long as he bought it in good faith, he may have a better right over the thing. Okay? Now, although sabi nga nung isang dati kong professor, ayaw niya ng it depends. Okay? I would have accepted another phraseology that RR would have a better right over this land because there is nothing in the problem which can be the basis of the conclusion that he is a buyer in bad faith, because the law presumes good faith, and therefore, as he is a buyer in good faith, and he was the first to register without knowledge of the defect of his title, then he would have a better right. I would have accepted that as a good answer. Okay? maski hindi, it depends. Kasi may presumption ng batas. Okay? Now, so here RR, if he registered the sale in good faith. This one, PP, because he was the first buyer and therefore a buyer in good faith. Just because he's the first buyer will not necessarily give him a better right. Okay? Because it is the buyer who was the first to register the sale. PP, if he took possession in good faith. This is not a good answer kasi immovable ito. Okay? Kung immovable sana, kulang pa nga ito eh. If he took possession in good faith, ang requirement ng batas, if he was the first to take possession in good faith. Okay? Letter CRR, because he was the first to register, again, subject to the requirement that he must have registered the sale in good faith. But this one is really good, okay? A good question on double sales, okay? June 15, 1995, Jesus sold a parcel of registered land to Jaime. 15 days thereafter, he sold the same land to Jose. Who has a better right if the first sale is registered ahead of the second sale with knowledge of the latter, or the second sale is registered ahead of the first sale with knowledge of the latter? Una, if a parcel of land is sold to 2 or more buyers, is it possible for all the buyers to be able to register the respective sale sa Register of Deeds? Aba pwede, tuwang-tuwa ang Register of Deeds yan kasi bayad lang ng bayad, di ba? But also, the Register of Deeds, we don't know if what was the alam naman memorize ng TCT number, di ba? Hindi niya alam yon. Kaya hala, rehistro lang siya ng rehistro, di ba? Tanggap lang tanggap, okay? But, okay? Which one is the more difficult question? Siyempre, ang mas mahirap, yung mas mataas ang points, yung 3 points, di ba? Pag konti lang ang points, para madali lang, kaya 2 points lang. Ito, very easy to answer. Second sale is registered ahead of the first with knowledge. It was a registration in bad faith. He already knew that there was already a prior sale. Kaya nung binenta sa kanya, may defect na ang title ng seller. So the registration was not done in good faith. Kaya it will be the first buyer who will have a better right. Pero itong letter A is a little bit difficult because the first sale is registered ahead of the second with knowledge of the latter. Ibig sabihin, nung binenta sa kanya, alam na niya that there will be another sale. Parang ESP ang dating, di ba? Parang ganyan bang ibig sabihin? Hindi naman, okay? First sale was registered ahead with knowledge of the second because nga, the first sale may have been registered a year after the sale. By that time, naibenta na doon sa second buyer. Pero nauna pa rin sa nagrehistro. Di ba? Saka lang nagrehistro ang pangalawang buyer. Okay? Thus, who will have a better right here? The first buyer. Because when he registered, even with knowledge of the second, at the time he bought, may defect na ba ng title niya? Wala. He is the first buyer. Ang second buyer, kaya lang he would have, kaya defective ang title niya is because it was already sold to another one before he bought it. Okay? Kaya ang kailangan sa kanya, no knowledge of the defect. Pero ang first buyer, wala pa namang defect because of the second sale? Definitely wala. Pero actually, take note, una, registration in good faith. Pag wala or in bad faith, ang susunod ay possession in good faith. Pag walang possession in good faith or the possession was done in bad faith, ang susunod ay oldest title. Ang oldest title, kailangan ba ng good faith? Kailangan pa rin. In other words, pwede ba ang first buyer may have bought the thing in bad faith? Yes, not because of the second sale, but because of a defect in the title of the seller. Like, alam ng first buyer na there was cessation of consent of the real owner, na binugbog lang ng seller ang may-ari to be able to buy the thing which thing was sold to the first buyer. Okay? Kaya in that sense, he may have the oldest title but he may not have been in good faith, so he may not have a better right. Okay? Now, kaya yun ang mga sagot. Okay? This is the provision. Ang problem dito ay who may have first recorded it in the registry of property. Kaya hindi alam ng iba what it means. Ang it ay the sale, or literally the deed of sale. Okay? Under 1544. But last two cases, okay? In relation to double sales, okay? Ito ang scenarios, okay? In the first sale, ano pala? A sold this parcel of land to B, okay? Instead of taking possession, physical possession, si B leased the land to A. Okay? Nilease niya. So A continued to be in possession. Thereafter, A sold the same land to C. And it was delivered to him. When C took possession of the land, he had no knowledge of the prior sale. Both B and C did not register the respective deed of sale. Who has a better right over this land? Take note, C took possession in good faith. Kaya lang sufficient na ba yun? Aba, hindi. Ang kailangan, he must have taken possession. He must be the first to take possession in good faith. But was he really the first to take possession in good faith? The Supreme Court ruled that hindi. Si B was the first to take possession in good faith in Bautista versus Soson, okay? And this ruling had been consistent to this day, okay? That the first buyer, okay, was the first to take possession in this scenario. Why? He did not take physical possession. Pero, when he leased the land to A, anong effect? By constitutum possessorium, he acquired ownership. And thus, with the lease, CA only has physical possession. CB already has legal possession. And 1544 does not qualify. So again, if the law does not qualify, we should not qualify. Ang possession under the law may be physical, may be legal. Kaya, even if C took possession in good faith, he was not the first to take possession in good faith. It was B who was the first to take possession. In other words, again, ang possession under 1544 need not be physical. It can be legal possession. Okay? Pangalawa, parang similar lang dito sa case na ito. May konting similarity. Okay? But, itong si A sold this land to B. This time, B took possession over the land. Okay? Now, thereafter, however, itong si C is the judgment creditor of A. Okay? And he had the sheriff levy upon this land. Ang lupa ang nilevy. Okay? Now, and thereafter, the land was sold in an execution sale na siya ang highest bidder, if not the only bidder. Okay? Thus, the sheriff issued a certificate of sale in favor of C, which C registered. Nirehistro niya ang certificate of sale without knowledge of the prior sale. Okay? Take note, B did not register the sale. He just took possession. Okay? But C registered the certificate of sale. Who has a better right over the land? Si B or si C? If you apply 1544, the correct answer would be C. Because B did not register the sale. And C registered the sale in good faith. He was the first, if not the only one, who registered the sale. But, is it possible that B may have a better right? That is possible, but only if this object of the sale is not a registered land. In other words, the Supreme Court consistently would rule that 1544 will only apply in a double sale in a problem on double sale, okay, involving a parcel of land if the land is registered under the torrent system. In other words, if the land is unregistered land, do not apply 1544. If you don't apply 1544, who will have a better right? Si B. Kasi when A delivered the land to B, B already acquired ownership. Kaya nung nilevy ng sheriff ang lupa na yan, there's nothing more to levy. Hindi na property ng judgment debtor yan eh. And therefore, there can be no valid sale over that parcel of land to bind B, okay? Because ownership had already passed to B, okay? If you just apply the ordinary rules on transfer of ownership. Now, this is one of the cases, Karumba versus Court of Appeals. Kaya, ang mga examiners, in fairness to the examiners, would be careful in formulating questions involving double sales. Sinisiguro nila na applicable, for example, ang 1544. Example, tingnan nyo ang problem, registered land. Okay? Kung hindi man sabihin niya na registered land, paano natin malalaman na talagang registered under the torrent system? If there is a TCT number or an OCT number. Okay? Just like here, nakalagay, who obtained a TCT, Transfer Certificate of Title. It means the land is registered under the torrent system. 1544 can be invoked. Okay? So I think okay na yan sa double sales. So this case is a very good case. Okay? Dolorita Biatinco versus Liliagasis. Okay? The issue here is whether or not there was a double sale which would give a better right to hear and respondent as the possessor of the property. This is a sale involving a parcel of land. Yung first sale was in favor of Dolorita Biatinco. Okay? Pero she did not take possession. Although ang claim niya, yung sale was notarized. So it's a public instrument. Okay? Thereafter, however, this same parcel of land was sold to Liliagasis. And Liliagasis took possession over the land. Okay? Now, but ang owner, thereafter, itong si Dolorita Biatinco filed this proceeding petition for the issuance of a new TCT claiming that the old TCT was lost. Yung pala, ang original copy, ang owner's copy, nasa second buyer na kay Liliagasis. Okay? Kaya, Liliagasis opposed the petition. Okay? So, who has a better right? The first buyer na public instrument or yung second buyer who is in actual possession? Sabi ng Supreme Court, between a public instrument and actual possession, the one who is in actual possession would have a better right. Okay? Kaya ang public instrument may pagka-second fiddle lang ang ano niya, ang dating niya. Okay? Sabi ng Supreme Court, kung public instrument na siya, okay, the buyer should have pursued yung possession over the land. So when the second buyer was the one who took possession, the Supreme Court ruled that the second buyer would have a better right over this land. Okay? And yes, covered ito ng double sale. Okay? So, we can have a few minutes lang on delivery. Okay? As I said, hindi masyadong favorite ito sa bar exam, but let's start with the modes of delivery. I mentioned this morning that there are different modes of delivery in sale of things at saka sale of rights because rights are incorporeal. So I'll start with sale of rights. What are the modes of delivery? When would ownership pass, okay, in this kind of sale? Una, by the execution of a public instrument, okay, ownership may pass. Yun nga lang, wag dapat in a way, walang kalaban na possession. Okay? Now, execution of a public instrument, this is the only mode of delivery common to both things and rights. Okay? But again, if you read the article completely, unless the contrary intention is clear in the deed. Kasi naman, maski notarized ang deed of sale, pero maski 10 beses pang inotarize. If in the deed of sale, it is so clear that ownership will pass only until full payment, then it will never pass despite the notarization 10 times. Okay? It will be upon full payment that ownership will pass. Okay? Pangalawa, by the placing of the titles of ownership in the possession of the vendee. Okay? Again, what is meant by the law, possession of the titles of ownership, ang ibig sabihin ay certificate of titles. Okay? Like in a sale of shares of stocks, okay? Upon the delivery of the stock certificates to the buyer, ownership passes to the buyer. Okay? Placing of the titles of ownership in the possession of the buyer. But the third one is a bit, in a way, not so easy to understand. By the use of the vendee of his rights with the consent of the vendor. Why would there be a need for the consent of the vendor for the vendee to be able to exercise his rights, di ba? Lalo na kung bayad na niya ang presyo, fully paid na siya. Ang magandang senaryo dito, yung nangyari sa Meralco during the stockholders meeting about 3 years ago. Although ngayon, ang nag-away at that time was the Lopez family and in a way Mr. Garcia ng GSIS, di ba? Nagkagulo doon. Ang pinag-awayan nila, proxy votes. Okay? Now, ang proxy votes kasi, ang scenario sa mga corporations is this. Before the day of the meeting, stockholders meeting, mga 1 month before that, the books of the corporation would be closed. In other words, only those registered owners of the shares at the time of the closure will be recognized during the stockholders meeting. In other words, if you are the buyer of the shares during that period, you will not be allowed to enter that meeting. Okay? You will not be recognized unless the seller recognized you or gave his consent. How? By giving you a proxy. Di ba? So if you were authorized by the seller to participate in that stockholders meeting, by law, that would constitute delivery in order for ownership to pass. So maski hindi ka pa registered owner dahil sarado nga ang libro, you can already participate in that stockholders meeting. Yun, nag-away-away sila. Okay? Yung, pero now, I think Meralco is already owned by the Pangilinan group of companies. Okay? Hindi na ng Lopez family. Now, I don't know, pero may share pa rin yata ang Lopez, pero hindi na controlling. Okay? Now, then, into the sale of things. What are the modes of delivery? Some authors would say there are 4, others would say there are 5. The law says there are 2. Okay? So, between the law and the authors, I would side with the law. Okay? Dalawa lang ang modes of delivery, either actual or constructive. In other words, if the delivery is not actual, then it is constructive. All the rest mentioned by these authors would fall under constructive delivery. But when would the delivery be an actual delivery? Okay? Example, if the seller delivered physically the goods to the buyer, there is already actual delivery? Not necessarily. Because there will only be actual delivery resulting in transfer of ownership if the buyer would have not only the possession but also control over the goods. Kaya kung dineliver ang goods sa buyer only for safekeeping, walang transfer of ownership. Okay? Ano lang siya, depositary lang siya, walang actual delivery resulting in transfer of ownership. Okay? Again, it's both control and possession, not just possession. Okay? But Kung ang tinanong sa kaso sa Supreme Court, what if it was delivered to a person who is not the buyer? Okay? May there be actual delivery nonetheless? Kasi nakalagay sa codal provision, buyer. Okay? But the Supreme Court said, yes, it may still be actual delivery if it was delivered to a person who was authorized by the buyer to receive the goods. In other words, agent siya with the authority to receive, then that would still constitute actual delivery. Okay? But into constructive delivery, we have already discussed brevi mano. So I will not discuss that again. We have already discussed constitutum possessorium. Itong nangyari dito, nanilis niya doon sa seller, that would be constitutum possessorium. But I would say, hindi kailangang lease. Pwede namang deposit, pwede namang comodatum. Halimbawa, binenta ni A kay B, pero mukhang kailangan pa ni A ang bagay. Sabi niya kay B, can I first borrow the thing? Okay? So, hiniram muna niya. Would ownership pass to the buyer? Yes, by constitutum possessorium. In the loan in comodatum, ang lender na ang may-ari. Ang borrower, he only has the right to use. Okay? Possession and the use. Kaya, there is constructive delivery by way of the traditio constitutum possessorium. Okay? But longa mano, in a way, opposite ng, yung brevi mano, parang it's literal of shorthand. Shorthand kasi hawak-hawak na niya ang bagay. Di ba? Hawak-hawak na ng buyer. Longhand, others would say, by the seller merely pointing at the thing to the buyer, iyan ang binibenta ko sa iyo. That would already result in transfer of ownership. But if you will read the provision strictly, it is by mere consent of the seller. Ownership passes to the buyer because at the time of the perfection of the sale, the seller could not transfer possession over the thing to his buyer. Parang weird. He can cause the transfer of ownership, but he cannot cause the transfer of possession. Pwede ba yan mangyari? Aba, pwede. Maybe the thing at the time of the sale was being rented by another person and the period of the lease had not yet expired. Can the lessor, who is the owner, sell the thing to this buyer? Of course. And the buyer may acquire ownership, but he will not be entitled to possession because a third person has lawful possession. But ordinarily, who will be entitled to the rentals? Ordinarily, it should be the buyer. Ikaw na ang may-ari, alangan namang iba pa ang mangungulekta ng rentals, di ba? But actually, is it possible that the seller may continue to have the right to the rentals? Yes, by stipulation. If I am the buyer, I may agree that the seller will continue to collect the rentals up to the expiration of the lease. Pero ibabawas doon sa price. Diba? Kung ang makakolekta niya, 100,000 pa, ibawas natin sa price. And I would agree to that. Dahil sigurado na ako nagbabayad na ang mga lessee. Malay natin, di pa magbayad ang mga yon. And I don't know them. Alam ng lessor pa ang mga kiliti ng mga yon. Okay? So, I would agree to that. I may not be entitled to the rentals, although I am already the owner because of that agreement. Okay? Now, symbolic delivery. Professor De Leon would call this symbolic. By the mere delivery of the keys to the place where the goods are located. Okay? Take note, ang object of the sale are the goods, not the warehouse. Okay? Because if the warehouse is the object of the sale and the keys to the warehouse were delivered, I don't think that would be constructive delivery. It will be actual delivery because then the buyer would have control and possession over the warehouse. Pero if the goods located inside the warehouse are the object of the sale, by mere delivery of the keys, ownership passes by symbolic delivery. Okay? Siguro one last, aside from the execution of public instrument, which I already mentioned, would pertain to this scenario. What if the seller, pursuant to his agreement with the buyer, delivered the goods to a common carrier for ultimate delivery to the buyer's place? Baka taga Sambuanga ang buyer. Okay? So ang seller, ginawa niya, he delivered the goods to a common carrier sa Sulpicio Lines, okay, na barko. Okay? Upon delivery to the common carrier, ownership passed to the buyer? Maski nandun pa lang sa Port of Manila? As a rule, the answer is yes. Delivery to a common carrier as a rule is equivalent to delivery to the buyer. But there are two exceptions to this. Okay? Even if there was such delivery, ownership may not pass to the buyer. Una, if the seller reserved ownership. Malinaw naman. Ang tanong ko lang palagi dito, how would we know if the seller reserved ownership in relation to this problem? Ang common ng sagot, it can be shown, it can be seen sa bill of lading, which is really wrong. The bill of lading has nothing to do with ownership as to who is the owner. The only subject matter of the contract pertains to who has the right to obtain the goods from the common carrier. Kaya nakalagay sa bill of lading, the goods are deliverable to. Who cares kung driver siya ng may-ari or security guard ng may-ari? As long as his name appears in the bill of lading, he will be the one to have the right to obtain the goods from the common carrier. Walang pakialam ang common carrier kung sino ang may-ari. Pero kung may reservation of ownership which can be seen sa deed of sale, then despite delivery to a common carrier, then ownership will not pass to the buyer, okay? Upon the mere delivery of the goods to the common carrier. But the second, what if doon sa deed of sale walang reservation of ownership? Therefore, by mere delivery to the common carrier, ownership already would pass to the buyer. Still not necessarily, because there's a second exception. That is, when there is a reservation of possession. Kanina may reservation of ownership, ngayon reservation of possession. This time, paano natin malalaman if there is a reservation of possession? Makikita ito una sa bill of lading. Okay? Because in the bill of lading, if the goods are still deliverable to the seller, ay natural, walang delivery to the buyer. Or, deliverable to the agent of the seller, wala din. Okay? There is no delivery to the buyer, which would result in transfer of ownership. Okay? Now, then, ang next would pertain to this. Okay? Problems involving delivery. What if the goods delivered were less or more than the quantity of goods as agreed upon? Okay? At ang ginawang bar exam question ay tungkol sa mansanas. Okay? A buyer ordered 5,000 apples from the seller at 20 pesos per apple. The seller delivered 6,000 apples. What are the rights and obligations of the buyer? Okay? Even in class, in my classes, I would always say that in this scenario where the seller delivered more, the worst answer to that is the buyer would have the right to reject all the 6,000 apples. Sobra nga eh. Why would he have the right to reject all? Diba? Di na bali kung kulang. He can reject all. Pero sobra, ang reasonable rule could be that if he wants, he can accept only the quantity agreed upon but reject the excess. That would be reasonable. But for him to have the right to reject all, walang basihan, di ba? Kaya, ano ang tamang option? Okay? He can accept all 6,000 apples and pay the seller at 20 per apple. Or, he can accept all 6,000 apples and pay a lesser price for the 1,000 excess. Siniswerte siya, di ba? Dahil sumobra lang, lesser price na for the excess. Okay? Pero letter C can keep the 6,000 apples without paying for the 1,000 excess since the seller delivered them anyway. Sobrang swerte ng buyer na ito, di ba? Libre na dahil sobra. But letter D, he can cancel the whole transaction since the seller violated the terms. As I told you, this is the worst option. Okay? Ang susunod dyan, sumobra lang ng isa, ay reject lahat kasi sobra ng isa. Di ba? That would really be without any basis. Kaya, ang tamang sagot ay this. He can accept all 6,000 apples and pay the seller at 20. Actually, he can accept all, but he will have to pay the excess at the contract rate. And that is the contract rate, 20 pesos per apple. The premise of the law here is the seller is willing to sell the excess. Kasi baka nagkamali lang ang pag-deliver ng 1,000 na yon. Baka ang 1,000 para sa kapitbahay, hindi para sa kanya. Kaya, if the seller is also willing, why not? And the buyer would want to accept all the 6,000. Okay? But if I will have to ask a question sa bar exam, if I will be asked to give a question, okay? Not necessarily the examiner, okay? Maski maraming chismis, kaliwat kanan, okay? I will not ask a question about apples, okay? Kasi hindi makatotohanan ito, okay? May kaso na ba sa Supreme Court involving 6,000 apples, okay? Wala. Pag mayroong incident na ganyan, hindi nagkakasundo about apples or mangga, ang result niyan, saksakan, okay? Saksak, duguan, okay? In other words, ang kaso sa Supreme Court, criminal case, hindi civil case as to how much one is entitled, di ba? Ito totoo, kwento sa akin ng kulig ko in another law school, a lawyer who is also a doctor, okay? This kwento niya, this child, mga 5, 6, 7 years old, okay, was selling banana cube, okay? And here comes this man, medyo malaki ng mama, okay, who took one of these banana cubes, isang stick, at kinain. And after eating, the child told the man yung bayad. Ayaw magbayad ng mama pagkatapos kainin ng banana cube. Okay? So the child, anong ginawa? He ran. He went to his father. Hindi pala kalayuan ng tatay. Okay? And the father went to that place and demanded payment. Galit pa yung isa. At anong nangyari? Nasaksak ang tatay, dinala sa ospital. Yun ang nangyayari in real life, di ba? Saksakan, ganyan. Walang kaso-kaso, magpapile ka ng kaso dahil kulang ng 5 apples or 10 apples. Walang ganon. So if I have to ask a question in relation to these principles, it would pertain to a parcel of land. Okay? In a sale of a parcel of land, which there are so many such cases, okay? What if in the deed of sale, the area, as mentioned in the deed, was more or less 1,000 square meters? Okay? Pag nakakita kayo yung deed of sale, 99% meron yan, more or less 1,000 square meters, the area. Okay? Now, thereafter, baka may price agreed upon. Maybe, magkano kaya? 13 million o 10 million na lang para medyo madali mag-compute. Okay? So, again, 1,000 square meters, okay, more or less. But when the buyer had the land survey, it turned out that the area was only 950 square meters. So, kulang ng 50, di ba? The area lacking is 50 square meters, okay? Now, what are the rights of the buyer, if any, in relation to this scenario, okay? Una, of course, specific performance, okay? If the seller is in a position to deliver the lacking area, okay? Because he may not have any other land in the world. So that would be an impossible remedy. Okay? Pero common ito na ang seller would have a large parcel of land but he would only sell a portion. So kung kulang ang dineliver sa'yo, you can easily ask for another 50 square meters to complete the 1,000 square meters. Otherwise, okay, the next question would be, is an action quantum minoris a remedy in this problem? Okay? An action quantum minoris is an action for the proportional reduction of the price. On its face, this is not a remedy. Because on its face, the sale is a lump sum sale. Did I mention, nakalagay ba sa facts, that the land was sold at sabi ko, ang price was 10. 10 million. Kung 10 million, 1,000, mukhang 1,000, no, 10,000 per square meter. 10,000 per square meter times 1,000, that would be 10 million. Okay? Now, it doesn't appear that the land was sold at 10,000 per square meter. Okay? Therefore, it is not a sale at a certain rate per unit of measure. Therefore, it would appear to be a lump sum sale. And in a lump sum sale, there is no right to demand for a proportional increase of the price if the area turned out to be larger. But neither would there be a right for a proportional reduction of the price if the area turned out to be less than that stated in the contract. Bawi-bawi lang. Okay? Pag less, yun pa rin. You will be entitled to the area. Pero pag more, ang buyer entitled to the entire pero walang obligation to pay additional amount. Okay? Now, but finally, okay, is rescission a remedy? In the problem, it doesn't appear that such is a remedy. Because under the law, for rescission to be a remedy on the part of the buyer, the area lacking must be more than 10% of the total area. Ang 10% ng 1,000 ay 100. Okay? And therefore, ang kulang lang under the facts ay 50. And therefore, rescission would not be a remedy. This, you should remember, is consistent with 1191. For rescission to be a remedy, the breach must be a substantial breach. Kaya pag ganyan lang kaliit ang breach, ay wala, rescission would not be a remedy. Okay? But having said that, even if the area lacking is less than 10% of the total area, rescission may be a remedy on the part of the buyer if he can prove that he would not have bought the land had he known that it was less than the area stated in the deed of sale. Siguro kung mapuprove niya na bawat square meter was so important in his plan, okay, sa pag-construct ng isang project. Baka kung building ito mabawasan ng isang square meter o 10, baka mawalan na ng mga CR ang building. Kaya he would not have bought the land had he known that it was less than the area stated in the deed of sale. Only then would rescission be a remedy because the area lacking is less than 10%. Okay? Now this one is a good case. Okay? Carmen del Prado versus Spouses Antonio Caballero. Okay? In relation to a lump sum sale. In this case, a parcel of land was sold. Okay? This land is covered by a tax declaration. Hindi pa ito registered. So tax dec lang ang evidence in relation to the land. And in the deed of sale, the price was agreed upon, baka 1 million pesos, no, mga 300,000 lang siguro. But the area as stated in the deed was more or less 4,000 square meters. Okay? Now, the buyer, preliminary to his application for registration of the land, had the land surveyed. It turned out that the land covered by that tax declaration was more than 14,000 square meters. Okay? Pero, despite that, the buyer had the entire 14,000 square meters lot applied for registration. Yung buong covered ng tax declaration. Nag-oppose ang seller. Sabi ng seller, I only sold to you 4,000 square meters of this lot, not the entire lot. Okay? But the buyer argued that this is a lump sum sale. Okay? In a lump sum sale, as argued by the buyer, even if the area turned out to be more than that stated in the deed, the buyer will be entitled to the entire area without the need to pay for additional compensation. Kaya ang issue dito, lump sum sale ba ito? Pangalawa, kung lump sum sale ba ito, is it correct? Is the buyer correct that he is entitled to the entire 14,000 square meters without the need to pay the seller additional amount? Sabi ng Supreme Court dito, from the contract, it doesn't appear that this is a sale at a certain rate per unit of measure. Wala namang nakalagay na uh, 750 pesos per square meter, di ba? Kaya, sabi ng Supreme Court, this sale appears to be a lump sum sale. Therefore, dahil lump sum sale, the buyer is entitled to the entire 14,000. Aba, ang Supreme Court ang ginawa, the Supreme Court looked at a dictionary, tumingin sa dictionary, pero hindi ganun ka basta-basta dictionary. Black's Dictionary ang tiningnan. In relation to the phrase, more or less. Kaya sinasabi ko nga sa mga estudyante, kung Supreme Court nga, nagdi-dictionary, tayo pa kaya. Di ba? Kaya pag hindi naintindihan ang word o ang phrase, ay by all means, may katabi kang dictionary. Lalo na yung mga bata ngayon, yung mga gadgets ng mga bata ngayon, nako, isang 3 pindot lang, dictionary na kaagad. O di ba? So alam mo na kaagad anong meaning ng mga words. Okay? You don't have to have a 10 inches thick na Webster Dictionary or Moreno's legal dictionary. Okay? To know the meaning of the word or the phrase. And in Black's Dictionary, ang meaning ng more or less is slight deviation from. Kaya kung 4,000 naging 40,000 square meter, would that fall under the more or less slight deviation from? The Supreme Court said hindi. Okay? Kasi 4,000 naging 14, mukhang hindi ito more or less. Mukhang more and more ang dating, di ba? Kaya tama ang Supreme Court, hindi ito more or less. Okay? Ang more or less, mula sa 4,000, baka naging 4,120. Or instead of 4,000, 3,895 lang. That's more or less. Pero from 4,000 to 14,000, ay mukhang hindi talaga applicable yon. So that this concept of lump sum sale was not applied in this case. Okay? Thus, land is entitled to the entire parcel of land, including the excess, dito hindi. Okay? I think we can have a break again. Okay? So, break muna. Kape muna tayo. The parties may have agreed as to when the delivery should be made, maybe a month after the signing of the contract or perfection of the contract. Okay? But if the obligations of the parties are what are known as pure obligations, meaning demandable at once, because the parties did not agree that there would be a period or a condition for the fulfillment of these obligations, upon perfection, the seller is already bound. Again, not necessarily, because until the buyer pays, the seller will not be bound to deliver. Okay? This is a classic rule in relation to a Tagalog term na alam natin lahat, known as kaliwaan. Hindi ka pa nagbabayad, hindi ako mag-deliver. Which is a very sensible na rule, di ba? Because the seller did not agree that he will deliver before payment. But, last scenario, what if the parties agreed that the seller will have to deliver the goods 1 month after the agreement of the parties? But they also agreed that the buyer would have another 30 days from the delivery of the goods within which to pay. Now, upon the arrival of the period for the delivery, which is 1 month, okay, is the seller already bound to deliver, even if the buyer had not yet paid? The answer is yes, because the buyer has another 30 days from delivery within which to pay. Kaya lang, is it not possible that if the thing is a generic thing, okay, where will be the place of delivery? Well, which in our own experience, napakalam natin, in the place of business of the seller. Imagine nyo lang, kung gusto mo ng pandesal, gusto mong bumili, sa tingin mo, pupunta ba sa iyo ang pandesal? Siyempre hindi, unless there is a stipulation. Ikaw ang pupunta sa place of business of the seller para bumili ng pandesal. Okay? Now, of course, kung wala siyang place of business sa kanyang residence, okay? That would be the place of delivery. Now, as I promised, I'll go back to those places fixed by usage or trade. Okay? Now, because of the archipelagic characteristic ng ating country, okay? I would say na una na mode of transportation ang mga sa dagat. In fact, our municipalities, cities na mga old are basically based near the rivers, okay? Now, thus we have developed this delivery arrangements or shipping arrangements, okay, in relation to this contract, okay? And there are many of such, like X-warehouse, X-ship. Basically, X-warehouse, the buyer has to go to the warehouse to pick up the goods. Mag-X-ship doon sa barko, okay? But ang pinaka-common dito na delivery arrangements or shipping arrangements are yung FOB and CIF, okay? So I will focus on these two. If the parties agreed on an FOB arrangement, where would be the place of delivery, okay? Pag FOB, there will always be a port agreed upon. Like FOB Manila, FOB Cebu, etc. FOB Manila could be the port of origin, okay? FOB Cebu could be the port of destination. So kung ang usapan nila ay FOB Manila, where will be the place of delivery, okay? Ang premise natin, again, just to make sure, para walang confusion, there is no stipulation as to the place of delivery, okay? Pero may FOB Manila sila na usapan, okay? It is said that the place of delivery is the port as agreed upon, okay? In an FOB arrangement, okay? The reason for this can be seen from the name, FOB. What does FOB mean? Sabi ng mga accountants before, years ago, more than 10 years ago, I would have students, accountancy students, who would give me this name na pag FOB daw ay freight on board, okay? Which is really wrong, okay? Maski grammatically speaking, that is wrong. Because if you would look at a dictionary, like Webster Dictionary, what freight means, it means goods on board. So if FOB ay freight on board, that would be goods on board, on board. Medyo nasobrahan yata, di ba? But there is a legal basis to that, okay? Na hindi freight on board, it is free on board, okay? Lately, itong mga libro ng accountancy, nare-reflect na ang legal, okay? Mukhang tumatama na, okay? That this is free on board, why? If the goods, for example, came from Baguio, okay, Benguet, but to be shipped to Cebu, pero would pass through the port of Manila, from Baguio to Manila without a stipulation as to who will shoulder the expenses for the transportation of the goods, who would normally shoulder? The seller, okay? But in an FOB Manila na arrangement, okay? Ang nakalagay free on board. It means that upon arrival of the goods at this port of Manila, the seller shall be free from any expenses in relation to the transportation of the goods. In other words, if he is already free from such expenses, sa freight charges, kay papuntang Cebu, sa Port of Manila pa lang, who appears to be the owner? The buyer. Siya na ang magbabayad ng pamasahe. But if he is already the owner, where is the place of delivery? It would appear sa Port of Manila. Alangan namang siya na ang may-ari, ang delivery sa Cebu pa lang. Di ba? Thus, in an FOB Manila, it is the Port of Manila which is considered to be the place of delivery. Kaya kung port of destination ang usapan, that will be at the port of destination ang place of delivery. Now, in a CIF arrangement, ganun din. Okay? Although in a CIF arrangement, there would be no such port agreed upon. Basta CIF lang. Okay? And where will be the place of delivery? It will be the port of origin. Why? CIF means cost, insurance, freight. This means that as to the price agreed upon, the amount to be paid by the buyer, that would already include the cost, the insurance, and the freight. So effectively, who paid for the freight charges? Yung buyer. Galing sa kanyang pera eh. And therefore, sa port of origin pa lang, it would appear that the buyer already acquired ownership. Therefore, at the port of origin pa lang, there had already been delivery. Having said that, okay, the Supreme Court would tell us that this delivery arrangement, these shipping arrangements, only would raise presumption, okay, a presumption as to the place of delivery which may give way to the real intention of the parties as the real place of delivery, okay? In other words, it is only disputably presumed na pag CIF, port of origin. Pag FOB, port of origin, that it is the port of origin. In other words, what is really determinative as to the place of delivery, as the court would say, is the manner and place of payment. Kung saan ang bayaran, doon ang place of delivery. Okay? Is this a good ruling? I think this is really a good ruling. By analogy, 1582 is cited here. In 1582, may pagkabaliktad. If there was no stipulation as to the place of payment, saan ang place of payment? Sabi ng article, sa place of delivery. So, kabaliktaran, kung walang stipulated place of delivery, saan place of delivery? Sa place of payment. Sa Tagalog, kaliwaan. Diba? Kung saan ang delivery, doon ang bayaran. Kung saan ang bayaran, doon ang delivery. I think there's so much sense to this decision. Okay? Thus, I will cite two cases lang decided by the Supreme Court. One, in relation to a CIF arrangement. The parties agreed na CIF ang shipping arrangement. Pero there was a stipulation that the buyer can demand for the payment of the price upon the arrival of the goods at the port of destination. So saan talaga ang place of delivery? Pag CIF, sabi ko, di ba, port of origin, dapat. But the Supreme Court said the place of delivery is the port of destination, because it is in that place that the seller can demand for payment, so that will be the place of payment. Now, on the other hand, bakit ang question next is, why did they agree on a CIF arrangement if the place of delivery is the port of destination? Isa lang ang sagot. It is merely for the fixing of the price. Para malinaw na ang price as agreed upon will already include the cost, the insurance, and the freight. In other words, malinaw, wala nang gagastusin ang buyer. Okay? Seller na ang bahala magbayad sa insurance, sa freight, based on the price. Doon kukunin sa price. Okay? But in the other case, okay, ang usapan nila, FOB destination. Okay? Pero it was stipulated in the contract that the seller can demand the payment from the buyer by presenting the bill of lading to the buyer. But where can the seller present the bill of lading? Aba, sa port of origin pa lang, he can already present the bill of lading because the shipper, the seller, would have the bill of lading at the port of origin. Kaya if he demands, he presents the bill of lading, the buyer will already be bound to pay. Kaya, even if FOB destination, the Supreme Court ruled that the place of delivery is the port of origin. Okay? Again, bakit nag-FOB destination? Magaling ang buyer dito. Okay? Ang gusto ng buyer, the seller will be responsible for all the expenses in the transportation of the goods hanggang port of destination. Okay? Thus, they agreed on an FOB destination even if the place of delivery is the port of origin. Okay? Now, then we can proceed to this third. Okay? Before the MCQs, this is not really a favorite. There had only been one question for the past 30 years before the MCQs. Pero now, may mga tanong na. Okay? Now, first, okay? May there be a warranty in a sale of a second-hand item? The answer is, of course, yes. There can be such a warranty. In fact, there can be an express warranty in relation to a second-hand item. But in an implied warranty, can there be an implied warranty involving a second-hand item? The answer still is yes. Ang wala lang na warranty in a sale of a second-hand item is a warranty against hidden defects or as to the condition of the thing. But as to against the eviction, warranty against eviction, there will still be such warranty. Now, so the point of this discussion is at least there are two kinds of warranties. My express was unimplied. To point to you yung express warranty involving a second-hand item, for example, in a sale of a second-hand car, okay, gamit na kotse. If the seller told the buyer that with this car, you can drive the car for 50 kilometers with only 1 liter of gasoline. Aba, that is an express warranty. At dapat panindigan niya yun, okay? Not even an OD can do that, okay? Ang brand new OD, mga 31 kilometers per liter lang ang kaya. Second hand, 50 kilometers, ba, siniswerte ka, okay? More often than not, ang mga second hand, humihigop na ng gasolina, okay? Kaya mas magastos, okay? But, why not, okay? If you watch yung mga news, okay? I've known of this because of a team in De La Salle, okay? Which would participate in international competitions, okay? And nananalo sila, ang tawag sa kanilang vehicle ay sinag, okay? O sinagtala, parang gano'n. It's parang ray of hope, whatever, okay? Now, with this car, or anong tawag man yan, they can drive, it can travel for more than 1,000 kilometers with only 1 liter of gasoline, pero may solar energy, okay? Combined with solar energy. Naka-travel. So I won't be surprised in the next 10 years, makapag-drive na tayo ng 1,000 kilometers with only 1 liter. Yan, sarap nun, di ba? Hindi na mahal ang gasolina, okay? Kaya lang baka ang gasolina nun ay 10,000 per liter. Ganon din, bawi-bawi din. Now, ganyan talagang buhay, okay? But, okay? Express and implied. There can only be an express warranty if there is an affirmation of fact, okay, in relation to the thing, not to the buyer or anything else, but to the thing, as to the quality of the thing, okay? Like kanina ko nga, maybe the car, you can drive the car for 1,000 kilometers with only 1 liter. But if the statement of the seller was, if you buy this car, na second-hand car, you will forever be a happy person, okay? Of course, it cannot be an express warranty because the affirmation of fact does not pertain to the thing. It pertains to the buyer, okay? Now, on the other hand, okay, sa implied warranty, there are different kinds, okay? Let's consider this first. This is the only question before the MCQs, okay? Which is somehow related to express warranties, okay? In December 85, Salvador and the Star Semiconductor Company, San Sebastian College, on the thing, executed a deed of conditional sale wherein the former agreed to sell his 2,000 square meter lot in Cainta, Rizal to the latter for the price of 1 million, payable 100,000 down, and the balance 60 days after the squatters in the property have been removed. If the squatters are not removed within 6 months, the 100,000 down payment shall be returned by the vendor to the vendee. Salvador filed ejectment suits against the squatters, but in spite of the decision in his favor, the squatters still would not leave. In August 86, Salvador offered to return the 100,000 down payment to the vendee on the ground that he is unable to remove the squatters on the property. SSC refused to accept the money and demanded that Salvador execute a deed of absolute sale of the property in its favor, at which time it will pay the balance of the price. Incidentally, the value of the land had doubled by that time. So, Salvador consigned the 100,000 in court and filed an action for rescission of the deed of conditional sale plus damages. Will the action prosper? Okay? Again, if the question is, will the action prosper? Okay? The first thing that should be in your mind, tingin ko lang, is who is the injured party? Okay? Because remedies are only granted to the injured, to the aggrieved. Just because he is the plaintiff does not make him the injured. Minsan, paunahan lang ito. Okay? To make it appear na siya ang api, siyang naunang nag-file ng kaso. But he may not be the injured. If you will answer this question on the basis of remedies, the answer would have been, the answer is no. Okay? It will not prosper because the plaintiff here, the one who filed the action for rescission, is not the injured party. He was the one who failed to perform his obligation to remove the squatter. So why should this person have a remedy under the law? Okay? Although it may be argued that as agreed upon, if the squatters are not removed within 6 months, the 100 down shall be returned. Yun naman ang ginawa niya. Therefore, is it not his right to return, and therefore the buyer should accept the 100,000? I also don't think so. Okay? This stipulation is clearly intended as a protection to the buyer. Okay? That if the seller would not be able to remove the squatters, okay, then the buyer may refuse to continue with the sale. Okay? And therefore, the seller can be compelled to return the down payment of 100,000. Okay? Kaya, on that basis alone, the action will not prosper. But there is another way of answering this question. Do not panic. Okay? There are instances when a question can be answered in 2 ways or 3 ways. Okay? Magkakaibang approach, but any one of them would be a good answer. Okay? Even last year, no, 2011, okay, in relation to redemption, okay, yung heirs who inherited, okay, which I will be discussing, you can answer the question by attacking it under the law on succession. There is an express provision on succession, but you can also answer correctly the same question in relation to law on sales, okay, when we discuss redemption as the last part dito sa law on sales. Okay? Now, does will the action prosper? No, but there is another way. Okay? Under 1545, yes, because the contract was not perfected as the condition was not fulfilled. Tama ba yan? Or yes, because it was stipulated that if the squatters are not removed within 6 months, the 100,000 down shall be returned. Or no, because there was a substantial breach, and no, because the buyer may waive performance of the condition. There was, because the contract was not perfect, as the condition was not fulfilled, this is really wrong. Okay? The contract had already been perfected. The condition which was not fulfilled pertains to the performance of the obligation, not to the perfection of the contract. Okay? It pertains to the payment of the balance. Okay? Kaya hindi totoo ito. Okay? This one, as I told you, the reason is this is intended to protect the buyer. Okay? there was no substantial breach. Of course, it can be a substantial breach. In fact, it can even be argued that he would not have bought that land if the squatters were not removed, okay, as agreed upon. The answer is letter D, because under 1545, if the performance of an obligation, okay, is subject to a condition, and the condition did not happen, like due to the fault of the seller, yung buyer has three options. Una, he may cancel the sale, he may not proceed with the sale because the condition did not happen. Ba't ko bibilhin? May mga squatters pa, di ba? But another option is, he may waive the happening of the condition and proceed with the sale, which was the option taken by the buyer. Even if the squatters are still there, I will proceed with the sale. Just execute the deed of sale, I will pay the balance. Ang third option niya dito is to treat the non-happening of the condition as a breach of warranty, which can be the basis of a liability for damages. Pero as I told you, ang pangalawang option ang kinuha ng buyer. Okay? Waive the happening of the condition and proceed with the sale under 1545. Okay? But, I'll start with this claim of, or question muna. Okay? Has Philippine law adopted this common law principle known as caveat emptor? Okay? De Leon would take the position that as a rule, the answer is no. Okay? And I fully agree with that because caveat emptor, literally in English, is buyer beware or let the buyer beware. In this country, it is not really a buyer beware country because if the buyer is deprived of the thing or if the thing bought turned out to have hidden defects, the seller can be held liable. Kumbaga sa Tagalog, hindi ito bahala ka sa buhay mo, okay? Kung bumili ka, okay? So may mga remedies because of the implied warranties. If only because of that, De Leon, I think is correct that Philippine law has not adopted this common law principle known as caveat emptor as a rule, but there are exceptions, okay? The exception specifically would pertain to the implied warranty against hidden defects, okay? Because under certain contracts, in certain contracts of sale, there may not be an implied warranty against hidden defects. Although, this is a common statement that in sale of animals in fairs, there are no implied warranties. Mali yan. That is not an accurate statement of the law. Ang sabi ng batas, in sale of animals in fairs, there is no implied warranty against hidden defects. In other words, mayroon pa ring warranty against eviction, which is sometimes called warranty of title. Okay? So, aside from sale of animals in fairs, in markets, any other contract of sale where there would be no implied warranty against hidden defects, sinabihan na natin ang sale of second-hand items. Okay? But there is this kind of sale where there will also be no warranty against hidden defects. Ang tawag ng sale ay as is, where is sale. Okay? In my experience, I actually saw, okay, sa Gateway, sa Sony outlet. Kung nakapunta na kayo doon, nakita nyo ang Sony outlet, I think in the 3rd floor, okay? I saw 2 identical TV sets, okay? Yung Sony Bravia, okay? Kung ano ang model, exactly the same. Mga EXW, whatever, okay? And the size, exactly the same. Baka 49 inches bawat isa, okay? But, ang difference ay, in one TV set, ang nakasulat ay mga 65,000. On the other hand, doon sa kabila, abang nakasulat lang mga 25,000. Pero under the price na 25,000 is the phrase, quote-unquote, as is, where is. Okay? In other words, if the buyer is not aware kung ano ang ibig sabihin ng as is, where is, and he bought the TV set kasi mura, 25,000, At pagdating niya sa bahay, after 2 hours, wala nang picture, that's it. As is, where is. In other words, there will be no implied warranty against hidden defects because in that kind of sale, the buyer would have to buy the thing as it is found and where it is found. As is, where is. Sa Tagalog, may pagka, bahala ka sa buhay mo. Okay? Kung bibilhin mo yan, after 2 hours, wala na. Okay? Wala na picture, wala nang sounds. Walang implied warranty against hidden defects. Okay? Now, but, as a few, hindi lang isa or dalawa, a few authors will claim there are no implied warranties in judicial sales. Okay? With all due respect to these authors, they are really wrong. Okay? I can imagine, however, the source of this confusion. Okay? Una, I think this is 1546, okay? Which would tell us the kinds of implied warranty. Sa last paragraph, there is this provision to the effect that itong mga pledgors, mortgagors, auctioneers, and including sheriffs, okay, cannot be held liable for breach of warranty, di ba? And in judicial sales, who would normally be the seller? Sheriff. So if the sheriff cannot be held liable, okay, for breach of warranty, ang conclusion ng ibang authors ay there are no implied warranties in judicial sales. In logic, ang flaw ng argument dyan is known as non sequitur. Just because the sheriff cannot be held liable doesn't mean that no one can be held liable. By express provision of the law, and this is 1552, okay? If the buyer in a judicial sale, like in an execution sale, is deprived of the thing, who may be held liable? Sabi ng batas, the judgment debtor, okay? Although, he may not be held, the court may exempt him from this obligation, which I cannot imagine why, okay? And I don't think there is any case where the court exempted this judgment debtor from that obligation, okay? But the other one is, the buyer, however, the judgment debtor, however, cannot be held liable for damages. Ayaw nga niya ipabenta ang kanyang property, galit pa nga siya sa sheriff o sa nag-levy doon sa property niya. So how can he be considered to be in bad faith? Okay? Now, the other possible source ng confusion in relation this time to warranty against hidden defects is because of this scenario. When the sheriff would levy upon the properties of the judgment debtor, he would normally go to the house or to the office of the judgment debtor, and there he would normally levy upon used items, di ba? Mga gamit na ng mga appliances, mga computer na mga Pentium 1, Pentium 2, di ba? Na mga computers. Thus, would there still be an implied warranty against hidden defects? The answer is, wala na, used items. But, is it not possible for the sheriff to be able to levy upon properties of the judgment debtor which are brand new? The answer is it is very much possible. Like if the seller is in the business of selling brand new appliances. Pag pumunta ang sheriff doon sa showroom, mga brand new ang mga yon. Kaya under 1570, by express provision of the law, the provisions covered by implied warranty against hidden defects are made applicable to judicial sales. Ang medyo, yun lang, ang common weakness na nagbabasa ng mga provision ng batas. If a provision would cite another provision, the reader would not normally read that provision cited. Kaya hindi niya alam what the provision is talking about. In other words, as a matter of custom na lang sa inyo, okay? Pag ang isang article would cite another article, by all means, read that other article so that you will have a full picture of what the law is trying to tell us. Okay? Now, Then, in that provision, okay, I told you the law would tell us the kinds of implied warranties, although the authors again are not in agreement as to whether there are only two kinds or three kinds. Okay? Yung two kinds, against eviction and against hidden defects. Yung three kinds, there will be a third, warranty of quality. Okay? In fact, ang bar exam question 2011 is this one. A warranty inherent in a contract of sale, whether or not mentioned in it, is known as the warranty on quality, warranty against hidden defects, warranty against eviction, and warranty in merchantability. Ano ang sagot dyan? Tatingin ko, ang tamang sagot dyan ay lahat sila. Okay? Tamang sagot. Pero din Pineda would tell us that it is known as a warranty against eviction. But yung warranty against hidden defects is it not a warranty inherent in a contract of sale? Yung warranty on quality, is it not also a warranty inherent? They are. Yung merchantability is a kind of warranty on quality. Okay? Kaya lahat sila implied warranties. If there is, in a way, the worst question of 2011, ito yun. Okay? But I can imagine paano nangyari yan. Okay? As a professor of law, just like Justice Dean Pineda, in my MCQs, I sometimes would have a fifth option, yung none of the above, o kaya all of the above. Kaya lang during his time, 2011, bawal ang mga none of the above or all of the above. Diba? Yun ang requirement ni Justice Abad. So, siguro, ginawa ni Dean Pineda, tinanggal niya ang fifth option, pero he was not able to adjust the four options. So, ang labas ito. Ang tamang sagot, all of the above. Okay? Nonetheless, this will tell you na lahat sila ay implied warranties. I will fully agree to this classification of implied warranties into three instead of only two. Kasi yung warranty as to quality cannot be subsumed or covered by warranty against hidden defects, which is the premise of those claiming that dalawa lang ang implied warranties. Why? For example, into this warranty of quality, okay, one of them, aside from merchantability, is that the thing is fit for the particular purpose of the buyer. Yung thing na yan, may hidden defects ba? Wala. But if it is not fit for the particular purpose of the buyer, then there will be a breach of warranty. Thus, to a million other buyers, walang problema. Kasi wala itong defects eh. Pero as to the purpose of one of the buyers, this thing is not fit for his purpose. Okay? Kaya, I would consider, yes, a third kind of implied warranty known as warranty on quality or warranty of quality. Okay? Now, into the implied warranties, warranty against eviction. First, in most articles, ang pangalan ng warranty is warranty against eviction. Okay? But if you remember one of these articles, the law would call this warranty of title. Okay? Ordinarily, I won't mind kung tawagin ito ng warranty of title. Also, I'm just concerned ng possible mga misconception kung you would use the word or the name warranty of title. Okay? Why? Okay? Because if the seller was able to perform his obligation to transfer ownership, and thereafter, the buyer was deprived of the thing, may there be a breach of warranty of title or warranty against eviction? Parang if you would use the name warranty of title, mukhang wala. Because he was able to transfer ownership to the buyer. Although ang unang tanong dito, how could the buyer be deprived of the thing if he was not deprived of the ownership? Can that happen? Of course it can happen. Okay? It can happen if a third person has the right to the possession or has the right to the use of the thing kaysa doon sa buyer. And who may this person be? A lessee. Okay? So if the contract of lease is binding upon this buyer, sorry na lang ang buyer na ito. He can be deprived of the thing, but he will not be deprived of ownership. Okay? And warranty against eviction would include such warranty that the buyer will be in peaceful possession of the thing. Okay? Now, kung lessee ang may right to the possession, tapos ang contract of lease is for a period of 99 years, which is allowed by law, ang hindi pwede ay more than 99 years. Okay? By the time nag-expire ang lease, buto-buto na lang ang tira sa buyer. Okay? O buhok din, kasi ang buhok hindi yata nasisira basta-basta. Okay? Ilang centuries yata bago masira. Okay? Now, thus, yung implied warranty against eviction would appear to be really a good name. Okay? Now, but in relation to this warranty, there are many requisites. Marami talaga. Okay? Like, there has to be a final judgment. Hindi pwedeng RTC decision lang, o lalo na claim pa lang ng third person, liable na ang seller. Definitely no. Because even if the trial court decided against the seller, okay, the seller can appeal up to the Supreme Court. The buyer is not required to appeal. Okay? Kasi ang pwedeng maging liable ay ang seller. Okay? Now, also, another requirement is the seller must have been given notice as to this claim by a third person. Elementary due process lang yan. Okay? But also because, ordinarily, between the buyer and the seller, who would actually know yung history ng bagay na yan. Okay? Yung title over the thing. It's the seller. Siya ang may kwento niyan. So, if one can defend, siya yun. Okay? But there are others, for example, that the right of the third person who was able to deprive the buyer, okay, by final judgment, must arise after the sale. Okay? Prior to the sale. This is consistent with priority in time, priority in right. Okay? Kaya lang, the law would allow also liability on the part of the seller for breach of warranty, even if the right of the third person arose after the sale but imputable to the vendor. Sa Tagalog, kasalanan ng vendor. At ang classic na example dito ay double sale. Okay? In other words, ang second buyer, the right of the second buyer accrued after the first sale. But nonetheless, kasalanan ng seller. Okay? That the second buyer may have a better right over the first buyer. Kaya the seller can be held liable even if the right of the third person in relation to the first sale arose after the sale. Okay? What else? Okay? What if there is a waiver, okay, executed by the buyer? Okay? Ang waiver, the tenor is, I will not hold the seller liable even if I am deprived of the thing. Okay? If there is such a waiver, may the seller nonetheless be held liable in case the buyer indeed was deprived of the thing, thereafter was deprived of the thing? The answer is, it is possible. Okay? If there is a waiver, okay, these are the possible liabilities if the buyer is deprived. Okay? Lahat, 5. And take note, pwedeng cumulative sila, lahat-lahat. But the seller can only be liable for all these amounts if the seller acted in bad faith. Okay? Pag bad faith ang seller, lahat ito. Okay? In fact, if there is a waiver and the seller acted in bad faith, that waiver is void. And therefore, liable siya for everything. Lahat-lahat. Okay? Ang tanong lang next dito is, when would the seller be considered to be in bad faith? If he was aware of the defect of his title at the time of the sale, does that necessarily make him a seller in bad faith? The answer is no. Okay? Not necessarily. Because he may be aware but he informed the buyer. So why would he be in bad faith? Pangalawa, what if he did not inform the buyer? Therefore, seller in bad faith? Not necessarily again. Because the buyer may already be aware of the defect when he bought. Kaya, he need not be informed. Can that happen? It can happen. Again, pag abogado na kayo ng isang realty firm and your company is planning to buy this particular parcel of land, one of your obligations as a lawyer of that company is to investigate as to the title over the land. And therefore, after having investigated, you may be able to discover that there is a defect in the title of the seller. Okay? And if the seller is informed of this defect, sasabihin normally ng seller, hindi ko alam yan. O diba? Pero more often than not, alam niya yun. Kunyari lang, hindi niya alam. Okay? Pero alam mo na. And therefore, is there a need for the seller to inform the buyer that there is a defect? Wala na. Alam na ng buyer eh. Okay? But, if there is a waiver and the vendor is a vendor in good faith, and thereafter the buyer was deprived of the thing, may the vendor nonetheless be held liable for breach of warranty? The answer is yes. Pwede pa rin. Okay? If the waiver is known as a waiver consciente or a consciente waiver. Pero ang liability niya in a way maliit lang. Definitely walang damages. Ang damages para lang sa bad faith. Okay? Wala from income, fruits, etc. Ang liability lang niya is the value of the thing at the time of eviction. When would the waiver be called consciente waiver? If at the time of the sale and the execution of this waiver, the buyer was not aware of the defect of the title of the seller. But the seller acted in good faith. So, posible, wala sila pareho alam. In that scenario, liable pa rin ang seller, pero that will only be the value of the thing at the time of eviction. Pero, if the waiver is what is known as an intentionada waiver, alam ng buyer ang defect ng title ng seller when he executed the waiver. Why would the seller be liable? Okay? Although ang tanong dito, if the seller's title is defective, in the first place, why would the buyer buy? Pangalawa, hindi lang niya binili. Nag-execute pa siya ng waiver that in case he will be deprived, he will not hold the seller liable. Minsan, parang gusto nating tawagin siyang T-A-N-G-A, di ba? May pagkaganon ang dating niya, okay? Kaya lang, ang mahigpit na pangangailangan, pag mahigpit ang pangangailangan, ganyan ang ginagawa natin, di ba? Nagpapakatanga tayo. Dahil kailangan di ba? If you really need the thing, sometimes, ganun ang gagawin natin. So, yung buyer would buy even if he knew na defective ang title ng seller. But the seller also will not sell unless the buyer would execute a waiver because he knows that he may be held liable, okay? If the buyer is deprived. So he will demand that the buyer execute a waiver. Wala nga magawa ang buyer, hala. He would also execute a waiver. That is a waiver intentionada. If there is no waiver and the buyer was deprived, all the requisites being present, liable palagi. Ang question lang, extent of liability. If the seller was in good faith or in bad faith. Basta bad faith, may liability for damages. Pag wala, walang damages. Into the 4 liabilities lang. Okay? Now, then into this. Implied warranty against hidden defects or any charge or non-apparent encumbrance. Again, seryosohin niyo ang mga pangalan. Kasi sa mga pangalan, you may know the requisites, you may know the nature of the concept. Okay? Let's start with implied warranty against hidden defects. From the very name, the defect must be hidden. If the defect is obvious to the naked eye, there can never be a breach of warranty, okay, against hidden defects. Because the buyer has a right. This right is known as the right of examination or the right of inspection. Kaya, he will be deemed to have waived kung hindi niya nakita ang hidden defects na ito. Okay? Now, however, if the seller was not aware of this defect, there is this siguro confusion. Pag hidden ba, does it mean that the seller was not aware kasi hidden? Aba, pwedeng alam niya. Hidden nga lang, pero alam niya. Parang itinago natin, pero alam natin kung nasaan, pero hidden. So it doesn't mean na pag hidden, hindi alam. Pero pag alam na hidden in bad faith, mas malaki ang liability. That's the difference. Okay? Now, if the seller was not aware of this hidden defect, still liable siya? Yes. But mas maliit ang liability kaysa hidden and he was aware and he did not inform the buyer. Okay? Now, on the other hand, if there is such a hidden defect, is it possible that the buyer cannot hold the seller liable? This time, the answer still is yes, if the buyer is an expert of such thing. Kasi ang batas, mataas ang pagtiin sa mga expert. In other words, expert ka sa bagay na ito, hindi mo nakita ang hidden defect, sorry ka na lang, di ba? You should have discovered the defect because you are an expert, okay? Now, ito muna, any change or non-apparent encumbrance not declared nor known to the buyer, that should be nor known to the buyer, okay? A good example here is a right-of-way, okay? If in a sale of a parcel of land, mayroon palang right-of-way in favor of this person who is the owner of an inferior land, okay? Because there is such right-of-way in favor of this third person, therefore the seller is automatically liable. The answer is no, okay? Una, that encumbrance must be non-apparent, okay? Kaya lang, ang right-of-way, pwede bang non-apparent, okay? Idaanan ito di ba? But the answer is readily yes. Sa mga rural areas, ang mga right-of-way ay hindi concrete, okay? At ginagamit lang ang right-of-way ordinarily during harvest season, okay? So, if it will be used only every 3 months, after the harvest season na 5 araw, in 5-10 days, pogon uli lahat yan. So, it will be non-apparent, okay? Therefore, the seller may be held liable, okay? Non-apparent, kasi kung apparent, why should the seller be liable? Dapat alam mo yun if you are the buyer, di ba? Now, but, if it is non-apparent, does it mean na liable ka agad ang seller? Hindi pa rin. Malay mo, it was declared. O kaya, if not declared by the seller, it was known to the buyer, okay? Malay natin, the buyer is just the owner of the neighboring land. Okay? So, alam niya ang right-of-way na yan. Okay? Therefore, you cannot hold the seller liable. But ultimately, even if the encumbrance is non-apparent, kasi puro kobon, puro grass, tapos, not declared, not known to the buyer, is the seller automatically liable? Hindi pa rin. Because that encumbrance may have been annotated at the back of the title of the property. In other words, kasalanan na ng buyer yon if he did not demand for such owner's copy kung saan nakasulat ang encumbrance na yon. Yung ibang mga tao, medyo, ano ba ang term na maganda? Mga tuso, okay? Or talagang mahilig lang manggaya, okay? Ang gagawin nila, pwedeng isi-xerox lang nila ang owner's copy. Kaya lang, yung front lang ang isi-xerox, yung likod wala. So, walang annotations, okay? But also, pwede rin nila ipasirox ang likod at that time na wala pang encumbrance, di ba? So, pag-present to the buyer na xerox lang, oo nga, walang encumbrance na nakasulat. That was because pinasirox na wala pang annotation, okay? Pero as the one interested in the land, you should have demanded for the original, yung owner's copy, okay? Therefore, you cannot hold the seller liable. But, last, what if indeed the seller is liable, okay? Mukhang there was a violation of this implied warranty in relation to a non-apparent encumbrance, like a right-of-way. But the sale was entered into last year, January 1, para madali lang ang computation. So, 2012, January 1, if an action is filed by the buyer for breach of warranty, will the action prosper? This time, the answer is, it depends, okay? Because this is a clear example of, it depends on, una, what was the action, nature of the action. Pagtanong palagi, will the action, unahin mong isipin, unang tanong, is he the injured party? Pero ang pangalawang tanong ay, what's the nature of the action? Is it an action for specific performance, etc., rescission? This time, if the action filed, like tomorrow, kasi Sunday ngayon, okay? Tomorrow, an action was filed by the buyer for breach of warranty. If the action is an action for rescission, it will not prosper. Because the law requires such action to be filed within 1 year from the date of the contract. Okay? But if the action is merely an action for damages, and it is filed tomorrow, the action may prosper. It is not it will prosper, but it may prosper if that action was filed within 1 year from the date of the discovery of the encumbrance. Like, kung ang sale na January 1 last year, na-discover ng buyer encumbrance yung right of way about February pa lang, today or tomorrow, will the action for damages prosper? Never. Okay? Because it is already more than 1 year from the discovery. Pero kung na-discover ng buyer encumbrance, Agosto na, dahil galing pa siya sa London, so hindi pa niya nakita talaga yung right of way na yan, by today or by tomorrow, July 1 pa lang bukas, pwede pa. It is still within 1 year from the discovery of the encumbrance. Okay? But, next question is, what if the thing bought had hidden defects and thereafter it was lost or destroyed? May the seller still be held liable? Better yet, what if the loss was due to the fault of the buyer? Kasalanan ng buyer kung bakit nasira o nawala. May the seller nonetheless be held liable? Believe it or not, the answer is yes. Okay? Even if the loss was due to the fault of the buyer himself, even if the loss was due to a fortuitous event, the seller may still be held liable. This is one of the laws which would provide for liability even if the loss was due to a fortuitous event. Diba? One of the exceptions is because the law so provides. And this is one law. Okay? Ito muna. Maganda itong bar exam question na ito. Knowing that the car had a hidden crack in the engine, X sold it to Y without informing the latter about it. Okay? In any event, the deed of sale expressly stipulated that X was not liable for hidden defects. Okay? Thus, Y have the right to demand from X a reimbursement of what he spent to repair the engine plus damages. Okay? Again, knowing, alam niya na may hidden crack. Okay? But without informing. Pero, stipulated that X was not liable for hidden defects. Okay? The options. Yes, X is liable whether or not he was aware of the hidden defect. Parang totoo yan, di ba? As mentioned earlier, it doesn't matter whether the seller was aware. Okay? But letter B, yes, since the defect was not hidden, X knew of it, but he acted in bad faith in not disclosing the fact to Y. Letter C, no, because Y is in Stoppel, having changed engine without prior demand. And letter D, no, because Y waived the warranty against hidden defects. Yung letter C is really the worst answer. Okay? Dahil nag-change siya ng engine without prior demand, in-stoppel na siya, the law so provides for liability. Okay? Ang defect ng letter A, X is liable whether or not he was aware of the hidden defect, is because this option did not consider the fact that there was a waiver. Okay? So if there is a waiver, would that not change the effect of the loss or the hidden defects, the fact that there was a hidden defect? Sabi ni Dean Pineda, ang correct answer is letter B. Okay? Since the defect was not hidden, X knew of it, but he acted in bad faith in not disclosing. In other words, what is wrong with letter B? It's because Y waived the warranty against hidden defects, but this waiver is a void waiver, diba? Because he knew of this defect, but he did not inform. So when the buyer executed the waiver, the seller was in bad faith and the buyer was not aware. Okay? Thus, it is a void waiver. I agree with this fully, that this is the best answer, but something is wrong with the option. Okay? Mali lang, nagkamali lang. Okay? Since the defect was not hidden, X knew of it, but he acted in bad faith in not disclosing. Ang mali dyan, the word not. Okay? Yes, since the defect was hidden. Okay? In fact, napakalinaw sa facts, hidden crack. So mukhang hidden ang defect. Okay? So, again, sometimes may typographical errors lang. Okay? So, you have to consider the context na lang. Okay? Kung mali sa fax, mukhang hindi yun ang ini-intend niya. Again, do not confuse yung hidden from not known. Okay? It may be hidden but known. In the problem, alam ng seller. Okay? Known pero hidden. Okay? Hidden, hindi obvious to the naked eye. Okay? Now, as mentioned earlier, ito. Okay? What will be the extent of liability of the seller in case of loss of the thing with hidden defects? Ang premise dito, the thing lost had hidden defects. Okay? The answer will depend on the cause of the loss. Okay? Take note, these are the possible liabilities. Pero if you will read the nature of these amounts, okay, the damages, okay, they cannot be awarded at the same time, lahat-lahat. Hindi cumulative. Okay? Because yung dalawa cannot be awarded at the same time. It's either return the price or price less the value at the time of the loss. Also, damages cannot be awarded together with interest in this scenario. Okay? But if the cause of the loss is the defect itself, mas malaki ang liability kaysa if the loss was due to a fortuitous event or fault of the buyer. Okay? Take note, bakit mas malaki? Because the liability is return the price. So that's kung 100,000, return the entire 100,000. Pero kung cause of the loss is kasalanan ng vendee or fortuitous event, ang liability lang ng seller ay price less the value. Which means, kung ang value at the time of the loss is 70,000, 100 minus 70, ang liability lang ng seller ay 30,000 lang. Di ba? Because the cause of the loss is fortuitous event or fault of the vendee. Pero, maski defect yan or fortuitous event, mas malaki ang liability if the vendor was in bad faith. Because palagi siyang liable for damages. Pero if not aware, ay at best, worst is interest lang ang liability niya. Walang liability for damages. Okay? Basta ang damages para lang sa bad faith yan. Okay? Now, in relation to sale of animals, okay? Kung sa things, hidden defects, sa animals ang tawag redhibitory defect. Okay? May pagka-hidden defect ito by definition because a redhibitory defect is one which cannot be discovered despite a professional examination or examination by a professional. So, limbawa, veterinarian na nag-examine, hindi niya makikita. That would be a redhibitory defect. In other words, okay, if a dog was bought, pero ang dog na ito had lumps, okay, in Tagalog, may mga bukol-bukol ang aso. Do you think that would be a redhibitory defect? Hindi siguro. Ay maski bulag ka, kapkapin mo lang ang aso, makikita mo ang mga bukol, di ba? And therefore, that is obvious, okay? That is not a redhibitory defect. Now, a problem here may arise in a scenario where the buyer bought 7 dogs, 7 aso, okay? But only one of the dogs turned out to have a redhibitory defect. If he files an action for rescission as to the entire contract involving all the 7 animals, will the action prosper? Ordinarily, it will not. Because the action for rescission or for redhibition will only prosper as to the animal with a redhibitory defect. Kung isa lang ito, din hanggang doon lang. But there is again an exception. If the buyer can prove that he would not have bought the others had he known of the defect of one. Okay? Now, but does the buyer always have the burden of proving such? Na hindi ko dapat binili yung iba kung alam ko lang, di ba? The answer is no. Under certain circumstances, the law would presume that the buyer would not have bought the others, okay? If he bought the animals as a team, he bought the animals as pairs, in pairs, okay? In yoke, okay? In other words, ang dogs nga lang in this country are not normally bought as a team. Okay? Ewan ko lang sa Pilipinas kung anong gagamitan mo sa dogs as a team. Unlike in the Arctic places sa mundong ito, okay, where the dogs are used as sled dogs. Although in recent years or decades, years at least, parang hindi na rin uso ang dog dahil cruelty to animals na yata ang treatment. Ang ginagamit na nila mga motorized na ng mga sled, di ba? But at any rate, mukhang meron pang ganun gumagamit dogs. Siguro effective pa rin ang dogs, okay? Kaya these dogs, when bought as sled dogs, they are bought as a team, okay? Kasi they have to work as a team. Hindi pwede ang dogs kanya-kanya ng direksyon, okay? Mukhang as a team, these dogs would actually have a leader, okay? And in fact, dahil katatapos lang ng eleksyon, I dare to say, mas magaling pang pumili ng leaders ang mga aso kaysa mga tao, okay? Kasi sa mga aso, hindi kailangan ng pera para maging leader ng kanilang pack, okay? Dito sa ating eleksyon, nako, kung mayroong 1,000 mga nanalo, baka wala pang isa na nanalo na hindi gumastos ng pera o hindi bumili ng botante, okay? Lalo na sa gastos, okay? Ganoon talaga, halimbawa, tingnan mo, 100 million plus ang gastos. Para ang mga nananalo, sila ang pinakamatataas ang gastos, probably except for one, okay? Alam niyo na kung sino. Isa sa pinakamataas na gastos, pero natalo, okay? Hindi naman guarantee yun. Pag mapera ka, panalo ka. Pero pag wala kang pera, talo ka. Yun ang parang guarantee. Pero sa mga dogs, meron silang ala criteria, okay, in choosing their leaders na hindi kailangan ng pera. You should watch this movie, okay, yung 8 Below, okay, how they would choose their leader, okay, just 1 minute, okay. In this movie, the dogs were left in that part of this earth, okay, na puro ice, because the owner had to go back to the city, okay. Pero they were left without food, okay? So they had to really look for food, they had to leave their place, and one of them was injured. The leader of the pack was injured, okay? So the other dogs, yung 6, the rest of the dogs, yung 6, they would have the food by catching birds, okay? Yung low-flying birds, yun ang kailang kinakain nila, okay? And almost all the 6 would do that. Hala, catch, kain, except this one dog. Imbis na kainin niya ang kanyang kinakatch, he would give the bird to the injured dog. Yun ang kanyang binibigay. Okay? Siguro napansin ng iba nahiya. Okay? Nahiya ang ibang dogs. Siya ang piniling panibagong leader ng pack. Okay? So, walang pera-pera, okay, ang pag-choose ng leader sa kanila. Diba? Based on values, based on skill, etc. Okay? But even among dogs, may ano yan, may maano ang kanilang pagpili ng leader, okay? But lalo na kung lovebirds ang binili, diba? Pag lovebirds, do you think you would buy the other bird if one of the 2 birds is defective, has a regulatory defect? Because if one of them dies, the other one will kill itself. Hindi lang will die, will kill itself. Okay? Nagkaharakiri, nagsuicide ang isang bird. Okay? Ang ginagawa niya, binabang niya ang ulo niya sa wall, okay? Sa cage. Kaya, bali-bali ang mga necks, okay? Ng mga birds na ito. Before, for years, ang akala ko lang dito, why they would do that is because of love, di ba? Dahil parang mahal na mahal niya ang ano ito, partner. But it's not because really of the concept of love. It's because of the nature of these birds that they are essentially monogamous. Hindi katulad ng mga tao, di ba? Essentially monogamous, meaning they cannot live with any other partner in their entire life. Kaya parang wala nang silbi ang buhay, di ba? Kaya naghaharakiri na lang sila, patay, di ba? So, it's but natural for the law to raise a presumption that the buyer would not have bought the other bird had he known of the defect of one of the two birds. Okay? But last, this MCQ, S sold to B a dog on January 10, 2002. 2 days after delivery, the dog suffered some illness which caused its death. B is now suing S for breach of warranty against seed and defect because the dog died within 3 days after delivery. Decide. S is liable because the disease existed within 3 days after the purchase. Or S is not liable if he was not aware of the disease which caused the death of the dog. Or S is liable if you were in bad faith. Or S is not liable because the disease did not exist at the time of the purchase. These two, B and C, are really wrong. Okay? Is not liable if he was not aware. Hindi naman. Liable pa rin siya, but his liability is less kaysa naman if he was aware and he did not inform the buyer. Yung letter C lalo na. Ang implication ng letter C, that if he acted in good faith, he will not be liable. Liable pa rin siya. Implied warranty ito eh. Again, mas maliit lang ang liability pag he acted in good faith. Ang letter A is liable because it existed. Mali. It's not about existed within 3 days. It should already exist on the date of the purchase. And the animal died within 3 days. Okay? Under the facts, the answer is letter S, not liable because the disease did not exist at the time of the purchase. If you read the facts carefully, 2 days after the delivery, the dog suffered some illness. So at the time of the sale, wala pang illness. It was only 2 days thereafter that the dog suffered an illness and thereafter died within 3 days, which is required by law. Although ang tanong dyan ay, possible ba yan that within 24 hours, the dog would die from the time it acquired the illness, the disease? The answer is actually yes. Okay? I've asked several persons here, okay, mga mahilig sa mga pets, okay, if not veterinarians, okay, that some virus involving dogs very much lethal in 24 hours, patay ang dog, okay? Kaya the answer is letter S, not liable because the disease did not exist at the time of the purchase, okay? So, we can proceed, mabilis lang ito, the rights and obligations of the vendee, okay? Basically, okay? Into the price, okay? The most known obligation of the vendee is the obligation to pay the price. We have already discussed as to where the price is to be paid. It's by stipulation. Kung wala, place of delivery. Doon ang bayaran, okay? But a good question may pertain to a scenario where the seller delivered the thing much earlier than the payment. Okay? Pwedeng the seller delivered 2 years ago, pero nagbayad lang ang buyer today. Okay? Is the seller entitled to interest? In other words, can the buyer be compelled to pay interest because he only paid today? Diniliver sa kanya 2 years ago. The answer in general is no. The seller is not entitled to interest. The buyer cannot be compelled to pay interest. This is in a way similar to loans, di ba? But there are 3 instances when the buyer can be compelled to pay interest. Okay? The first, as in a way, parang loan if it was stipulated. Okay? Kaya naman siguro the seller agreed for the payment to be made today is because there is such a stipulation that the buyer will pay interest. But even without such stipulation, the buyer can be compelled to pay if the thing delivered or the thing which is the subject matter of the sale is a fruit-bearing thing. This is reasonable. Because for example, ang object of the sale is a rice field. In 2 years, nakailang harvest na ang buyer? Mukhang naka-4 na. Diba? And therefore, the law is wise in holding the buyer liable for interest. Okay? But the third one, even if there's no stipulation, even if the thing is not a fruit-bearing thing, if the buyer is already in delay after judicial or extrajudicial demand. This is just consistent with the concept of delay. In an obligation to pay a sum of money, if the debtor is already in delay, he will be liable for damages. And the liability for damages in monetary obligations is by way of interest. Okay? Kaya he can be held liable for interest because he's already in delay. Okay? Now, this one. Okay? If the seller, through his employees or workers, okay, had the goods delivered to the place of business of the buyer, okay? And sometimes, these workers or employees of the seller would immediately leave the premises of the buyer, di ba? Siguro, nagmamadali sila, may iba pa silang pupuntahan. But 1 hour after the delivery, okay, the buyer called the seller, okay, to inform him that he is rejecting the goods, okay? When the buyer received the goods, does it mean that he already accepted the goods? The answer is no. Okay, not necessarily. The general rule here is the buyer has the right of inspection. So, he would receive preliminary to acceptance. Dahil i-inspect pa niya, i-examine niya, and then he may accept. Okay? Of course, as I said, as a rule, because this is subject to stipulation, pwede namang the buyer will waive his right of examination or right of inspection. And the law would even tell us, in a COD arrangement, walang right of examination, walang right of inspection. Okay? Now, so, if this buyer informed the seller to get these goods from his place because he is rejecting the goods, but before the seller could obtain the goods from the buyer's place, all the goods were destroyed due to a fortuitous event. Can the buyer be compelled to pay the price? In other words, again, ang tanong dyan, who bears the loss? Okay? The answer is, it will depend on the reason why the buyer rejected these goods. Because under the law, if the buyer has no just cause in rejecting the goods, by law, ownership is deemed to pass to him. And thus, if he is already the owner at the time of the loss, under res perit domino rule, he will have to bear the loss. And thus, the law says he can be compelled to pay the price. Pero naman, if he has a just cause in refusing to accept, dahil kulang-kulang ang goods, dahil inferior ang quality, dahil sira-sira ang goods, then the law expressly would tell us that he cannot be compelled to pay the price. Okay? Now, dalawa na lang. Okay? Una, as to the fruits. I promise to discuss this with you. Okay? Ito ang isang bar examination question, which is a good question. Okay? By means of a public instrument, Mr. Nagbibili sold his mango plantation to a bentorero effective immediately. Okay? But there is something wrong with this. Okay? The parties may have agreed that the delivery will be effected 6 months from the execution of the deed of sale. Okay? Now, when the said period arrived, a bentorero demanded delivery in writing, but nagbibili-bili-dalid. Okay? In Tagalog, nagpatumpik-tumpik. Okay? It was not until a month afterwards that Nagbibili finally gave the land to a bentorero. In the 3 weeks before the delivery, Nagbibili sold and delivered the entire produce of the mango plantation to Mr. Comerciante for 200,000 pesos. Comerciante knew nothing of the contract between Nagbibili and a bentorero. A bentorero now seeks to recover from Comerciante either the full value of the mangoes or a similar amount and quality of the mangoes. Does a bentorero have this right against Comerciante? Take note, the question is not against Nagbibili. This is against Comerciante, the buyer of the fruits. Okay? In order for the seller, the buyer of the plantation, to be entitled to the fruits, he must already be entitled to the thing. Di ba? Now, in other words, during the 6-month period, okay, who is entitled to the fruits? If you will read the second paragraph, or others would say the second sentence of 1537, it will be the buyer who will be entitled to the fruits dahil nakalagay, that the buyer shall be entitled to the fruits of the thing from the time of the perfection of the sale. But then again, do not read this provision literally. Okay? You have to read this provision in relation to 1164. Okay? And in 1164, the law provides that the creditor shall be entitled to the fruits only from the time the obligation to deliver arises. Okay? To be more precise, this is from the time the obligation becomes due and demandable. In the problem, clearly the seller is entitled to the fruits for the 6-month period. In the first place, why would he want such stipulation na i-deliver lang niya after 6 months? Kasi gusto niya ang fruit sa kanya within the 6-month period. Okay? But after that, who is entitled to the fruits? During the 1-month period before the delivery, it is already the buyer who is entitled to the fruits. Either under 1537 or under 1164, the buyer is already entitled to the fruits. Pero, because he is entitled, does it mean that he has a right against komersyante? The answer is no. Because under 1164 last paragraph, the buyer will only have a real right over the thing from the time such thing was delivered to him. Especially under the facts of the case, the buyer of the fruits is a buyer in good faith. He was not aware of the agreement between nagbibili and abentorero, kaya abentorero doesn't have a right of action against komersyante. Ang kanyang right of action is against the seller of the plantation. Okay? Because upon the expiration of the 6-month period, ang buyer entitled na sa fruits. Okay? Kaya lang, seller ang pwede niyang habulin, hindi si komersyante. Okay? Now, kaya, no, because he has no real rights over the thing until the same has been delivered to him and the buyer was in good faith. Okay? Kaya ang last dito ay masedalo, pero uwi na tayo. Okay? I think ang next my schedule is in Thursday, 5 o'clock in the afternoon. Okay? So we'll just have masedalo and then remedies and redemption. Definitely we can finish this in less than 2 hours. Okay? So we will proceed already